objection ಇದೆ. ಬರ್ಬೇಕು ದಿನ ಬಂದ್ಮೇಲೆ ಕೊಡೋದು. ನಾಳೆ ಒಂದಿನ ಬುಕ್ಕಲ್ಲಿ ಎಂಟ್ರಿ ಇಲ್ಲ. ಏನ್ ಮಾಡ್ತಿದ್ದೆ? ಬುಕ್ಕಲ್ಲಿ ಎಂಟ್ರಿ ಇಲ್ಲದೆ ಯಾವ್ದು ಕಳ್ಸೋದೇ ಇಲ್ಲ. ಸುಮ್ಮನೆ ಹೇಳ್ಬಿಡಿ. ಕೊಡಿ ಕಳಿಸ್ತೀನಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಅದ್ ಹೆಂಗ್ ಬುಕ್ಕಲ್ಲಿ ಯಾವ್ದು ಎಂಟ್ರಿ ಮಾಡದೆ ಕಳ್ಸೋದೇ ಇಲ್ಲ. ನೀವು ಇವತ್ತು 18th ಅಲ್ವಾ, ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲಿದೆ ಅದು? ಎಷ್ಟು
ಮೇಡಮ್
ಏನಣ್ಣ ಅನ್ಕೊಂಡೆ ನಾನು ಮೊನ್ನೆ ಪಾಸ್ವರ್ಡ್ ಹೇಳಿದ್ದೆ ಕೊಟ್ರ ಅಂತ ಹೇಳ್ತೀನಿ. ಅವತ್ತಕ್ಕೆ ಮಾಡಿದ್ದೀರಲ್ವಾ? ಫೋನ್ ಮಾಡಿದ್ದೀನಿ. ಫೋನ್ ಮಾಡಿದ್ನ?
ಮತ್ತೆ ಮೇಲನ್ನು ಕಳಿಸಿದ್ದೀನಿ. ಮೇಲ್ ಕಾಪಿ ಇರೋದಕ್ಕೆ ಏನು
ಎಕ್ಸಸೈಸ್ ಮಾಡ್ಬೇಕಮ್ಮ. ಅದು ಎಕ್ಸಸೈಸ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ
moving memo. Matter is urgent.
What is the urgency?
They have filed an injunction suit and have taken an interim order, whereas in the Honorable High Court has ordered status quo in the matter, but they have the gifted holder has gone ahead and taken an interim order and is trying to dispossess the appellant.
This is excessive bail petition, my lord. I sought for interim bail on the account. The petitioner's husband is no more. To perform, my lord, obsequious and last night ceremony, my lord, I sought for interim bail. My lord, it has to be posted before this honorable court only.
Criminal day ಇವತ್ತು ನೀವು ನೆನ್ನೆ ಮೊನ್ನೆ ಕೊಟ್ಟಿರಿ, ಇವತ್ತು ಹಾಕ್ಸ್ಕೋಬಹುದಿತ್ತು.
Yesterday I filed, my lord, because my lord, a special public prosecutor has been appointed in this case, my lord. I have served the copy also. Like, maybe my lord, humanitarian government, my lord.
Next week iದ್ರೆ ಹಾಕ್ಬೋದಿತ್ತು.
Humanitarian government, my lord, to perform obsequious ceremonies, my lord, it may be taken up tomorrow, my lord. Special circumstances.
ತಗೊಂಡಿರಿ ನೋಡು.
Position ಮಾಡ್ಲಿಕ್ಕೆ city survey CTS
Urgency merits ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. Whether you have enjoyed the interim relief earlier. ತಗೊಳ್ಳಿ ಹಾಕ್ಸ್.
One review petition. The respondent has filed appeal challenging the expert approved injunction order. Subsequently, final order has also been passed.
ಶುರು ಮಾಡಿ, ಕಾಪಿ ಶುರು ಮಾಡಿ, ಅದರ್ ಸೈಡ್ ಕೊಡಿ. Post ಮಾಡಿಸಿ. ಇವತ್ತ?
Notice to the respondent. Or else tomorrow.
Tomorrow.
My lord, in a suit wherein I've sought for formation of a trust, I'd also filed IA under order 39(1) and 2, seeking that I be permitted to enter into a family temple, my lord, which is open to the public. It's a dispute between two brothers. Now my brother is not permitting me to enter my own father's temple, my lord. This challenging that order before the trial court have come, my lord. It's a fresh matter.
Yes, tomorrow.
May I make one mention, madam? Serial number 18, madam.
Page wise 18.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇಲ್ಲ ಇವ್ರು ಮುಗಿಸ್ಲಿ ಅವ್ರ ಮೇಲೆ
ಹೇಳಿ
mention
ಹೇಳಿ
ಇದೆ.
ಹೇಳಿ.
It's a suit for partition. The parties have settled the disputes, madam.
Hmm.
For reporting settlement, if it may be taken up on Friday.
Friday, ಕೊಡಿ ತೊಗೊಳ್ಳಿ ಹಾಕ್ಸ್ರಿ Friday.
Serial number 18, not asking for an adjournment. My only request is this, Maharaj. Your lordships had directed on the last date, the
ಪಾಠ ಏನಾಯ್ತಂಗಿದೆ?
the Chief Commissioner BBMP to be present. He was in Belgaum. He has come down only for this, Maharaj. If your lordships could accommodate us at the earliest, since the officer is present, Maharaj, Chief Commissioner is present. He just wanted to clarify to your lordships that.
At least they would have sought time because they have received the
Correct.
direction by
No,
the
no, no,
court.
no, 100%.
They have sought time.
Absolutely,
They
Maharaj. It's
would
our,
given time also.
no, in fact, what we ought to have said and what I'm requesting.
Received the same
Yes,
and kept quiet.
correct, Maharaj.
If they were unable to perform the duties as directed by this court, would have requested the court.
No, no, absolutely, Maharaj, absolutely. No, no, in fact, first of all, I want to apologize, Maharaj. We should have brought it to your lordship's attention. Secondly, Maharaj, I'm instructed to also submit that the city surveyor, Maharaj, falls under the thing of the revenue department. The BBMP collect baralla. So in fact, of course, it is our duty to bring that to your lordship's attention, and then it's not as if we should sit back. So first of all, Maharaj, I should apologize. But if your lordships could
Property comes within the BBMP. only.
comes within BBMP limits.
Can seek the assistance of revenue department, that's all.
The city survey department belongs to the commissioner survey settlement, sir. They have all the records of the earlier city survey.
You can request them and get it done, that's all.
But sir,
Why you are shirking your responsibility? Property comes within your limit only,
Yes.
BBMP.
Yes, sir. But
Then you seek the assistance of the revenue department, survey department, and get it done and submit the report, that's all.
sir, we will do that, sir. But if your direction goes to commissioner survey settlement,
It will get expedited, Ashtaj, that's all. Our ugly.
I will
Not that we are
also-
shirking, we will also follow up,
also
and
follow up.
additional direction may be issued.
In
Ashtaj.
passing an order,
Yes,
I will direct them also to give an assistance to the BBMP to submit the report. That I can do.
yes.
You get it done through them, that's all.
okay,
So if on direction, that would also help, Maharaj, because
yes.
as your lordships knows that
I will
if there
direct,
is,
while passing an order,
very
I
well.
will direct them.
So since the officer had come, that's why I thought I'll mention, because session in the, idikke bandidru. So you may have to go back. I'm not sure whether he's going back or he'll have to join on VC.
ಈಗಲೇ ಕಳ್ಸಿ ಪರವಾಗಿಲ್ಲ.
Ah,
ಕೆಲ್ಸ,
that's all.
let him see that
Yes.
work should be done.
Yes, Maharaj, we will certainly. My colleague will be here when the matter is called out, Maharaj. So, yes.
They would have requested us.
Oh, of course, it's
to
our
not
mistake. We should have.
Carry out the direction issued by this court
Correct.
in time. Please extend the time. That would have been made
Correct.
difference. That's all.
Some communication gap, Maharaj, it's our mistake. There's no excuse. I'm sorry, Maharaj.
Yes, I will pass appropriate. order.
Grateful.
He need not wait also,
Obliged.
but let him see that work is done.
No, that certainly. Maharaj.
Mentioning from page number 6, 22 to 26, 27 to 31.
Serial number 30. What do you want, madam? You want time? Opponent counsel seeks time, You are for respondent, respondent. And respondent counsel also present, list this matter after immediately winter vacation.
32 to 34.
My lord, serial number 32, I have filed wakalat today, my lord. And NOC wakalat for R2, R3 and R4 today I have filed, my lord.
ಆಯ್ತು, ಅವಾಗ ಬಂದಾಗ ಮೆನ್ಷನ್ ಮಾಡಿ. ಈಗ ಅದರ್ ಸೈಡ್ ಇಲ್ಲ, ಅವರು ಇರ್ಬೇಕಲ್ಲ, ಅವ್ರ ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡೋಣ.
Yes, ma'am.
ನೆಕ್ಸ್ಟ್
35 to 38, 39 to 46, 47 to 51,
Serial number 42 million.
32. ಹೇಳಿ ಏನ್ ತಗೊಳ್ತೀನಿ.
Can it be taken tomorrow? I have to go to the hospital.
ಕೌನ್ಸಿಲ್ ನಾನು ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ ಇವತ್ತು, ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ಏನ ಇದೆ.
ನಾಳೆ
ಹಾ.
ಸ್ವಲ್ಪ
Day after tomorrow.
tomorrow.
The applicant counsel seeks time. List this matter tomorrow. ಬೆಳಗ್ಗೆಲ್ಲ ಕಳಿಸ್ರಿ ಫೈಲ್.
My lord, serial number 51, my lord, I am appearing for
Serial number?
appellate. 51, my lord,
51.
please, my
ಫೈನಲ್
lord,
ಇಯರಿಂಗ್
house for me, last late only final.
ಅದು ರೀಚ್ ಆಗಲ್ಲ, ಆಲ್ಮೋಸ್ಟ್ ಅಡ್ಮಿಷನ್ಸ್ ಸುಮಾರು ಇದೆ.
Please, my lord,
ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ?
please.
ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ?
ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ. ಇಲ್ಲ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ,
ಮಾಡಿಲ್ವಾ?
ಮಾಡ್ತೀನಿ.
ಮಾಡಿದ್ರೆ ಈಗಲೇ ಕೊಡ್ತೀನಿ, ಇಲ್ಲಾಂದ್ರೆ ಮಾಡಿ ಸಬ್ಮಿಷನ್ ಮಧ್ಯಾಹ್ನ ಹೇಳಿ.
Please, my lord, please, my lord.
52 to 57, 58 to 60,
ಯಾವ್ದು
60,
ರೀಚ್ ಆಗಲ್ಲ, ಸುಮ್ನೆ ಏನು ಕರಿತೀರಿ.
61.
ಮಧ್ಯಾಹ್ನದೆಲ್ಲ ಮಧ್ಯಾಹ್ನದ ಇರ್ಬೇಕು ಇದು.
ಅದೇ.
ಅದು ಬೇರೆ ಇದೆ, ಮಧ್ಯಾಹ್ನ ಇನ್ನೆಲ್ಲ RFS ಯಾವ್ದು ರೀಚ್ ಆಗಲ್ಲ. ಫೈನಲ್ ಇಯರಿಂಗ್ ಯಾವ್ದು ರೀಚ್ ಆಗಲ್ಲ. ಫೈನಲ್ ಇಯರಿಂಗ್ ಯಾರು ವೇಟ್ ಮಾಡೋದ್ ಬೇಡ.
Orders matter, Silver 1, SG Hegde.
ಇದರಲ್ಲಿ I filed application.
Furnishing of ಏನ್ರಿ ಇದು 2015 ಇನ್ನೂ
ಇಲ್ಲ, I issued a notice to the, because the parties ಗೆ
ಪೆಂಡಿಂಗ್ ಇದೆ ಇನ್ನು.
ಇಲ್ಲ suit
Appeal,
ಇದು
appeal was
miscellaneous.
preferred. Appeal was preferred. Against appeal, that appeal was dismissed for non-prosecution.
Which appeal?
That regular appeal
ಹಾ
against the suit.
ಹಾ
That appeal was dismissed for non-prosecution. To restore that appeal, my lord, that filed a miscellaneous petition.
ಹಾ against this
That is-
miscellaneous
that is
this
this-
appeal.
Against miscellaneous.
Miscellaneous.
ಹೇಳಿ ಏನಾಯ್ತು?
ಇದರಲ್ಲಿ I filed yesterday only the parties came after issuing the notice.
ಹಾ
ಈಗ applications file ಮಾಡಿದ್ದೀನಿ.
ಹಾ
One memo I am filing that reporting the death of the respond number, appellant number 2, respond number 1B, respond number 2.
ಸರಿ, ಈಗ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಿದೆಯಲ್ಲ ಅದಕ್ಕೆ ಏನ್
ಆ-
ಮಾಡಿದಿರಿ?
ಇವತ್ತೇ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. Remaining applications I filed already.
ಹ್ಮ್ ಹ್ಮ್ ಏನಕ್ಕೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಕೇಳ್ತಿರ್ರಿ?
ಇಲ್ಲ ಪೇಪರ್ ಇಲ್ಲ, ಅದು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಇದೀಗ ಮತ್ತೆ ಡೆತ್ ಆಗಿರೋದ್ರಿಂದ.
ಅದಕ್ಕೂ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ
ಅಲ್ಲ,
ನೋಡಿ.
ಈಗ ಒಟ್ಟಿಗೆ ಎಲ್ರಿಗೂ
ಆಯ್ತು,
ಸೇರಿ
ನೀವು ಹೋಗಿ ಆಫೀಸಲ್ಲಿ ಅದೇನು ಕ್ಲಾರಿಫೈ ಮಾಡಿ ಅವ್ನ್ ಪಾರ್ಟಿ ಆಗ್ದಲೇನೆ ತರದಲೇನೆ ನೀವು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಕೇಳಿದಿರಿ. ಅದಕ್ಕೆ ಅದು ಅಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ. ಈಗ ನಾವು ಯು ಆರ್ ರಿಪೋರ್ಟಿಂಗ್ ಡೆತ್ ಆಫ್ whom?
appellant number 2,
Counsel for the appellant submits that appellant number 2 is also no more and reporting the same.
respond number 1B, respond number 2,
1B and respond number 2,
respond number 4C.
4C and respond number 5 are the ಅವರು ಏನೋ ಡೆಡ್ ಅಂತಿದೆ ಇಲ್ಲಿ.
ಅವ್ರು ಸತ್ತಿದ್ದಾರೆ.
ಹಾ.
ರಿಮೈನಿಂಗ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1A 4B ಸತ್ತಿದ್ದಾರೆ, ಬಟ್ ಆಲ್ರೆಡಿ ರೆಕಾರ್ಡ್.
ಬ್ಯಾಡ್ರಿ, ಕನ್ಫ್ಯೂಷನ್ ಯಾಕೆ ಮಾಡ್ಕೋತೀರಿ? ಈಗ ಸತ್ತೋಗಿರೋದು ಯಾರು?
ಸತ್ತೋಗಿರೋದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ appellant number 2
ಅಪ್ಲೆಂಟ್ ನಂಬರ್ 2 ಎಲ್ಲಾರ್ಸ್ ಇದಾರಾ ಇಲ್ಲ?
ಎಲ್ಲಾರ್ಸ್ ಇದ್ದಾರೆ ಸರ್.
ನೀವು
ಆಲ್ರೆಡಿ
application
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ, ಇವತ್ತು ಹಾಕಿದ್ದೀನಿ,
ಹಾಕಿದಿರಿ?
ಇವತ್ತು ಹಾಕಿದೆ ಸರ್.
ಹಾ.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1B, ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2, ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4C, ರೆಸ್ಪಾಂಡ್
ಅವರು ಎಲ್ಲ ಸತ್ತೋಗಿದ್ದಾರೆ.
ಅವ್ರಿಗೆಲ್ಲ ಇವತ್ತು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ ಇವರು.
ಹೌದಾ? The council submits that appellant number 2 is also no more and also filed application for bringing LRs of appellant number 2, respond number 1B, respond number 2, respond number 4C and respond number 5. And hence the registry is directed to put up the applications.
ಇದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1A 4B ಡೆಡ್, ಲೀಗಲ್ ಏರ್ಸ್ ಆಲ್ರೆಡಿ ಏನ್ ರೆಕಾರ್ಡ್.
ಯಾರು ಅಂತ ಹೇಳ್ಬೇಕು ನೀವು?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1A
1A ಗೆ ಯಾರು ಎಲ್ಲಾರು? ಹ್ಮ್ ನೀವು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳ್ಬಿಟ್ರೆ ನಾವಾಗ ಅವ್ರನ್ನೇ ಟ್ರೀಟ್ ಮಾಡ್ಬಿಡ್ತೀವಿ ಎಲ್ಲಾರ್ಸ್ ಯಾರು ಅಂತ.
ಫೈಲ್
ನೋಡ್ಕೊಂಡು ಹೇಳಿ
ಎಸ್
ಯಾರು ಅವ್ರಿಗೆ ಎಲ್ಲಾರ್ಸ್ ಅಂತ ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೀನಿ.
1F and 1G.
ಎಸ್
1A ಗೆ
ಹೌದು.
1C,
ಹಾ
1F and 1G ಆಗ್ತದೆ.
1B ನು ಸತ್ತೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
1B,
ಹ್ಮ್. 1C 1B ನು ಸತ್ತೋಗಿದ್ದಾರೆ ಮೇಡಮ್.
1B ಸತ್ತೋಗಿದ್ದಾರೆ, ಅವ್ರಿಗೆ ಆಲ್ರೆಡಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ.
ಈಗ 1C
1C 1D
ಹಾ
ಅಲ್ಲ 1C ಸತ್ತೋಗಿದ್ದಾರೆ, ಅವ್ರಿಗೆ 1D and 1E.
1C ನು ಸತ್ತೋಗೋರ?
1C ಸತ್ತೋಗಿದ್ದಾರೆ ಸರ್.
1B ಸತ್ತೋಗೋರ್ರಿ.
ಸರಿ
1B ಗೆ ನೀವು ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀನಿ
ಎಸ್
ಪುಟ್ ಅಪ್ ಮಾಡಕ್ ಹೇಳಿದೀನಿ.
ಹೌದು.
ಈಗ ಮತ್ತೆ ಈಗ ಉಳಿದಿರೋದು ಯಾರು ಎಲ್ಲಾರ್ಸ್ ಯಾರು?
1C ಗಂಗಾ,
ಹಾ
1D
1D
ಮಂಜಿ,
ಹಾ
1E.
ಅಂದ್ರೆ CDE ಆರ್ ದಿ ಎಲ್ಲಾರ್ಸ್ ಅಂತನಾ? ಆಯ್ತು. 4B ಗೆ ಯಾರು ಹೇಳಿ? 4B ಗೆ 4A
4A ಇದ್ದಾರೆ ಸ್ವಾಮಿ, 4C ಇದ್ದಾರೆ.
4C ಇಲ್ಲ, 4C ನು ಸತ್ತೋಗೋರ ಅಂತ ನೀವು ಮಾಡಿದಿರಿ.
ಎಸ್ 4A ಒಬ್ರೇ ಸರ್. ಸಾರಿ
4A ಒಬ್ರೇನಾ?
ಹೌದು.
ತೊಗೊಳ್ಳಿ. The appellant counsel submits that 1C, 1D, 1E are the legal heirs of respond number 1A and they may be treated as legal heirs of 1A. And also counsel submits that R4A is the legal heir of R4B and R4A may be treated as legal heir of R4B. And hence counsel submission is accepted and 1C, D, E are treated as legal heirs of 1A and 4A is treated as legal heir of 4B. The appellant counsel is directed to amend the cast title in terms of his submission. List this matter immediately after some winter vacation.
And permit me to office objection
The
complement.
counsel also in the meantime directed to comply with other office objections. Non-filing of objections to A
For
one of
respondent number
24.
22.
Respondent
filing
number
the
10.
objection, ma'am.
Huh?
Filing objection.
Your Lordship, appearing for the appellants.
Objections to A number?
IA number 1 and 2. Sir.
Objections to A number 1 and 2 is filed by respondent number 22 na? ನೀವು 22 ಗೆ 22 ಅವ್ರು ಯಾರಿಗೆ?
Respondent number 10. Sir.
Respondent number 10 also files objections to A number 1 and 2.
Copy served. Sir.
ಏನ್ 1 and 2 ಏನ್ರಿ?
Delay application and also
ಇಲ್ಲ ಎಷ್ಟು ದಿವಸ ಇದೆ?
more than
900 days.
Yes.
ಹಾ
28.
ಡಿಲೇ ಆಫ್ 628 days ರೀ.
IA ಅಲ್ಲಿ
Non
mentioned.
filing of acknowledgement having served appeal memo to advocate for R1.
Your Lordship, we had to serve note, the copy to R10, Your Lordship. as
ಆ
per
10
the-
ಆಯ್ತ್ರಿ, 10 ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ. ವಾಟ್ ಅಬೌಟ್ R1?
It's,
ಕಾಸ್ ಲಿಸ್ಟ್ ನೋಡೋದಿಲ್ವ ಬೆಳಗ್ಗೆ
note,
ಲಿಸ್ಟ್ ಆದಾಗ?
yes,
ಹಾ R1 ಗೆ
we will do the needful, Your
Huh?
Lordship. We will do the needful, Your Lordship.
ಅದೊಂದು ಕಲ್ತ್ಕೊಂಡಿರ್ತೀರಿ. ವಿಲ್ ಡೂ ದಿ ನೀಡ್ಫುಲ್ ಅಂತ. ಸರ್ವಿಸ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಅಂತ ಕೇಳ್ತೀನಿ ನಾನು.
We have already done from
ನಾನ್
R.
ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾನ್ಮೆಂಟ್ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಸರ್ವ್ಡ್ ಅಪೀಲ್ ಮೆಮೋ ಟು ಅಡ್ವೊಕೇಟ್ ಫಾರ್ R1. R1 ಸರ್ವಿಸ್ ಮಾಡಿದ್ರೇನ್ರಿ?
Service ಮಾಡಿದ್ವಿ sir, ಎಲ್ರಿಗೂ ಮಾಡಿದ್ವಿ.
ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಆರ್ ಕೊಡಿ, ಎಲ್ಲಿದೆ ಹೋಗ್ಲಿ?
We will
Service
file it in
ಮಾಡಿದ್ವಿ.
the counter, Your Lordship.
ಹಾ
Counter ಅಲ್ಲಿ file ಮಾಡ್ತೀವಿ.
ಆಯ್ತು. ಹಾಗಾದ್ರೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕೇನ? R1 ಏನಾದ್ರು ನೋಟಿಸ್ ಹೋಗಿದೆಯಾ ನೋಡಿ? ಇವ್ರಂತೂ ಸರ್ವ್ ಮಾಡ್ಲಿಲ್ಲ.
ಸರ್ ಇದ್ರಲ್ಲಿ ಕೊನೆ ನಾನು ಹೇಳ್ತಾರೆ to dispense with while order dated.
ನೋಟಿಸ್ ಟು R1 to R9 and R11 and 12 ಆಲ್ರೆಡಿ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆಯಲ್ರಿ?
ಆಗಿದೆ sir.
ನೀವೇ ಮಾಡಿಸ್ಕೊಂಡಿದ್ರಿ ಡಿಸ್ಪೆನ್ಸ್. 1 to 9 and R11 to 21 and 23 ಡಿಸ್ಪೆನ್ಸ್. ಹಂಗಾರೆ ನೀವೇ ಕಂಟೆಸ್ಟಿಂಗ್ ಇಬ್ರೇನ್ರಿ?
22 for 22.
22 and 10 ಮಾತ್ರ ಕಂಟೆಸ್ಟಿಂಗ್, ಬಾಕಿಯವ್ರು ಇಲ್ಲ.
ಇಲ್ಲ.
This matter immediately after vacation.
Copy served to Swami. Objection copy served to
ಯಾವ ಕಾಪಿ?
appellant.
Statement of objection ಆ?
Objection, yeah.
ಆಯ್ತು. Copies of statement of objections filed by the respondent number 22 and 10 are served on the counsel for appellant. ಆಯ್ತಾ? This matter immediately after winter vacation.
Please.
See?
Such a place.
ತಲೆ ಹೇಗೆ?
ಇದ್ರಲ್ಲಿ ಮೇಡಮ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಟು A1 and 2 ಫೈಲ್ ಮಾಡಿದ್ವಿ. ಇಲ್ಲಿ ತೋರಿಸುವಾಗ A number 2 ತೋರಿಸೇ ಇಲ್ವಲ್ಲ? A number 1 ಮಾತ್ರ ಇದೆ.
ಸರ್ ತೋರಿಸ್ಯಾರ ಸರ್.
1 of 24
ಇದೆ.
ಮತ್ತೆ 1 of 24 ಅಂತ ಇದೆ.
ನಾನು 2 of 24.
ಅದೇನ್ ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್? ಆಯ್ತು.
ಅಮೆಂಡೆಡ್ ಕಾಪಿ ಕೊಟ್ಟು
ಏನ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಅಲ್ಲಿ ಅಷ್ಟೇ ಹೆಸರು ಬರ್ದಿರೋದು ಅಷ್ಟೇ, ಏನಿಲ್ಲ.
ಕೊಡಿ ಏನದು? ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್
That's,
to issue notice to R2 to 4.
For last time, my lords, they wanted us to change the GPA holder name ಅಂತ.
ಹಾ ಹಾ
ಅಮೆಂಡ್ ಮಾಡಿದೀವಿ ಅದು. Your lordships had permitted. us
ಕಾಪಿನ
ಅಷ್ಟೇ.
ಕೊಟ್ಟಿಲ್ಲ
ಅಲ್ಲ
ಅಮೆಂಡ್ ಮಾಡಿರೋ ಕಾಪಿ
ಇಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಬೇಕಾ? ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
ಕಾಸ್ಟ್
ಕೊಡಿ ಅವ್ರಿಗೆ, ಅವ್ರ ವಕಾಲತ್ ಹಾಕ್ಬೇಕಲ್ರಿ?
ಅಲ್ಲ ಅದು ಇವರು ಅವ್ರು R1 ಆಯ್ತು
Or
ಕೊಡ್ತೀವಿ.
if your amendment, my lord, last time.
Amend ಮಾಡಿದೀವಿ.
If the amendment is taken place, I have undertaken.
Filed
to
a
file
memo
wakalat.
copy is also served on the learned counsel for the appellant wherein prayer is sought in view of the order dated 15/10/24 on A number 9 in voice. So the appellant may be directed to amend the cast title by replacing the representation of the respondent number 4 trust through its irrevocable John Power attorney holder Mr. Rajiv Kumar. Learned counsel for the appellant would submit that the memo may be accepted and no objections to the same are subject to challenge to the order dated 15/10/12 passed by the trial court on A number 9. Current counsel for the appellant seeks time to make proper amendment in view of the memo filed by the respondents. The same shall be done within 2 days, 2 weeks ಅಂತಿದೆ. This matter on 18/12.
ಮಾಡಿದೀನಿ ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ ಅಂತೂ.
The counsel for the appellant would submit that he has already amended the cast title. Cast title amend ಮಾಡಿದ್ಮೇಲೆ ನೀವು amended cast title ಹಾಕ್ಲಿಲ್ವಾ?
Lords, we have done it in the thing only. We will file a amended cost title.
Physically ಮಾಡಿದೀರ ಅಷ್ಟೇ.
Physically ಮಾಡಿದೀವಿ.
ಆಯ್ತು, ಅದ್ರಲ್ಲೇ
ಅದೇನ್ ಬೇಕಂದ್ರೆ ಇವತ್ತು ಮಧ್ಯಾಹ್ನ ಒಳಗೆ
ಯಾರನ್ನ ಸೇರ್ಸ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಸೇರ್ಸಿದಾರ ಅಷ್ಟೇ ಈಗ.
ಅಷ್ಟೇ, ಇನ್ನೇನ್ ಮಾಡಿಲ್ಲ ನಾನು.
ಈಗ ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
My lord, if they are carried out, my lord, respondent number 4, I will undertake to file wakalat.
ತಗೊಳ್ಳಿ. In view of the amendment is carried out,
A Mohammed Tahir.
the appeal memo, counsel Sri
A Mohammed Tahir.
A.
Mohammed Tahir.
Mohammed Tahir
Tahir.
undertakes to file wakalat for respondent number 4 and
Lords,
if
2 and 3.
if wakalat is filed, show the name of the counsel for R4. ಹೇಳಿ.
2 and 3, my lords, in fact, 2 to 4 were placed ex parte. Our R1, 2 and 3 are son and daughter of R1, respondent number 1. Our wakalat hakangidre, I have no issue. Otherwise, I don't want to take a risk. Though they are placed ex parte, I will take.
2 and 3 wakalat ಹಾಕ್ತೀರಾ?
ಹಾಕ್ತೀನಿ.
ನೋಡಿ, counsel Sri
MS ಮುಕರಂ.
MS
ಮುಕರಂ
Mukarram undertakes to file wakalat for R2 and R3. ಆಯ್ತಾ? ಅಲ್ಲಿಗೆ Service complete ಆದಂಗ ಆಯ್ತು.
Copies may be directed. to
ಇವಾಗ್ಲೇ
served.
ಅದೇನ್ ನಾನು ಇವತ್ತೇ ಕೊಡ್ತೀನಿ.
The appellant counsel is directed to serve a copy of this appeal memo and annexures on the council.
Yes, full appeal memo.
R4. List this matter immediately after vacation and interim order granted earlier is extended till next date of hearing.
Please.
Next date ಬೇಕಾದ್ರೆ urgency ಇದ್ರೆ ಡೇಟ್ ಕೊಡ್ತೀನಿ.
Please.
ಕೊಡ್ಬೇಕಾ ಡೇಟ್?
ಕೊಡಿ.
Date after.
Date 125.
Please, ma'am.
Interim order extend ಮಾಡೋದ್ರಿಂದ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ 21/85.
Date. Milords,
Date
8
one.
ಬದಲು 9 on.
Huh?
8 I will not.
ಆಯ್ತು 9/1.
Please.
2 and 3 को क्या लिखो MS?
MS Mukarram.
Hearing for that.
That you also the other end.
Non-filing of received acknowledgement
Lots.
from
Caveat copies have been served. Caveat, the caveat has been
KVTR ಕರ್ಸರು ಮಾಡಿದೀರಾ?
served ಮಾಡಿದೀವಿ. Copy
Has served
ಸಿಕ್ಕಿದೆ.
the copy.
Council appearing with the appellant submits that he has served the copy on the KVTR council and KVTR council who is also present acknowledge the same. ಏನಾಗ್ಬೇಕು ಇದ್ರಲ್ಲಿ?
Not the
Council
sought for-
submission and office objection with regard to difference in challenging A number ಅಂತ ಏನೋ ಇದೆ?
There are
ಅದು
13
ಏನಾಗಿದೆ
office
ಅಂದ್ರೆ
objections are there, ma'am. There are 13 office objections are there.
All
on
of
the
them have
appeal
been
memo.
complied, all of them have been complied with. ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇದರಲ್ಲಿ could I just request not look at page 38. ಅದು in the certified copy of Milords the order, there is a difference Milords in the trial court Milords.
Mentioning A number.
Mentioning the IA.
ಹಾ.
ಏನಾಗಿದೆ ಅಂದ್ರೆ
A number 2 ಅಂತ.
IA number 2 ಅಂತ ಹಾಕಿದ್ದಾರೆ, ಬಟ್ ಕೆಳಗಡೆ ನೋಡಿದ್ರೆ IA number 1 is filed ಅಂತ ಬರ್ದಿದ್ದಾರೆ. So that appears to be the.
A number 1 filed by the plaintiff under that, ಆ ರೀತಿನಾ?
ಆ ರೀತಿ ಇದು IA number 2 ಮೇಲೆ actually order
The
ಆಗಿರೋದು.
council submission is accepted regarding mentioning the IA number in the cast title and also the reference made while passing an order as IA number 1. Cast title as IA number 2 and reference is made as IA number 1. And the same is only a typographical error. ಆಮೇಲೆ ಬೇರೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಷ್ಟಿದೆ?
Not all the other office objections have been complied with.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆಯಲ್ರಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್
The
ಎಷ್ಟಿದೆ?
application which has been filed by the appellant is not filed as per the civil rules of practice. That is the office objection. They have to change it.
Office
That application has to be
objections
changed.
Not raised.
Lots. ಆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇದು
12 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಲ್ರಿ?
It's complete.
ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ ಮೇಡಮ್, ಇಲ್ಲಿದೆ ಇವತ್ತನ್ನು ಕೂಡ. ಅರ್ಲಿಯರ್ ನೀವೇನೋ ವಿಡ್ರಾಯಲ್ ಕೇಳಿದ್ರಿ, ವಿಡ್ರಾಯಲ್ಗೆ ಮೆಮೋ ಹಾಕಿದ್ರಿ, ದಟ್ ಮೆಮೋ ಇಸ್ ವಿಡ್ರಾನ್. Now there are 12 office objections. ಕೇವೆಟ್ ಸರ್ವಿಸ್ ಆಯ್ತು ಈಗ ಮಾಡಿದಾರೆ. ಅದಾಗೋಯ್ತು, ಈಗ ಅವರೇ ಮುಂದೆ ಇದಾರಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ, ಅದ್ ಬಿಟ್ರೆ ಬೇರೆ ಏನಿದೆ? ನೋಡಿ ಅಷ್ಟು 12-13 ಇದೆ. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ನಾಳೆ
ಏನ್ರಿ ದಿನ ನೆನ್ನೆಯಿಂದ ಇವತ್ತು, ಇವತ್ತಿಂದ ನಾಳೆ? This matter immediately after winter vacation.
Much of.
ಇಲ್ಲ, some urgency Milords.
ನೀವು ಸರ್ವ್ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನ್?
Milords will comply. I was given to understand that Milords ಎಲ್ಲ ಕಂಪ್ಲೈ ಆಗಿದೆ.
This
ನಾಳೆ
matter on 20th.
20th, I have an operation already on
Yeah.
20th.
ಲಾಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ ರೀ, ಅವತ್ತು ಇರ್ರಿ, ಆಮೇಲೆ ಹೋಗ್ರಿ, ಹೊರಗಡೆ ಹೋಗೋದಾರ.
Date has been fixed for my operation on 20th.
ಹಾ.
May be taken on 19th or else after vacation.
19 ನಾಳೆನೇ ರೀ. ಆಯ್ತು, ನಾಳೆನೆ ಹಾಕಿ. ಅದೇನ್ ನೋಡ್ರಿ, in the meanwhile comply.
I'll come.
Appellant counsel is directed to comply with office objection in the meanwhile.
Milords, the next one Milords, there are 2, ಎರಡಿದೆ.
ಅದ್ರಲ್ಲೂ ಸೇಮಾ?
Same. In fact, ಅದರಲ್ಲಿ
Same
there are no
order.
other office objections.
ಅದ್ರಲ್ಲೂ ಸೇಮ್ ಆರ್ಡರ್. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಾ?
ಅದರಲ್ಲಿ ಬೇರೆ ಆಫೀಸ್ objections ಇಲ್ಲ.
ಬೇರೆ
ಬೇರೆ ಇಲ್ಲ, ಇವೆರಡು ಬಿಟ್ರೆ.
ಇದು ಎರಡು ಮಾತ್ರ.
ಎರಡು
ಅದಕ್ಕೆ ಸರ್ವ್ ಮಾಡ್ಬೇಕು ಮತ್ತೆ
ಅದಾಯ್ತು.
ಅದೇ ನಂಬರ್ ಅವೆರಡು ಬಿಟ್ರೆ ಮಿಕ್ಕಿದ್ ಯಾವ್ದು ಇಲ್ಲ.
ಅದನ್ನ ತಗೊಳ್ಳೋಣ, ಕೊಡಿ ಅದನ್ನ. If it is complete, we can take it. First one ಆಯ್ತು. ಏನೀಗ ಪ್ರೇಯರ್ ನಿಮ್ದು? What is the prayer? A number 1.
Milords, this is with respect to Milords non-alienating the property. Milords, my entire
39 rule 1 and 2.
page 38 Milords. Milords, I am the owner of Milords survey numbers 196/3 and 196/1.
196/3.
And 196/1. I had not purchased it by way of Milords sale deeds in Milords way back in 95. Even prior to that Milords, the title Milords continues. The respondents claim Milords to have purchased 196/2.
196/2.
Part 2. Now, Milords, as far as my 196/3 and 196/1 are concerned, I have Milords had possession Milords right from 95.
What is the extent 196/3L?
The total Milords is about 4 acres.
Total
That
4
is Milords 2 acres 5 guntas. 196/1 is 2 acres 5 guntas. 196/3 is 2 acres 10 guntas. So totally Milords 4 acres 15 guntas.
196/2 measures, my lords, about 1 acre, 34 guntas.
34 guntas.
My lords, I have been enjoying, my lords, several interim orders. There have been, my lords, attempts to, my lords, dispossess me as between, my lords, the very same respondent one. There are, my lords, other suits pending, other than injunctions. At this juncture, my lords, 196/2, my lords, he seeks to purchase. Now, in that, what he has done is 196/2, 1987 sale deed ide. Otherly, there is, my lords, one set of boundaries that are, my lords, shown. Suddenly, my lords, in 2022, there is another sale deed that is executed in favor of by the first respondent in respect of in favor of second respondent, where boundaries are changed. Virtually, my lords, my property is now 190.
Clear sale deed and subsequent sale deed.
Although there is a difference in the boundaries.
Description.
The description by way of the boundaries, my lords, have changed. There is a discrepancy. Now, by virtue of this, it is my contention that, my lords, my 196/3 and 196/1, which I own and in respect of which I have several injunction orders, is clandestinely sought to be made part of this 196/2. So therefore, my lords, I had filed the suit seeking to set aside that sale deed insofar as, my lords, it pertains to my 196/3 and 196/1. I had also, my lords, filed 2 IAs. One IA, my lords, with respect to, my lords, not to disturb my possession. The other IA, which is the subject matter of this application, this very appeal, is not to alienate. Now, insofar as this not to alienate is concerned, in fact, this honorable court, my lords, had granted an order, ex parte order siglilla. Thereafter, my lords, in a writ petition, this honorable court, my lords, had granted that order. I'll just, my lords, pass across. And came to be, my lords, confirmed also, my lords, by the court. And this continued till, my lords, the disposal of the suit. That is the disposal of the IA, my lords. Saying, my lords, not to alienate. Idralli, tavu, if the interim order, my
By
lords,
granting an order directed to dispose of the application.
and in the meanwhile, my lords, they are my lords, directed not to alienate the properties. In fact, my lords, when, my lords, the interim order was there itself, they had entered into, my lords, a registered MOU seeking to, my lords, alienate the property. Contempt is there, all that is there. But ultimately, my lords, it is this: the trial court rejects my application primarily, my lords, on the ground that I have not made out a prima facie case. It says that my earlier sale deeds were in respect of one survey number 18. And I am now claiming in respect of one survey number 196/3 and /1. In fact, the very documents that they have produced, which is the revenue records, shows, my lords, that 196 and survey number 18, my lords, were one and the same. Avare produce madidare, my lords, documents are there. All of this, my lords, the trial court does not even, my lords, look at, and simply says, well, look, you've executed rectification deeds. That does not come to your benefit.
How it is changed? Whether because of body work or anything?
No, this is an old survey number.
According to you, old survey number.
Old survey number 18. Thereafter, my lords, there is resurvey number. It becomes 196.
That is after body work.
So all of this, my lords, trial court does not consider. Trial court also further says, look, you have not indicated what is the extent of the encroachment. Now, I am saying, well, they have the entire 1 acre 34 guntas.
Is it your case that they have encroached in a suit?
By virtue of not changing this thing, now they are 196/2 as it stands. Virtually, my lords,
Maybe the description they have changed in the sale deed. Is it your case that they have encroached your property?
they are, my lords, by virtue of this,
Then if it is encroached, then you have to seek for the relief of possession.
I have, my lords, sought for
What is the relief you have sought in the suit?
Page number 73.
page, my lords, 75. Sorry, 73, my lords. In page 73, my lords.
73, prayer.
Prayer. Wherefore, plaintiff please, the honorable court may be pleased to pass judgment and decree against the defendants of the following relief. Declare that the registered sale deed dated so and so, registered document number so and so is not binding on the plaintiff hearing to the extent that it encroaches on schedule A and B property being survey number so and so herein. Issue an order of permanent injunction as the defendants from interfering with the
And that
peaceful.
it encroaches ಅಷ್ಟೇ. That ಅಂದ್ರೆ description what they have
Please,
shown
lords.
is encroaches ಅಂತ.
ಅಷ್ಟೇ.
But
So-
they have encroached ಅಂತ ಏನಿಲ್ಲ ಇಲ್ಲಿ.
Please, my lords. So therefore, my lords, my only request, my lords, would be this. ಈಗ suppose with, my lords, this particular boundary. Now, if they, my lords, go ahead and, my lords, create further, as far as, my lords, that other IA, my lords, of my possession and all that is concerned, my lords, I'm not really, my lords, pressing that. But further alienation, if they, my lords, now alienated further with this, my lords, very same schedule,
Hmm.
it's virtually, my lords, in the nature of, my lords, alienating my property of 196/3 and 1.
Hmm.
All of this, my lords, is not appreciated by the trial court. Trial court simply says.
Sir,
not
they are
allowed.
claiming only relief in respect of 196/3 and 196/1.
Please, my lord.
Not to alienate. That is also relief is not to alienate. How it will come in the way? Your survey number is 196/2.
No, my lord. I
Hmm.
have purchased two schedules. One is 196/2. It's exclusively property of the respondent number 2.
Aito.
The petitioner before this honorable court, the appellant before this honorable court doesn't have title over the said survey number.
196/2
Part 2.
ಇಲ್ಲ.
It's exclusively property of the respondent.
ಆಯ್ತು.
And the survey number 196/1, they claiming they are also purchased the property, very same property. My lord, I'm requesting my lords to kindly see the.
You are also having any right in respect
Yes,
of
my lord, yes, my lord. I have a-
196/1?
Please, my lord.
196/1 ಸೇಲ್ ಡೀಡ್ ಇದೆಯಾ ನಿಮ್ಗೆ?
Sale deed ಇದೆ.
ಎಷ್ಟು
Sale deed.
ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟು?
2 acres 5 guntas.
2 acres 5 guntas also they are claiming.
Now I'll come to convince my lords. I'm requesting my lords to kindly see page number 73, the prayer of the suit.
Hmm.
The which shows declare the register sale deed dated 30th/4/2022. So and so
Their
is
contention,
not binding.
their contention
Please,
is
my lord.
in the sale deed dated 30/4/22, while mentioning the property, their property is shown. That is the reason only they sought for the relief of sale deed dated.
Yes, my lord.
That description shown in the sale deed 34/22 is not correct ಅಂತ.
No, my lord.
ಆಯ್ತು, ನಿಮ್ 34/22 ಗೆ ಒರಿಜಿನಲ್ ಓನರ್ ಬೌಂಡ್ರೀಸ್ ಏನಿದೆ?
My lord,
It should be corollary to the earlier sale deed.
please, my lord.
ಹೌದಾ? ಆ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಇದೆ.
The titles which they are claiming now
ಹ್ಮ್.
doesn't say single line about how the survey number 18 has been changed to survey number 196/3.
ಹ್ಮ್.
They purchase the property under a register sale deed where it has been shown as survey number 18.
ಹ್ಮ್.
After few days, they have made a rectification deed where
Hmm.
they have mentioned 196/3. How the survey number has been changed in the sale deeds, my lord.
ಹ್ಮ್. ಹ್ಮ್.
If something says,
ನೀವೇನ್ ಹಾಕಿರೋ ದಾಖಲೆಲ್ಲ ಅವರು ಚೇಂಜ್ ಆಗಿ
not a single paper they have produced.
ನೀವು ಹಾಕಿದಿರಿ ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ. ಯಾವ್ದ್ರಿ ಹಾಕಿರೋದು?
No, no, one, sir, the document which I have produced
My lords,
is the,
ನೀವ್ ಹೇಳಿದ್ರಲ್ಲ ಯಾವ್ದದು?
ಅದೇ ಇದು ಸರ್ವೆ ರೆಕಾರ್ಡ್ಸ್. Just my lords.
ಆಯ್ತು, ಡೀಟೇಲ್ ಏರ್ ಮಾಡೋಣ. ಈಗ ಏನ್
This
trial
is-
court-
it refers-
ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಅದನ್ನೇ
That has
ಕಂಟಿನ್ಯೂ
to
ಮಾಡಿ.
continue, lords. That is all that I
Continue
see.
ಮಾಡಿ ಅಷ್ಟೇ.
reason, my lord,
ಹಾ.
kindly permit me to.
Already
make
there
a
was an
submission.
order by this court till
Because
till
on the basis
disposal
of
of
my
IA.
submission, on the
Ah.
basis of my submission, that writ petition has been disposed,
ಹ್ಮ್.
saying that I only made a submission before the
ಹೌದು,
court
ನೀವೇ
saying that
ಮಾಡಿದಿರಲ್ಲ ಇಲ್ಲಿ
within
ಇದೆಯಲ್ಲ.
2 months of, within 2 months, the trial court has to be directed to
Trial
decide
court
the
perused the
application.
material on record and held that there was no prima facie case made out for grant of ad interim temporary
Madam,
extension. Being
requesting
agreed
lords to
this-
kindly see page number 77, valuation slip.
ಹಾ.
They have paid 225 rupees under section 7 subclause 2 of the Karnataka Court Fees Act. Now I am requesting lords to kindly see page number 129, where the land is not an agricultural land, it has been converted.
ಅದೆಲ್ಲ decide
So
ಮಾಡಿ
the court fee has
trial
not
court
been
ಅಲ್ಲಿ
paid by the property.
you file an application. If the suit is not properly valued, you file.
I have filed it, Mara, everything
Let
is
the trial
filed.
court decide now. That is not the issue now. Because while disposing of writ petition, you yourself has given consent. Continue the
ಇಲ್ಲ,
interim
ಏನಾಗಿದೆ,
order
ಇಲ್ಲಿ state
granted by
ತಗೊಂಡ್
this
ಬಿಟ್ರು.
court dated 20/12/22 may be continued till disposal of the interim application ಅಂತ ನೀವೇ consent ಕೊಟ್ಟಿದ್ದೀರಿ.
ಹೌದು,
ಈಗ
ಅಂದ್ರೆ-
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರೆ ಅವರು.
ಹಾ.
ಅದೇ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ. ದೆನ್ ಲೆಟ್ ದಿ ಕೋರ್ಟ್ ಡಿಸೈಡ್ ದಿ ಸೇಮ್ ಇನ್ ದಿ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ ಅಷ್ಟೇ.
ಇಲ್ಲ.
ಹಾ. ನೀವೇ submission
May I make a
ಮಾಡಿದ್ದೀರಲ್ರಿ?
request, my lord? May I make a request, my lord?
ಹಾ,
Anyhow, the other matter is coming tomorrow. This matter also may be have tomorrow, so that I will take that.
List this matter also tomorrow.
Please, my lord, please.
6.
This I appear for the appellant.
Complaint.
Based on 7 objections, my lord, I'll comply with the office objection. 2 weeks time may be granted.
Counsel for the appellant seeks 2 weeks time to comply with office objection and hence 2 weeks time granted as sought. List after winter vacation.
So I may be permitted to carry out the objections, my lord, during the vacation. That
During vacation ಕೊಡ್ತಾರೆ.
Yes.
ಲಿಸ್ಟ್ ಮಾಡೋದ್ ಮಾತ್ರ ಆಫ್ಟರ್ ವೆಕೇಶನ್. ನಾಳೆಯಿಂದಲೇ ನೀವು ಹೋಗ್ಬೋದು, ಯಾವ ತರ ಹೋಗಿ ಕಂಪ್ಲೈ ಮಾಡ್ಬೋದು.
they don't permit, my lord.
ಪರ್ಮಿಟ್ ಮಾಡ್ತಾರ್ರಿ, ನಾನು ಹೇಳಿದೀನಿ 2 weeks ಕೇಳಿದಿರಿ, 2 weeks ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಬರ್ದಿದ್ದೀನಿ ಆರ್ಡರ್ ನಲ್ಲಿ.
Defendant's appeal, my lords. Lords, defendant is a club. The office objection that has been raised
Counsel
is
submission with regard to
Counsel.
non-stating of correct details of appellant as per trial ಕೋರ್ಟ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಂತ.
Plaint
ಟ್ರಯಲ್
ಅಲ್ಲಿ
ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಬಂದು
ಏನಿದೆ ಆ ತರ ನೀವು ಇಲ್ಲಿ ಹೇಳಿಲ್ಲ ಅಂತ.
ಹೌದು, plaint ಅಲ್ಲಿ ಬಂದು it says
Hmm.
it's a company incorporated under the Companies Act. It is not a company, it's an association of persons. So the name, everything is the same, but yeah, characterization ಬಂದು change.
ಯಾಕೆ ಚೇಂಜ್ ಮಾಡಿದ್ರಿ? ಹಂಗೆ ಹೇಳ್ಬೇಕಲ್ಲ.
It's not a company, Manoj.
ನೀವು ಅಲ್ಲೇನ್ ಹೇಳಿದ್ರಿ ಅದೇ ತರ ಹೇಳ್ಬೇಕು.
ಇಲ್ಲ, I'm the defendant, Manoj.
ಆಯ್ತು.
The plaintiff has wrongly said, if your lordship see in the plaint page
ನೀವು
20,
ಹೇಳಿದಿರ ಅದನ್ನ
page 20.
ಫೈಲಿಂಗ್ ದಿ plaintiff suit wrongly described the defendant ಅಂತ ಏನಾರು ಹೇಳಿದಿರ ಹೋಗ್ಲಿ ನೀವು?
Manoj, in my written statement also I have taken that stand. Manoj.
Catholic
That
Club and Association persons.
Association of
Museum Road.
page 29, plaint ಅಲ್ಲಿ ಬಂದು
Same ಇದೆ. Address are same.
everything is the same, Manoj. Just the entity in that sense.
ಆಯ್ತು. The council submission is accepted regarding the defendant number 1 is not ನಿಮ್ದು incorporated under the provisions of Companies Act ಅಲ್ವಾ?
ಅಲ್ಲ,
ಹಾ.
association of
Same is not incorporated under the provisions of Companies Act 1956 and the same is an association.
ಹೌದು, association of persons.
Association of persons. And hence the office objection is overruled. Next non-filing of received acknowledgement from
Plus
Cavator
that
for him.
I had served by email, I've served them a physical set also.
Physically ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ನೋಡಿ. Cavator counsel submits that he has received the copies of the appeal memo. ಹೇಳಿ ಏನಾಗ್ಬೇಕು?
Lords, plaintiffs obtained membership of the club in January 2022, Manoj. Thereafter, on 13th of February 2022, there was an incident where they got drunk and they abused and physically assaulted the staff of the club. We issued them a show cause notice. They replied to the show cause notice, took part in the inquiry, their membership was terminated on 10/3/2022. So they were a member for all of about 58 days. Was aggrieved by the termination, they filed a suit. Suit al bandu onde ground iradu that they have not received any show cause notice. In my written statement, I've produced not only the show cause notice, I've also, of course, produced the CD showing the incident itself. I've produced the show cause notice and their reply to the show cause notice. Lords, in spite of that, the learned trial judge, my lords, accepts all of that and says, yes, we have produced it, and then says it has to go to trial and therefore passes an interim order in November of 2024, my lords, when the suspension, or sorry, the termination was in March 2022. My lords, may kindly see the plaint at page 29. ಅಲ್ಲಿ at 31 paragraph 9.
Paragraph number
9, Swami. Page, ink page 31, al bottom, last paragraph. That the plaintiff submit that the termination of his membership by the defendant without giving notice as per the rules of bylaws as produced above is highly illegal and arbitrary. Ashte our case. Thereafter, my lords, in my written statement at page 36, at 41, I have produced, just filing the plain documents and written statement documents. What would you have? Page, my lords, page 61 is the show cause notice, my lords,
now the documents which you have produced
along with the written statements. 61 ತಾವ್ ನೋಡಿದ್ರೆ 16/2/2022.
61.
Please, my lords. This is the show cause notice. My lords, their reply is at page 68. Where defendant number 1 says, respected sir, madam, this is with reference to your show cause notice, and he makes certain statements. 71 al bandu, the defendant number 2 son, sorry, respondent number 2 son also responds to the show cause notice. And in fact, 71 ali, in the last paragraph, I humbly request that this matter, sorry, I humbly request that this matter be looked into further and suspension be lifted, as I pledge this is a first time incident and intend on it being the last. I would again like to sincerely apologize for violating the club policy. 74 again, my lords, there is a response. Lords, before I take your lordships to the impugned order, may I kindly draw your lordship's attention to page 46. It's the folded pages from photographs of the
46.
46. How?
Of now new compilation or old?
ಇಲ್ಲ, the new compilation.
Compilation.
ಹೀಗಾಗಿ.
This is the photograph.
ಹೌದು. This is the first on 46 is respondent number 1. Lords 47, your lordships will see in the bandu respondent number 1 is raising his hand in front with the back with that Keith Harrington collection, that is respondent number 2. Your lordships can see the conduct. Similarly, my lords, page 48 and 49 show the respondent number 2, who is the respondent number 1's son. Then again, 50 and 51, my lords, show 51 in fact shows the respondent number 1 pushing someone. My lords, in spite of all of this, please see, my lords, the impugned order, which is along with the appeal. Impugned order, my lords, begins at page 16. Lords, at page 25. Paragraph 10, Swami. On the other hand, defendant numbers 1 and 2 have produced copies of complaints lodged by aforesaid bouncers by name so-and-so against plaintiffs for their alleged misconduct during so-and-so event held on 13/2. Copy of letter addressed by HR head of defendant number 1 to plaintiff about club membership interview. Copy of show cause notice issued by D2 to plaintiff number 1 and 2, calling for explanation and misconduct along with the aforesaid 2 bouncers through email. Reply issued by plaintiff number 1 to the said show cause notice dated 16/2. Copy of email addressed by plaintiff number 2 to defendant number 2 dated 16/2, furnishing his explanation to the show cause notice. My lords, thereafter, towards the middle of that page, my lords, the line starting with however. Does your lordships have it, my lord, please? However, whether plaintiffs have committed any act of misconduct or misbehavior during aforesaid event of the club dated 13/2, whether they were afforded proper opportunity to put forth their defense. My lords, I'll just pause to say this is not even their case before the inquiry committee, and whether the termination of plaintiff number 1 is carried out in accordance with law is a matter to be decided after full-fledged trial. And therefore, my lords, almost 3 years after his termination, without any discussion on whether there is a prima facie case and how the balance of convenience, in fact, my lords, just by virtue of it having been almost 3 years, and he was a member for at best 58 days, my lords, goes ahead and passes this interim order, allowing him to access the club, my lords. My lords, just, of course, in terms of the case law and the precedent on the point, my lords, the Supreme Court in Daver's case itself held that there should be no interference in club matters. May I just rely on 2 judgments, my lords, of our Honorable High Court?
No need. Adrian.
Lordship, they have taken 1.5 year time to argue the matter. They have taken 1.5 year time to argue the matter for the lower court on IA. And more, Lordship, I got the order on 27th November. Immediately thereafter, I applied for the certificate copies. I have produced the copy. So far, they are not allowing me to enter the club. And more, Lordship, the bouncer, before my mother, he says, be bastard. Thereafter, my mother has complained, given the complaint.
But what is your ground in the plaint, counsel?
Your Lordship.
You said that in paragraph number 9, without giving any notice as per the rules of bylaws as produced above is highly illegal and arbitrary.
Your Lordship. Yes,
But show cause notice was given.
Show cause
You have
notice-
given reply.
We have given-
And reply also you have regretted to the incident.
Yes, Your Lordship.
That you will not repeat in future also.
Yes, Your
Then
Lordship.
there you yourself has admitted that the incident is concerned and also regretted. Then how can you contend that no opportunity is given to you, no notice was given to you?
As per the bylaws, once they issue the notice, they have to allow me physically to be present before the committee before passing any final order.
I3, what is your ground for quashing of the expulsion order?
Your Lordship, I will file the objections, sir. They have filed IA. I will file the necessary objections, Your Lordship.
Told. Heard the appellant counsel and counsel for the respondent seeks time to file objections to IA.
IA, sir.
ಯಾವ IA ಗೆ?
They have filed IA, Your Lordship.
Objections to IA. And the counsel appearing for the appellant brought to notice of this court the very ground urged in the plaint in paragraph number 9 that no notice was given and also brought to notice of this court that show cause notice was issued and also the respondent has given reply. Thereafter, he appeared before the committee na ಏನ್ ಮಾಡಿದ್ರಿ?
Enquiry committee.
Inquiry committee and then passed an order. Then contention that not met the principles of natural justice cannot be accepted and having taken note of the material on record, the impugned order is stayed till in a state of hearing. This matter immediately after winter vacation. ಯಾವಾಗ ಬೇಕು ನಿಮ್ಗೆ ಯಾವಾಗ objection ಹಾಕ್ತೀರಿ ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
I will have immediately after interrogation.
On 8/1/2025.
Eight.
Most grateful.
Gangadhar.
Appellant.
ಏನ್ ಆಫೀಸ್ objection ಏನಿದೆ?
3 office objections have been raised. Regarding the application which was considered by the trial court. By mistake, it has been mentioned as IA number 2, it should have been IA number 3. 4 applications were filed at the time of filing the suit. One is, IA number 1 is seeking permission of the court by the mother guardian to file the suit on behalf of the plaintiff, minor plaintiff. IA number 2 is for dispensing with the issuance of notice to the dependents and to take the application for injunction on record. IA number 3 is filed under Order 39, Rule 1 and 2. That is the order that has now been challenged before this honorable court.
39 Rule 1 and 2 is challenged.
Yes. So therefore, office objection, so far as this is concerned, it may be overruled.
Office objections ಏನು? IA number
IA number 2 ಅಂತ ಇದೆ, IA number 3 objection ನಲ್ಲಿ IA number 2 ಅಂತ ಹೇಳಿದ್ದಾರೆ. That is filed by the respondent, but it should have been IA number 3. It was a typographical mistake, possibly. Kindly see page number 45 and 47, where they say IA number 2.
ನಿಮ್ prayer lane IA number 2.
IA number 3, that is the, in fact, kindly tell.
ನೀವೇನ್ ಮೆನ್ಷನ್ ಮಾಡಿದಿರಿ ಹೇಳಿ?
Please go to page 48 for a minute. Page 48 and page 49.
48 is the order sheet of the trial.
Yes, kindly go to this IA number 1.
ನಿಮ್ prayer lane ಇದೆ ಅಂತ ಕೇಳಿದೆ ನಾನು.
Prayer ನಲ್ಲಿ
ಈಗೇನ್ prayer ಕೇಳಿದಿರಿ?
IA number 3.
IA number 3
pass on.
IA number 3 ತಲೆ ಕೇಳಿದಿರ prayer ಲಿ? ಏನ್ ಮೇಡಮ್? IA 2 ಈಗ ಹಾಕಿರೋದಾ? IA number 2 ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
IA number 3, page 7.
Under section 151, please to dispense with production of legible and typed copies of RTC. ಅದೇ ಬೇರೆ ರೀ?
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ RTC extracts ಕೈನಲ್ಲಿ ಬರವಣಿಗೆ ಇರೋದು ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿಲ್ಲ ಅಂತ ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ.
ನೋಡ್ರಪ್ಪ ನನಗೇನು ಅರ್ಥ ಆಗ್ತಿಲ್ಲ.
The other objection.
Now you have sought the relief against the order passed by
IA number 3. IA number 3.
IA number 3 reject ಆಗಿದೆಯಾ?
Yes. So that is the order that is under challenge before the
IA number 2 does not tally with the IA filed before trial court.
No, it is the objection. Objection to IA, wherein they have mentioned it as IA number 2.
Court be placed to issue an interim order of temporary injunction restraining defendant number 1 to 4 from in any manner transferring, alienating, encumbering or creating any third party interest in respect of properties mentioned in the schedule hereunder in the interest of justice and equity. ಅದಲ್ಲೇನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಕೇಳಿದ್ರ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅರ್ಜಿ ಇಲ್ವಾ ಇಲ್ಲಿ?
IA number 3.
ಏ ನಂಬರ್?
ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಾದ್ರೆ IA number 2 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ, ನಾಟ್ ದಿ ಅಪ್ಲಿಕೇಶನ್.
3 ಇದೆಯಲ್ರಿ? 3 ಕರೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ? IA number 3 ನಲ್ಲಿ ಏನ್ ಪ್ರೇಯರ್ ಕೇಳಿದ್ರೆ ಅದ್ರ ಎಗನೆಸ್ಟ್ ಬಂದಿದ್ರೆ ಅದ್ರ ಪ್ರಕಾರ plaintiff in the OS number 4 temporary injunction is sought only against defendant number 1 and 2. In the present appeal, appellant is seeking the temporary injunction against all the respondents, that is respondent number 1 to 5.
They are trying to alienate the property belonging to the Hindu joint family, of which the plaintiff is the minor, one of the co-person.
Whatever it may be, what is the relief you have sought before the trial?
Before the trial court, I sought
against defendant number 1 and 2.
1 and 2, but
the same has been
they are the members. Yes,
same has been rejected.
the same has been rejected initially.
Now how you can seek for the interim relief against 1 to 5?
They are all the members of the family.
Maybe counsel.
The father.
You have not
the
sought any
grandfather. The grandfather, grandmother.
You have not sought any relief against defendant number 3 to 5.
Then I will confine.
You
by
confine
filing a
ಅಷ್ಟೇ,
memo, I will
ಅದಕ್ಕೇನು office
confine.
objections ಅದು.
I will.
You are not stating the actual fact.
No, I will confine the relief in the present application.
Unless you seek the relief against defendant number 3 to 5 before the trial court, now you cannot seek any relief before this court against 3 to 5.
I understand,
ಮತ್ತೆ
but they are all the members of the Hindu joint family. I have produced
whatever it
documents.
may be, counsel,
I have documents to,
maybe they are the members of the Hindu joint
I have
family.
produced the documents in this appeal which were produced before the trial court to show that other members of the family are also
Senior
attempting
counsel.
to sell the property. That is the reason. That is the reason. They are attempting
No,
to sell the
ಏನು-
property.
ಏನದು?
I have produced the
The
documents.
appellant counsel is directed to comply with office objection regarding office has raised the objection that the prayer sought in before the trial court is only against defendant number 1 and 2, and now the relief is sought against the defendant number 1 to 5, and hence the office objection is upheld. Next. Schedule aleno?
Schedule nalli
Schedule
initially in respect of item number 1 and 2, interim order of injunction was sought.
ತೋಟ ಅಂತಿದೆ. ಇಲ್ಲೇನ್ schedule ಹಾಕಿದಾರೆ ತೋರ್ಸಿ. ಇಲ್ಲೇನಂತ
ಎಲ್ಲದಕ್ಕೂ ಹಾಕಿದೀನಿ. All the items
ಇಲ್ಲೇನು?
which are the subject matter of the suit. 6 items.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ನೀವು ಯಾವ್ದೋ 2 schedule ಮಾತ್ರ ಹಾಕಿ.
Item number 1 and 2 ಅಂತ ಕೇಳಿದು, but all the items
ಇಲ್ಲೇನ್ ಮಾಡಿದಿರಿ?
ಇಲ್ಲಿ in respect of the suit schedule properties.
ಎಲ್ಲದಕ್ಕೂ ಕೇಳಿದಿರಿ.
ಎಲ್ಲದಕ್ಕೂ ಕೇಳಿದ್ದೀನಿ.
ಮತ್ತೆ ಅದು ಹಂಗಾಗಲ್ವಲ್ಲ? ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಒಂದು ಪ್ರೇಯರ್, ಇಲ್ಲೊಂದು ಪ್ರೇಯರ್. ದಿ ಅದರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರಿಗಾರ್ಡಿಂಗ್ ಶೆಡ್ಯೂಲ್ is also upheld.
I will file a memo to that effect.
Directed to comply with office objections.
Kindly call this matter tomorrow. In the meanwhile, I will comply the office objection by filing the memo. It may be ordered to be called tomorrow because these
And
respondents are trying to
comply
alienate the property.
Comply the office objection and list this matter day after tomorrow. ಫೈಲ್ ಹೋಗ್ಬೇಕು, ನೀವು ಅಲ್ಲಿ ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕು, ಆಗಲ್ಲ ನಾಡಿದ್ದು.
9. This is Sunita.
Non-amendment of cast title in respect of R2 and non-filing of amended cast title. ಹೇಳ್ರಿ ಯಾಕ್ ಮಾಡಿಲ್ಲ? 4/1/24.
Appeal memo is ready.
Huh?
Appeal memo is ready. Amended appeal memo is.
ಅಮೆಂಡ್ ಮಾಡಿದಿರಾ ಇಲ್ಲ?
Amend ಮಾಡಿಲ್ಲ.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಮೆಮೊ ಹಾಕಿ.
Please.
ಅಲ್ಲ ರೀ, ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ದಲೇನೆ ನೀವು ಅಮೆಂಡೆಡ್ ಅಪೀಲ್ ಮೆಮೊ ಹಾಕಕ್ಕಾಗುತ್ತಾ?
ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ, ಇದೆ.
ಆಯ್ತು, 1 ವರ್ಷ ಆಯ್ತು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಕ್ಕೆ. ನೆಕ್ಸ್ಟ್
10.
ಅರ್ಲಿ ಹಿಯರಿಂಗ್. Heard appellant counsel and counsel for SP Naik idara illa, and respondent counsel absent, and prayer is sought on IA number 1 of 24 for early hearing, and having considered the matter of the year 2022. And what is the urgency? 22 matter ಲೇನ್ರಿ? Urgency ಏನು?
Urgency is there is a dispute regarding the property. First week of
early hearing ಅಂದ್ರೆ ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ?
ಹೌದು.
MF ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ ನೋಡಿ ಮೇಡಮ್. ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಆಗಿದೆ ಅಷ್ಟೇನೆ. ಅಡ್ಮಿಟ್ ಆಗ್ದಲ್ಲ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಹೆಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋತೀರಿ? ಇಲ್ಲ ಅರ್ಲಿ ಹಿಯರಿಂಗು?
ಡೇಟ್ ಬೇಕಲ್ಲಿ. ಡೇಟ್ ಬೇಕಲ್ಲಿ.
ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ ಅದೇ. ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆ ಅಷ್ಟೇ. ತೊಗೊಳ್ಳಿ. IA 1 of 24 is filed for early hearing, and on perusal of the order sheet, appeal is not admitted and only notice is ordered. And hence IA 1 of 24 is rejected. However, list this matter in the first week of January after winter vacation.
ಡೇಟ್ ಬೇಕಲ್ಲಿ.
ಡೇಟ್ ನಾನ್ ಫಿಕ್ಸ್ ಮಾಡಕ್ಕಲ್ಲ. ನೆಕ್ಸ್ಟ್ ರೋಸ್ಟರ್ ಯಾರು ಬರ್ತಾರಲ್ಲ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಏನಾರು ಬರ್ಲಿಲ್ಲ ಅಂತ. ಫಸ್ಟ್ ವೀಕ್ ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಿ. ನೆಕ್ಸ್ಟ್
7.
MD Chandrachud, 28 days issue notice on IA number 1 of 24 and also on main against the respondents.
12.
Iridar H. Delay of issue notice on IA number 2 of 23 and 1 of 23 and also on main.
30.
Issue notice on IA 1 of 23 and also on main.
40.
Next, issue notice on IA 1 of
Appearing
24
for the
and also
appellate.
IA number 1 of 23 and also on main.
50.
Issue notice on IA 1 and also on main
60.
against the respondents. 594 209 IA 1 of 20 delay of filing. Setting assignment notice hoಯ್ತಾ?
ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್
LRs of R1 B notice ಹೋಗಿದ್ಯಾ?
ಹೋಗಿದೆ ಸರ್. They also filed the ವಕಾಲತ್.
ಸರ್ವಿಸ್ ಆಯ್ತಾ? ಮಂಜುನಾಥ್ ಎಂ R1 B 1 and 2 ಅಂತ ಬೇರೆ ಏನಿದೆ ಅವನು ಸತ್ತೋಗವನೆ ಅಂತ ಕಾಣುತ್ತೆ ಮತ್ತೆ ಅವ್ರಿಗೆ ಮತ್ತೆ LRs.
ಇಲ್ಲ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ಸರ್.
ಇಲ್ಲ R1 B ಗೆ ಇಲ್ಲ ಸರ್. R1 B 1 and 2 ಮಂಜುನಾಥ್
ಎಲ್ಲರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆಯಲ್ಲ? Heard on A number 1 of 23 and there is a delay of 3,940 days in filing the application for bringing LRs of R1. And also A number 2 of 23 for setting aside abatement and A number 3 of 23 for bringing LRs of deceased R1 B. And notice is issued against the R1 B LRs have been served and represented through counsel and not filed any objections, and for the reasons stated in the accompanying application of affidavit, IAs are allowed and delay condoned. Abatement is set aside and permitted to bring the LRs on record as per A number 3. Appellant counsel is directed to amend the cast title and file amended cast title within 2 weeks. List this matter immediately after winter vacation for final hearing. Good. Final hearing.
70 Raj Balla.
RP.
I appeal for the respondents, my lord.
Delay ಬೇರೆ ಇದೆ.
Of course, review petition ಹಾಕಿದ್ದಾರೆ. There is no merit on the review, my lord. Of course, delay condonation ನಾನು object ಮಾಡೋದಿಲ್ಲ ಯಾವಾಗಲೂ.
ಆಯ್ತು.
But there is no merit in the review petition itself.
Senior Mrs. Getting surgery, my lords. So
ಅವ್ರ ಸರ್ಜರಿ ಮಾಡ್ಲಿ, ನೀವು ಓದ್ಕೊ ಬಂದ್ರ ಇಲ್ಲ ಅಯ್ಯನ? ಅಯ್ಯ 1 of 24 ಓದಿದೀರಾ?
file is with senior, my lords. File is with senior, my lords.
File is with your senior.
Yesterday he took the file, my lord. All the file.
ಬೆಳಗ್ಗೆ ಬರ್ಲಿಲ್ವಾ? ಹೋಗ್ಲಿ ಆ ಫೈಲ್ ಓದಿದ್ರಲ್ಲ ನೆನ್ನೆ ಆಫೀಸಲ್ಲಿ ಇದ್ದಾಗ ಫೈಲ್. ಎಷ್ಟು ದಿವಸ ಇದೆ ರೀ ಡಿಲೇ?
Office it was 6.
ಡಿಲೇ ಎಷ್ಟು ದಿವಸ ಇದೆ ರೀ?
164 days, my lords.
165.
164.
ಏನ್ ರೀಸನ್ ಏನು? ರೀಸನ್ ಏನು ಅಂದೆ? ಬಾಯ್ ಬಿಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ನಿಮ್ಮನ್ನ. ರೀಸನ್ ಏನ್ ಡಿಲೇಗೆ ಅಂದೆ? ಸೀನಿಯರ್ ಫೈಲ್ ತಗೊಂಡು ಹೋಗೋಕ್ಕಿಂತ ಮುಂಚೆ ನೀವು ಫೈಲ್ ಓದಿದ್ರ ಇಲ್ಲ?
No, my lords.
Third, heard the appellant counsel and also the counsel appearing for the respondent on A number 1 of 24 where there is a delay of 165 days in filing the review petition. And in paragraph number 2, an affidavit is sworn to that the RSA was disposed of on 24/8/23 and copy of the certified copy of judgment was received by the counsel on 31/8/23. And in the meanwhile, he left India to visit his daughter at Dubai. That is on 24/8/23 and he came back to India only on 2/12/23 and hence there is a delay. And the delay is concerned, the respondent counsel also not seriously opposes the same and having considered the reason assigned in the paragraph number 2 of the affidavit, delay of 165 days is condoned. List this matter for admission immediately after winter vacation. Delay condone ಆಗಿದೆ. Parted. S. Vishwanatha, Rakshita, DJ. Awaiting report from the Commissioner BBMP Bangalore. ಏನಾಯ್ತು ಇದು?
was present in the morning.
It's present
ಇದೇ
in the
case
office.
ಅಲ್ಲ?
The same matter. Lords, may kindly
Third,
order the
This
commissioner.
court
revenue-
directed Commissioner of BBMP be present before this court in view of not complying the order passed by this court earlier. And Commissioner submitted that he could not comply with the order and assistance of survey department is necessary. And hence directed the survey department concerned to assist the Commissioner of BBMP to survey the land and get the land surveyed and submit the report.
My lords, if I may make a mention, my lords.
And hence the Commissioner BBMP is directed to get it done the same within 2 weeks. ಹೆಂಗಿರೋ ರಜಾ ಇದೆ?
My lords, 4 weeks, my lords, because
Okay. 4 weeks ಹಾಕ್ಬೇಕು, ನಿಮ್ಗೆ ಯಾಕೆ
We will, ಅಲ್ಲ ಸ್ವಾಮಿ, we will inform the city survey commissioner and my lords.
ಮಾಡಿ, ಅದನ್ನೇನ್ ಮಾಡಕ್ಕೇನು, ಅದಕ್ಕೆ 4 weeks ಹಾಕ್ಬೇಕು.
3 weeks accommodation,
ಹಾ?
3 weeks accommodation.
ಆಯ್ತು,
3rd week of January will submit.
ನಾನೇ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀನಿ.
Please,
I will fix the date.
please,
Only you get the assistance of the survey department and get it done the job. That's
please,
all.
please.
That's what I communicated in the morning to the
Yes.
BBMP commissioner when he was present before the court. You get it done, that's all.
Please.
ಆಯ್ತಾ? ಏನಾಯ್ತು ಮೇಡಮ್? With the assistance of concerned department ಅಂತ ಹಾಕ್ಬಿಡಿ. Concerned department
City survey,
and that is city survey,
commissioner city survey.
commissioner ಇದಾರ ಅದಕ್ಕೆ?
Idar.
Commissioner city survey. And date is fixed for the inspection to be held on. ಯಾವತ್ತು ಹೇಳಿ? 2 ವಾರದಲ್ಲಿ
First week
ಅವ್ರು
of January.
ಅಷ್ಟರಲ್ಲಿ process ಮಾಡ್ಕೊಳ್ಳಿ.
6th ಆದ್ಮೇಲೆ, January 6th ಆದ್ಮೇಲೆ ಯಾವಾಗ?
ಏಕೆ?
My lords, ಅಲ್ಲಿವರೆಗೂ ಒಂದು ಸ್ವಲ್ಪ
January 6th ಅಲ್ವಾ ನಿಮ್ ಪ್ರಕಾರ 3 ವಾರ ಆಗೋಗ್ಬಿಡುತ್ತೆ, ಅವ್ರು ರಿಪೋರ್ಟ್ ಮಾಡದೆ ಅವಾಗ.
ಅದಾಗಿ ಇಮಿಡಿಯೇಟ್ 3-4 days ಅಲ್ಲಿ
ಹಾ?
ವಿಲ್ ಸಬ್ಮಿಟ್ ಮಾಡಿ ಸರ್. ಅದಾಗಿ 3-4 days ಗೆ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀವಿ sir.
ಏಕೆ ನೀವಿರಲ್ಲ ಅಂತನಾ?
ಹಂಗಿಲ್ಲ
6ನೇ
sir.
ತಾರೀಕುವರೆಗೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ.
Within the vacation ಅಲ್ಲಿ ಆದ್ರೆ ಇನ್ನೂ ಒಳ್ಳೆದು.
ಹಾ?
Within vacation ಅಲ್ಲಿ ಆದ್ರೆ ಒಳ್ಳೆದು. Least first second.
ಬಿಫೋರ್ ಮಾಡ್ರಿ ರೀ, 28, 29
But ಯಾವಾಗ್ಲಾದ್ರೂ office-
ರಿಪೋರ್ಟ್ ಆಮೇಲೆ ಕೊಡ್ಲಿ, 1 ವಾರ ಬಿಟ್ಟು.
ಎಷ್ಟು?
Lords,
ಅವ್ರಿಗೂ ರಿಪೋರ್ಟ್ ಕೊಡಕ್ ಬೇಕಲ್ಲ.
also,
ಹಾ.
my lords, sir, there is some.
ಈಗ now it is within your knowledge.
Yes, my lords.
Only the BBMP commissioner has to get the, in the mostly session ಇರೋದೇ 3 ದಿವಸ.
ಹೌದು.
ಜಾಸ್ತಿ ದಿವಸ ಇದೆಯಾ? ಇಲ್ಲ ಅಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು
ಈ ವಾರ
extend ಆಗ್ಬೋದು,
ಹೋಗುತ್ತೆ.
extend
ಹಾ.
ಆಗ್ಬೋದು ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
ಹಾ.
ಆ ಕಾರಣಕ್ಕಾಗಿ.
And to be held on 30th of
January.
ಇಲ್ಲ 31st ಆಗ್ತೀನಿ ಬೇಕಾದ್ರೆ, ನಿಮಗೆ ಟೈಮ್ ಬೇಕು ಅಂದ್ರೆ. 31st
30th
ಎಲ್ಲ
January is-
ನ್ಯೂ ಇಯರ್ ಸೆಲೆಬ್ರೇಷನ್ ಮಾಡಕ್ ಹೋಗ್ತೀರಿ ನೀವು, ಅದಕ್ಕೆ ಬೇಡ. 30th
ಇಲ್ಲ ಸ್ವಾಮಿ.
30th of December
30th of December.
at 10:30. And the respective appellant councils and also the parties and also the council for respondents ಜಾಸ್ತಿ ಇದಾರ?
Please.
Respondents and their respective councils also be present and assist the city survey commissioner, the concerned officials to survey the land without expecting any notice from the court.
Fine.
10:30 30ನೇ
Mop
ತಾರೀಕು
instruction has been
Huh?
filed. Mop instruction has been filed to the court, my lord.
ಹಾಕಿದ್ದೀರಾ?
Both have
That has
filed,
to
my
be
lord.
sent to
Both the councils have submits that they have filed the memo of instructions also, and hence registry is directed to send the memo of instructions to the concerned BBMP commissioner forthwith.
Please, my lords.
And
Report-
also application ಹಾಕಿದ್ದೀರಾ ಕಮಿಷನರ್ಗೆ ಏನಾರು? ಇಲ್ವಾ? ಬೈ ಸೋ ಮೋಟೋ ಮಾಡಿರೋದ?
Suo moto.
ಹಾಗಾದ್ರೆ ಬರೀ ಮೆಮೋ ಆಫ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಹೋದ್ರೆ ಸಾಕು.
Please, with
Huh.
documents also are produced, my lord. The JDA, the will.
ಹಾಕಿದ್ದೀರಾ ಏನಾರು?
ಹಾಕಿದೀವಿ. Memo of instruction
Along with.
along with I have
And if
filed.
any other documents are filed along with memo of instructions, send the same forthwith to the BBMP commissioner. File report on 7/1/2025.
7-1.
90. Purandara.
Great.
Obliged.
The petition, my lord, we are producing documents, kind of pass over.
Producing, ಆಯ್ತು ಪಾಸ್ ಓವರ್. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರಂತೆ ಡಾಕ್ಯುಮೆಂಟ್.
20.
ಸ್ವರೂಪ್ ಆನಂದ್ heard in part.
This is that,
Huh?
this is that maintenance issue. The respondent were directed to come back on the quantum of amount that they are willing to settle the matter. They had come up with a memo for calculation. We have filed our detailed objections, my lord. It's on record.
ಏನ್ರಿ ಅದು ಕೊಡ್ರಿ?
Lord, he has claimed maintenance from the year 2018. Our objection is that since the claim is barred by limitation, he's not
ಇದ್ರ
entitled.
ಮೇಂಟೆನೆನ್ಸ್
Yes,
ಲಿಫ್ಟ್
my lord.
ಲಿಫ್ಟ್.
Yes, my lord. On that.
ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್ ಹೇಳಿ ಲಿಫ್ಟ್ ಕೇಸ್.
Your lordship,
ನೀವು ಲಿಫ್ಟ್ ಕೇಸ್ ಅನ್ಬೇಕು, ಮೇಂಟೆನೆನ್ಸ್ ಅಂದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ. ಲಿಫ್ಟ್ ಮೇಂಟೆನೆನ್ಸ್ ಅಂತ ಹೇಳಿ.
no, it is not only lift, your lordship, it is entire apartment amenities that has been provided for them with this.
Provided to the earlier occupant.
And
Not
they are
to
also
the
enjoying
present.
now.
Huh?
They are also enjoying now.
ಯಾರು?
Tenant of the appellant.
ಯಾವ ಟೆನೆಂಟ್?
Our tenant
ಪರ್ಚೇಸ್ ಮಾಡಿರೋದೇ ಈಗಲ್ಲೇನ್ರಿ?
purchase made already tenant has been placed.
ಈಗ now he is enjoying.
So
You can file a petition for recovery for against the earlier person who
earlier,
has not paid the amount from 2018. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಎತ್ತಿಗೆ ಜ್ವರ ಬಂದ್ರೆ ಎತ್ತಿಗೆ ಬರೆ ಹಾಕ್ಬೇಕು, ಎಮ್ಮೆಗೆ ಬರೆ ಹಾಕಕ್ಕಾಗಲ್ಲ.
But ಏನಂದ್ರೆ ಅದು
ಹಾ.
it is not with any other owner, it is seized by the bank.
Anyhow, he has come forward to make the payment of arrears for a period from 2000. ಎಷ್ಟು ವರ್ಷದ ಕೊಡ್ತೀರಿ? 4 ವರ್ಷದ ಅಂತೇನಾ? ನೀವು ಪರ್ಚೇಸ್ ಮಾಡೋದು ಯಾವ ಇಯರ್ಲಿ?
2021, my lord, on
2021 ನೀವು ಪರ್ಚೇಸ್ ಮಾಡೋದು ಯಾವಾಗ?
2024, my lord.
24 ಅಲ್ಲಿ.
ಹೌದು sir.
ಯಾವಾಗಿಂದ ಕೊಡ್ತೀರಿ ನೀವು?
2021 ನಲ್ಲಿ ನಾವು
21 ಇಂದ ಕೊಡ್ತೀರಾ ಅಥವಾ 2020 ಇಂದಲೇ ಕೊಡ್ತೀರಾ?
2021 ಇಂದ ಸ್ವಾಮಿ. ಆದ್ರೆ
ಕೊಡ್ತೀರಿ.
we have on 12/12/2024
ಆಯ್ತು, ನಿಮ್ಮ ಪ್ರಕಾರ 3 ಲಕ್ಷ ಕಟ್ಟಿದಿರಿ.
ಕಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಬಾಕಿದೇನ್ ಡಿಫರೆನ್ಸ್ ಇದ್ದು you are going to pay the same.
My lord, according to my calculation, even if I calculate from 2021, I'm only entitled, I mean, I'm only liable to pay 1,47,480 rupees. I have paid 3 lakhs, my lord.
ಅದೇ ನಿಮ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಏನು ಅದ್ರಲ್ಲಿ?
My lord,
Measurements.
I have filed the.
They are disputing the measurement, but I have produced measurement dispute
Lord,
ಮಾಡ್ತಾರೆ,
as
which I
per
have
the
produced
sale
all the
deed-
documents.
As per the sale deed, how much measurement is there? For that much I am paying the maintenance. But between my measurement and his measurement, there is a difference of 400 to 500 square feet, my lord.
ಅದೇ ಹೇಗ್ ಬರ್ತದೆ?
ಅದು ಯಾಕಂದ್ರೆ
ಅದು ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಅವರೇ
Swami,
ಹೇಳ್ಬೇಕು.
all the invoices have been booked in the carpet area, total carpet area. So ಎಲ್ಲರಿಗೂ ಅದೇ ರೀತಿನೇ ಎಲ್ಲಾ ಫ್ಲಾಟ್ ಓನರ್ಸ್ಗೂ ಸೇಮ್ ಚಾರ್ಜ್ ಮಾಡ್ತಾ ಇದ್ವಿ. There is not separate.
ಕಾರ್ಪೆಟ್ ಏರಿಯಾದಲ್ಲಿ.
Carpet area. They are saying that exact that area.
ಏನಾಗುತ್ತೆ ಗೊತ್ತೇನ್ರಿ, ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಿಮ್ ಮನೆ ಒಳಗಡೆ ಇರೋ ಏರಿಯಾ ಮಾತ್ರ ಅಲ್ಲ, ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ನಿಮ್ ಅಕ್ಸೆಸ್ ಇರ್ತದಲ್ಲ ನಿಮ್ಮ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಗೆ ಹೋಗಕ್ಕೆ, ಅದ್ರದ್ದು ಮೇಂಟೆನೆನ್ಸ್ ಚಾರ್ಜ್ ಅವ್ರಿಗೆ ಬರ್ತದೆ. ನಿಮ್ದು ಮಾತ್ರ ಹಂಗಾಗಲ್ಲ.
ಮನೆ ಮುಂದೆ ಕ್ಲೀನ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಯಾರು ಮಾಡ್ತಾರ ಅದನ್ನ?
My lord, even then, my lord, at page number 116, that measurement shows, even then.
ಆಯ್ತ್ರಿ, ಅರ್ಲಿಯರ್ ನಿಮ್ಮ ಆಕ್ಯುಪೆಂಟ್ ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ಕೊಡ್ತಾ ಇದ್ದಿದ್ದು ಎಂಟೈರ್ ಎಕ್ಸ್ಟೆಂಟ್ ಗಲ್ವಾ? ಕಾರ್ಪೆಟ್ ಏರಿಯಾ ಏನಿದೆ ಅದಕ್ಕೂ ಕೊಡ್ತಾ
Maybe, my lord.
You cannot
ಇನ್ವಾಯ್ಸ್
dispute it.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ.
My lord, not only that.
ಇನ್ವಾಯ್ಸ್ ಏನಿದೆಯೋ ಫಸ್ಟ್ ಅದ್ರ ಪ್ರಕಾರ ಕೊಡಿ. ಎಷ್ಟಾಗುತ್ತೆ ಹೇಳಿ. 3-4 ವರ್ಷದ ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್ ಲೆಟ್ ದಮ್ ರಿಕವರ್ ಇಟ್ ಅಷ್ಟೇ.
My lord, I have already paid 3 lakhs. My contention.
3 lakhs ಆಯ್ತ್ರಿ, ಒಟ್ಟು ಟೋಟಲ್ ಎಷ್ಟಾಗುತ್ತೆ ಹೇಳ್ರಿ?
My lord, I have to seek instructions. Also, my lord, whatever it is, he is not even claimed the amount. Or court fee ಕಟ್ಟು ಮನೆ recovery.
ನೀವು ಮತ್ತೆ ಬೇಡ, ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಿಮ್ ಸೀನಿಯರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದಾರೆ, ನಾವು ರೆಡಿ ಟು 21ರಿಂದ ಕೊಡ್ತೀವಿ 24ರವರೆಗೆ ಅಂತ ಹೇಳಿದಾರೆ. ಡೋಂಟ್ ಆರ್ಗ್ಯೂ ಒನ್ಸ್ ಅಗೇನ್. ಆಯ್ತಾ? ಮ್ಯಾಟರ್ ವಾಸ್ ಹರ್ಡ್ ಇನ್ ಲೆಂತ್. ಆಮೇಲೆ ಅವ್ರಿಗೆ ನಾವ್ ಹೇಳಿದ್ವಿ 4 ವರ್ಷದ ಕೊಡ್ತಾರೆ, ಉಳಿದಿದ್ದನ್ನ ನೀವು ರಿಕವರಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ವಿ ಲಾಸ್ಟ್ ಟೈಮ್. ಅದಕ್ಕೆ ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ತಗೊಂಡ್ರು. ನಿಮ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಏನ್ ಹೇಳಿ, 4 years ಏನಿದೆ ಹೇಳಿ.
4 years ನಾನು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ನಾನು ರಿವೈಸ್ ಮಾಡಿ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ. ಯಾಕಂದ್ರೆ ಅದು ಮೆಜರ್ಮೆಂಟ್ ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಸಬ್ಮಿಟೆಡ್ ಇಸ್ 161.
ನೀವು ನೋಡ್ರಿ,
ಆಮೇಲೆ ಒಂದೇ
ನೀವು ಕೂಡ ಈಗ ಬರೀ ನಾನ್ ಮನೆ ಒಳಗಿರೋದ್ ಮಾತ್ರ ಕೊಡ್ತೀನಿ ಅಂತ ಅನ್ನಕ್ಕಾಗಲ್ಲ. ನಿಮ್ ಲಿಫ್ಟ್ ಹೋಗೋ ಸ್ಟೆಪ್ಸ್ ಗೆ ಯಾರು ಕ್ಲೀನಿಂಗ್ ಯಾರು ಕೊಡ್ತಾರೆ?
ಗಾರ್ಡನ್ ಇದೆ,
ಮತ್ತೆ ಇನ್ನೊಂದು
ಸ್ವಿಮ್ಮಿಂಗ್ ಪೂಲ್ ಇದೆ.
GST ಬರಲ್ಲ ಇದಕ್ಕೆ. there is a circular of this one. GST ಎಲ್ಲ ಹಾಕಿ ಕ್ಲೇಮ್ ಮಾಡಿ.
GST ನು ಎಲ್ಲರಿಗೂ 2018 ನಾನು ಇನ್ವಾಯ್ಸ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ. GST ಇನ್ವಾಯ್ಸ್. There is nothing for him special. I am putting it today.
ಎಲ್ಲಾರ್ಗೂ GST
only one submission.
ನಾನು ಹೇಳಿದಿನಲ್ಲ ಅದ್ ಮಾಡಿ.
ಒಂದೇ ಒಂದು submission, your lordship. See what the memo of calculation which I filed at page number 4. We have reduced the 1,61,000 as well as the 1 lakh the legal charges also. Almost 2,60,000 in the 2,70,000 taka. Out of 9,25,000 we reduced other than that also. So only the 4,56,000 is the difference as per that statement.
4,56,000 difference is
Difference ಇದೆ. ನಾನೇನ್ ಹೇಳ್ತೀನಿ, ಇನ್ನು
ನೀವು ಹೊಸದಾಗಿ ಕೊಂಡ್ಕೊಂಡ ಅಪಾರ್ಟ್ಮೆಂಟ್ ನವನಿಗೆ ಹಳೇದೆಲ್ಲ ಕೊಡು ಅಂತಂದ್ರೆ
ಇಲ್ಲ, ಹಂಗಿಲ್ಲ ಸ್ವಾಮಿ. ಅದೇ ಸೀಸ್ ಆಗಿರೋದ್ರಿಂದ ಅದು ಇನ್ವಾಯ್ಸ್ GST ಇರೋದ್ರಿಂದ
ಸೀಸ್ ಆಗಿದ್ದು ಯಾವ ವರ್ಷ? ನೀವ್ 2018 ಇಂದ 21 ವರ್ಗು ಸುಮ್ನೆ ಇದ್ರಿ?
ಇಲ್ಲ, ಅದು
ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಇಮಿಡಿಯೇಟ್ ಆಕ್ಷನ್ ತಗೋಬೇಕಿತ್ತು.
ನೋಟಿಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಕೊಂಡ್ರವನಿಗೆ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು, ಎತ್ತಿಗೆ ಜ್ವರ ಬಂದ್ರೆ ಎತ್ತಿಗೆ ಹಾಕ್ಬೇಕು, ಬರೇನಾ ಎಮ್ಮೆಗೆ ಬರೀ ಹಾಕಲ್ಲ.
ಲಾಸ್ಟ್ ಪಾಯಿಂಟ್ your lordship. ಈಗ ಏನಂದ್ರೆ
ಕೌನ್ಸಿಲ್
4 lakh
ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್ ನೀವು ರಿಕವರಿ ಮಾಡ್ಕೊಳ್ಳಿ. ಅರ್ಲಿಯರ್ ಯಾರು ಇದ್ನ ಅವ್ನ ಆಕ್ಯುಪೇಷನ್ ಅವನಿಗೆ.
only one small submission, your lordship. 4,56,000 is a difference.
ಓನ್ಲಿ 4,56,000 ಡಿಫರೆನ್ಸ್ ಅಂದ್ರೆ ಅವನಿಗೆ ಆಲ್ರೆಡಿ ಕಟ್ಟಿದ್ದಾರೆ 3 ಲಕ್ಷ.
ಅದು ಇಲ್ಲಿ ಕೋಟಿ ಬಂದ್ಮೇಲೆ ಸ್ವಾಮಿ 6 ತಿಂಗಳಿಗೆ ಎಂಜಾಯ್ಡ್ ದಟ್ ಎಕ್ಸ್ಪೈರ್ಡ್ ಆರ್ಡರ್.
ನಿಮ್ಮ ಪ್ರಕಾರ ಈಗ 4 years ಗೆ ಎಷ್ಟಾಗುತ್ತದ್ರಿ?
ಅದನ್ನ ಒಂಚೂರು ಕ್ಯಾಲ್ಕುಲೇಟ್
ಮಾಡಿ ಹಾಕಿ. ನೀವು ಹಾಕ್ರಿ. ನೀವು ನನಗೆ 400 square feet ಕಡಿಮೆ ಇದೆ ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್
ನಿಮ್ಗೊಂದು ಬೇರೆ ನ್ಯಾಯ ಅಲ್ಲ. ಎಲ್ಲಾರ್ಗು ಏನ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನ್ ಇರ್ತಾರೋ ಎಲ್ಲಾರ್ಗು ಒಂದೇ ನ್ಯಾಯ. There cannot be two yardstick. Both council seeks time to file fresh memo calculation and hence list this matter on 9/1.
10/1 please.
10/1 ಬೇಕಾಯ್ತು. 10/1
please.
Interim order may be extended.
Interim order granted earlier is extended till next date of hearing.
Please.
21.
I appear for the appellant in this case. But in fact, this matter was heard by your lordship. Lord, the claim of the Lord defendant is respondent in the extent of three-bit passage claiming that not it is the three-bit passage. Whereas the B schedule property is part of A schedule property. And my lord, in fact, my lord, the trial court has come to the conclusion that my lord, in
Why
the
it was adjourned in the last occasion after hearing the
Lord,
matter? First you make
my
some
learned friend
submission.
said that my lord, he has also filed,
One
he has
more,
also
one-
filed an appeal. Lord, as against the rejection of the IA filed.
Now the MFA 3646 of.
The MAC number ಕೊಟ್ಟಿ.
MFA number ತೋರಿಸ್ತಾ ಇದೆ.
MFA, my lord, MFA 4636, my lord.
4636.
Please, my lord.
ಅಲ್ಲ ಸರಿ ನಂಬರ್ ಕೊಟ್ಟವ್ರು ಯಾರು ಇದನ್ನ?
ಅವರೇ ಕೊಟ್ಟಿದ್ರು.
3646 ಅಂತ ಕೊಟ್ಟಿದ್ದೀರಿ, ನಾವು ಅದನ್ನೇ ಬರ್ದಿದೀವಿ.
ಇಲ್ಲ ಇಲ್ಲ.
ಅದಕ್ಕೆ ಅದು MEC ಫೈಲ್ ಅಂತ ಪುಟ್ ಅಪ್ ಮಾಡವ್ರೆ.
46.
ಈಗ ಯಾವ್ದು? Respondent counsel submits that other connected matter is MFA number
4636, my lord.
4636. ಆ ಕಡೆದ ಈ ಕಡೆಗೆ ಹೇಳಿದ್ರಾ? 4636 of 24 and hence registry is directed to put up the same and dealing this MFA number 3646 of 24. This matter immediately after winter
No,
vacation.
no, no, no,
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
my lord, your lordship kindly appreciate. No, he is suffered an my lord, order as against him. Not all that has sought injunction against him, my lord, B schedule property, which is part of A schedule property. Lord, now after having, my lord,
This matter day after tomorrow. Urgency ಇದೆಯಾ?
urgency, my lord, that is the reason from the
Day
time.
after tomorrow.
Time and again he sought time to, my lord, that is the reason why the matter. He has sought the time.
No, I'm not certain. Day after tomorrow, no problem.
ನೀವು ರಾಂಗ್ ನಂಬರ್
ತುಂಬಾ-
ಕೊಟ್ರಿ, ಇವತ್ತು ಕರೆಕ್ಟ್ ಫೈಲ್ ಇದ್ದಿರ ಡಿಸೈಡ್ ಮಾಡ್ಬೋದಿತ್ತಲ್ವಾ? ಆಯ್ತು, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. 3 ದಿವಸ ಬರೀ ಇದೇ ಕೆಲಸ ಮಾಡೋಣ.
Admission matter 22. ನಿಮ್ಮ ಹಿರೇಮಠ.
Your lordship in this matter, represent respondent, your lordship. May kindly have it after vacation.
Respondent counsel
I want to
says time,
speak-
appellant counsel present, list this matter after winter vacation.
Much obliged, your lordship.
ತಿಮ್ಮೇಗೌಡ ಏನು?
Therefore, respondent,
Should I appear for the-
senior brother is hospitalized. Kindly have it tomorrow.
Senior?
Senior brother is hospitalized.
Senior brother?
Hospitalized. Kindly have it tomorrow.
Urgency ಏನು?
Lord, urgency is that, Lord, we have requested for status quo to be maintained, Lord.
ನೋಡ್ರಿ ಇದೇನಿದೆ? ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಆಬ್ಸೆಂಟ್ ಅಲ್ರಿ?
Now.
ನಾ ಬರ್ಕೊ ಬಂದಿದ್ದೀನಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ. Now you are pressing for an interim order. Last time you are absent. Heard counsel for the appellant is absent. Learned counsel for respondent is present. If the learned counsel for the appellant does not appear on the next date of hearing, appeal will be dismissed for non-prosecution ಅಂತ ಬರ್ದಿದ್ದೀವಿ.
Very well.
ಈಗ
That is why,
urgent.
Lord, I am here.
List this matter immediately after winter vacation.
Lord, till then status quo.
No status quo. Dismissal ಇಟ್ಟಿದ್ವಿ. 22ರಿಂದ ಆರ್ಡರ್ ಅರ್ಜೆಂಟ್ ಇರಲ್ಲ. ಡಿಸ್ಮಿಸಲ್ ಗಿಟ್ಟಕ್ ಬಂದು ಅರ್ಜೆಂಟ್.
There is already a status quo. Lord, if your lordship will just permit me one.
ಸ್ಟೇಟಸ್ ಕೋ ಇದೆಯಾ? ಎಲ್ಲಿ?
No, in Supreme Court for the same property, my lord, there is already a status quo in operation.
ಸ್ಟೇಟಸ್ ಕೋ ಇದ್ರೆ ಮತ್ತೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್
No,
ಮಾಡ್ತಾರೆ.
after the order, my lord, after the impugned order. This order is passed in Supreme Court after the impugned order.
ಇದು ಯಾವ ಮ್ಯಾಟರ್ ಯಾವ್ದ್ರ ಮೇಲೆ ಹೋಗಿರೋದು ನೀವು?
Lord, if your lordship will give me 1 minute, my lord, to explain this. Lord, some third party, my lord, filed a suit, my lord, in respect of the same property. Lord, by deleting us from the array of parties, my lord, they entered into a compromise and, my lord, on that amongst themselves. We filed, my lord, RFA, my lord. That was dismissed. And after that, we filed a review. That was also dismissed. Against that, we filed the SLP, my lord. In that, my lord, there is a order for status quo to be maintained. And the
Pending
person who has
other-
taken the notice there is, my lord, the plaintiff in this
ಸೂಟ್
case.
ಪ್ರಾಪರ್ಟಿ ಅದು ಇದು ಒಂದೇನಾ?
Same property.
Kindly have it on tomorrow.
ಅಲ್ಲ ರೀ ಸ್ಟೇಟಸ್ ಕೋ ಇದೆಯಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಅದೇ ಆರ್ಡರ್ ಮೇಂಟೈನ್ ಮಾಡಿ ಅಷ್ಟೇ. ದಟ್ಸ್ ಆಲ್. RFA dismiss against that order they filed RP also dismissed, then they went to Supreme Court. Suit property ಅಂತ ಅಂತಾರೆ. Status quo will be maintained as regards to the suit property.
And the person who has taken notice there is the plaintiff, my lord, present plaintiff. If your lordship sees in that, so and so takes notice for respondent number 39 ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
Before the Supreme Court.
Before the Supreme Court.
He is the plaintiff.
He is the plaintiff.
Kindly have it on tomorrow.
ಮತ್ತೇನ್ ಹ್ಯಾಬಿಟ್ ರೀ ಸ್ಟೇಟಸ್ ಕೋ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಸ್ಟೇಟಸ್ ಕೋ ಮಾಡೋಣ ನೆಕ್ಸ್ಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್.
Yes.
ತಗೊಳ್ಳಿ.
Senior
The
brother.
counsel appearing for the appellant would submit that as against the order passed by
Kindly have it
in
on tomorrow.
RFF 956 of 2018 and 18, and also the order passed in the RP number 418 of 22, filed SLP before the Supreme Court in diary number 33526 of 2022, wherein pending further orders, the apex court passed an order status quo shall be maintained as regards the suit scheduled property. The counsel appearing for the appellant would contend that the suit scheduled property in the said SLP as well as in the present suit is one and the same. And in view of passing up an order to maintain the status quo, this court also can pass an order of status quo. And counsel also brought to notice of this court that the notice has been ordered against respond number 39.
39, who is accepted, ಅಲ್ಲಿ ಕೇವೇಟ್ ಅಲ್ಲಿ ಇದ್ರು.
39, who is a caveator and directed to accept the notice, and who is the same plaintiff before the trial court, and now he is the respondent in this appeal. And hence, in view of passing of status quo order by the apex court, it is appropriate to direct the parties to maintain status quo. List this matter immediately after winter vacation on 9/1/2025.
The other Milord respondents,
ಇದ್ರಲ್ಲ ನೋಟಿಸ್ ಏನೋ ಬಾಕಿಯವರಿಗೆಲ್ಲ
the notice to respondent 2 to 22 may be dispensed, Milord. They are co-defendants.
ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ. The appellant counsel files memo to dispense the notice against respond number
2 to 22.
2 to 22. ನೀವು ಎಷ್ಟನವ್ರಿಗೆ ಮತ್ತೆ?
Respondent number 1, the plaintiff.
And hence the notice against R2 to 22 is dispensed. ನೀವು R1 R1 ಅಷ್ಟೇ. ಬಾಕಿಯವರಿಗೆಲ್ಲ ಡಿಸ್ಮಿಸಲ್.
They are all co-defendants.
ಮೆಮೊ ಬರ್ದ್ ಕೊಡಿ.
Obliged.
24, Shantraj KG.
Medical documents filed by advocate for appellant. ಏನ್ರಿ ಇದು?
Appearing for the appellant, my lordship. The last occasion, this honorable court has given the direction to file the application for further documents. Under 41 rule 27.
ಆಫೀಸರ್ ಮಾಡಿದ್ರ ನಿಮ್ಗೆ ಇದನ್ನ?
Yes, I have served the copy.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದು?
The trial court has taken the contention.
ಇದ್ರ ಜೊತೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲಿದೆ? ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮೊದ್ಲೇ ಹಾಕಿದೀರಾ?
ಮೊದ್ಲೇ with memo
ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಿರಿ. ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅದು?
The trial court has taken the contention that the appellants did not file the medical treatment documents, my lordship. After the incident, the injured shifted to the government hospital of Tiptur, wherein they have given the first aid. Thereafter, they have advised to these appellants.
ಹೋಗೆಲ್ಲ ನೀವು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರೆಕಾರ್ಡ್ಸ್ ಹಾಕಿದಿರಲ್ರಿ ಇಲ್ಲಿ? ನಿಮ್ ಮೆಮೊ ಜೊತೆ FIR, ಡೆತ್ ಇಂಟಿಮೇಷನ್, ಇನ್ಕ್ವೆಸ್ಟ್ ಮಾಜರ್ ಇವೆಲ್ಲ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿಲ್ವಾ?
ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ವಿ.
ಹಾಕಿಲ್ಲ?
ಹಾಕಿದ್ವಿ ಎಲ್ಲ ಹಾಕಿದ್ವಿ ಸುಮ್ಮನೆ. ಇದು FIR
ಫೋಟೋ, ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್
ಇಲ್ಲ, ಅದು LCR ಮಿಕ್ಸ್ ಆಗಿರ್ಬೇಕು ಸುಮ್ಮನೆ ಮೋಸ್ಟ್ಲಿ. ಮೆಮೊ
ಜೊತೆ ಹಾಕಿದಿರಲ್ವಾ? ನಾನು ಅದಕ್ಕೆ ಹೇಳಿದೆ ಮೆಮೊ ಜೊತೆ ಹಾಕಕ್ ಬರಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಆರ್ಡರ್ 41 ರೂಲ್ 27.
ಅದು ಹಾಕಿದ್ವಿ. ಅದನ್ನ
ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ, ಏನಿದೆ?
ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಅದು ಹಾಕಿರ್ತಕ್ಕಂಥದ್ದು
ಇಲ್ಲಿದೆ ಇದ್ರಲ್ಲಿ. ಇದಲ್ಲದೆ ಬೇರೆ ರೆಕಾರ್ಡ್ಸ್ ಇರ್ಬೇಕು ನೋಡಿ ಮೇಡಮ್.
My learned friend has filed a memo first, then an application. This record should have been annexed with the application.
Annexed with the memo. I have filed the.
ಇವೆಲ್ಲ ಜೆರಾಕ್ಸ್ ಹಾಕಿದಿರಿ, ಒರಿಜಿನಲ್ ಹಾಕದ್ ಬೇಡೇನ್ರಿ?
ಒರಿಜಿನಲ್ ಹಾಕಿನಿ.
ಎಲ್ಲಿದೆ?
ಅಲ್ಲಿ ಬೇರೆ ಇರ್ಬೇಕು ಸಮ್ ಮಿಸ್ಪ್ಲೇಸ್.
ಇಲ್ಲೊಂದ್ ಸ್ವಲ್ಪ ಏನಾಯ್ತು ಅದ?
ಇದೆಲ್ಲ
ಇಲ್ಲೇ ನಾನು ಸ್ವಲ್ಪ ಹಾಕಿದ್ರೆ ಇಲ್ಲೊಂದ್ ಸ್ವಲ್ಪ ಅದ್ ಜೆರಾಕ್ಸ್ ಅವ್ರಿಗೆ ಕೊಟ್ರದ? ಇಲ್ಲೂ ಫಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ನೀವೇನ್ ಹಾಕಿದ್ರೆ ಜೆರಾಕ್ಸ್ ಇದೆಯಲ್ರಿ?
ಸೇಮ್
ಇದಿರ್ಬೇಕು. ಫಸ್ಟ್ ಒನ್ ಜೆರಾಕ್ಸ್, ಸೆಕೆಂಡ್ ಒನ್ ಕೂಡ ಏನೋ ಟ್ರಾನ್ಸ್ಲೇಟೆಡ್, ಸೆಕೆಂಡ್ ಒನ್ ಆಲ್ಸೋ ಡೆತ್ ಇಂಟಿಮೇಷನ್ ಜೆರಾಕ್ಸ್.
ಅದೆಲ್ಲ ಸಪರೇಟ್.
ಇನ್ ಯಾವ್ದಿದೆ ರೀ? ಮೆಮೋ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ 611 ಇನ್ನೊಂದ್ ಇದೆಯಾ? ಇಲ್ಲೇನ ಮತ್ತೇನೋ ಒರಿಜಿನಲ್ ಏನ್ ಹಾಕಿದಿರಿ? ಇಲ್ಲೂ ಬರೀ ಒಂದ್ ಮಾತ್ರ ಹಾಕಿದ್ರೆ ಅಷ್ಟೇ. ಈಗೇನು ಮೊದ್ಲು ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ರಿಲೈ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ವಾ? 27/8 ಯಾವ ಡೇಟ್ ಇದು ಏನೋ ಒಂದು ಪ್ರೋಗ್ರೆಸ್ ನೋಟ್ ಅಂತ ಇದೆ. ಅದೊಂದೇನಾ? ರೇಡಿಯಾಲಜಿ ಸಿಟಿ ಬ್ರೈನ್.
Yes, yes, my lordship. First, after the incident, the injured shifted to the Tiptur Government Hospital, wherein she has taken the first aid. On the advice of the doctor, the injured shifted to the Nimans, my lordship, wherein she admitted, and the appellants are a resident of Ranebennur, so that they are not able to look after the injured. Hence, they have requested to the hospital authority to give the direction to the nearest hospital, so that the injured shifted to the Bapuji Hospital of Davangere, wherein they have given some treatment. After that, the injured have the head injury, so that operation is essential, and shifted to the SSM hospital, wherein she died. For that, I have filed all the documents, medical documents, where the injured taken the treatment. But in the trial court, the trial court judge has taken the contention that this incident has not taken place, and moreover, this incident taken in the midnight of 1 to 1:30 on 26th, my lordship, because on 26/8/2015, the injured along with the applicant number 1 traveled from Ranebennur to Tiptur railway station, my lordship. In the midnight, after deboarding by the applicant number 1, while the deceased was deboarding, at that time train was moved. Due to that, she lost the balance and fell down by the train. At that juncture, the applicant number 1 could not pursue his bag and other things. So he shocked, and with the help of the passenger who are present at the platform, with their help, they have
Shifted the injured
by the 108 ambulance, the injured shifted to the hospital. My lordship. And afterwards, the investigation of respondent DRM report has filed, wherein they have taken the contention that no one eyewitnesses, and moreover, eyewitness has not made the witness as in the least, so my lordship. And moreover, he himself has given the evidence before the trial court, and fully crossed by the other side, and also taken the contention in the written statement. He has denying, but admittedly, the incident has been placed by the applicants on the basis of record. It reveals that incident happened. Unfortunately, the railway authority did not issue the message. That is the drawback of the case. So this investigation.
According to this incident was taken place where?
Tiptur railway station, my lordship.
Railway station itself.
Yes, ma'am. While deboarding the train, and moreover, in the year of 2015, this incident happened. This case had filed before the trial court in the year of 2017, my lordship. So after the receipt of the notice by the respondents, they have investigated how it is possible to ascertain without having any document by the railway, my lordship. And also kindly see the DRM report. How many?
What are the documents you have placed before the railway tribunal?
Yes, my lordship. All the investigation papers of the GRP, Government Railway Police, I have filed, and along with why the applicant number 1 deceased left the Ranebennur to the Tiptur. That is the prima facie evidence.
Document A1 ಯಾವ್ದ್ರಿ ಯಾರು ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಿದೆ FIR ನ?
FIR register.
Railway police.
Yes. Here.
ಆಯ್ತು, AW1 evidence ಹೋಗಿ first ನೋಡಿ.
Yes, my lord.
Who is AW1?
AW1 is the husband of deceased.
Deceased.
Yes.
My deceased wife and myself got the journey ticket from Ranebennur to Tiptur on 26/8/2005 for a visit to Tiptur due to the marriage of my brother's daughter at Tiptur, and we boarded the passenger train at general compartment at Ranebennur railway station at night. When the train had come to the Tiptur railway station, I alighted by the train while alighting my deceased wife of. It was moved, hence due to the lost balance, we fallen down from the train on 27/8/2000 early morning and sustained the severe head injury and other all over the body with the help of 4 passengers and who were presented at the railway station injured by husband shifted by the hospital ambulance to the Tiptur government hospital, wherein due to the severe head injury, doctor has advised The Niman's Hospital, Bangalore, on their advice, referred to individual to the said hospital wherein injured has gone to so scare. ನಿಮ್ಮ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲಿದೆ ಸರ್? ತಿಪ್ಟೂರ್
ಈಗ ಮೆಮೊ ಅಲಾಂಗ್ ವಿತ್ ತಾವು ನೋಡಿದ್ರಲ್ಲ ಸುಮ್ಮನೆ ಅದು
ತಿಪ್ಟೂರ್ ಹಾಸ್ಪಿಟಲ್ ಸಂಬಂಧ
ತಿಪ್ಟೂರ್ ಹಾಸ್ಪಿಟಲ್ ಫಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸುಮ್ಮನೆ
ಈಗ ಹಾಕಿರೋದು ಅದೇನಾ?
ಹೌದು ಸುಮ್ಮನೆ ಹೌದು. ಸಾರ್ವಜನಿಕ ಆಸ್ಪತ್ರೆ ತಿಪ್ಟೂರು ಪ್ರೋಗ್ರೆಸ್ ನೋಟ್ಸ್ ಅಂತ ಇದೆ ಅಲ್ಲ ಸುಮ್ಮನೆ.
ಸಾರ್ವಜನಿಕ ಆಸ್ಪತ್ರೆ ತಿಪ್ಟೂರು
ಅದು ಸೇಮ್ ಸುಮ್ಮನೆ 27/8/2000.
ಹಿಸ್ಟ್ರಿ ಏನ್ ಬರ್ದವ್ರ
ಹಿಸ್ಟ್ರಿ ಫಾಲ್ ಫ್ರಮ್ ಟ್ರೈನ್ ಫಾಲಿಂಗ್ ಡೌನ್ ಟ್ರೈನ್ ಬೈ ಟ್ರೈನ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಸುಮ್ಮನೆ ರೈಟ್ ಸೈಡ್ ಆ ಡೇಟ್ ಕೆಳಗಡೆ. ಅದು ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅದೇ ಸೇಮ್ ಡೇಟ್ 27ಗೆ ನ್ಯೂಮ್ಯಾನ್ಸಿಗೆ ಹಾಕಿ ಅಡ್ಮಿಟ್ ಆಗಿರ್ತಕ್ಕಂಥ ಸುಮ್ಮನೆ ರೆಸಿಪ್ಟ್ ಅಂತಂದೇಳಿ
ವೆರಿ ಸೇಮ್ ಡೇ
ಸೇಮ್ ಡೇಟ್
27/8 2:44 PM 27/8.
So wherein she has taken a treatment summary due to not able to look after the injured by applicants. So they have requested to the hospital authority kindly give the direction to the local hospital to take the treatment of the injured. On the request of the applicants, the injured shifted to the Davanagere. But for Bapuji Medical College Hospital, I have produced some documents. Memo. Original.
Bapuji Hospital records ನಿಮ್ಯಾನ್ಸಿಂದ ವಾಪಸ್ ಹೋದ್ಮೇಲೆ
ಅರ್ಲಿಯರ್ ಹಾಕಿದೆ ಸುಮ್ಮನೆ.
ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ನಿಮ್ದು ಎಷ್ಟು ವಾಟ್ ಆರ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಯು ಆರ್ ರಿಲೈಯಿಂಗ್ ಅಪಾನ್ ಅನ್ನೋದನ್ನ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಡೇನ್ರಿ ನೀವು.
ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್
ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ನೀವು ರಿಲೈ ಮಾಡ್ತಾ ಇದೀರಿ ಅನ್ನೋದನ್ನ ಹೇಳ್ಬೇಕಾ ಬೇಡ?
ಅದು
ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ
ಅರ್ಲಿಯರ್
ಹೋಗ್ಲಿ. ಎಲ್ಲಿದೆ ಬಾಪೂಜಿ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲಿದೆ?
ಇದೆ
ಮೊದ್ಲು ಹಾಕಿದ್ರಲ್ಲ ಅದ್ರಲ್ಲಾರು ಇದೆಯಾ?
ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿನೂ ನಮ್ಮ ಹತ್ರ ಇದೆ.
ಇದೆಲ್ಲ ಎಲೆಕ್ಷನ್ ID ಕಾರ್ಡ್ ಎಲ್ಲ ಈಗ ಯಾಕೆ ಹಾಕಿದ್ರಿ? ಅಲ್ಲಿ ಕೆಳಗಿನ ಫೋಟೋ
ಈಗ ಹಾಕಿಲ್ಲ ಸುಮ್ಮನೆ ಅದು ಟ್ರಯಲ್ ಕೊಡ್ಸ್ ಎಲ್ಲ ಯಾವ್ದು ಇದು ಅದು ಮಿಸ್ ಆಗೈತೆ ಸುಮ್ಮನೆ.
ನೀವೇ ಹಾಕಿರೋದಲ್ರಿ ಇದು? ನಮ್ಮ ಅಲಾಂಗ್ ವಿತ್ ಅರ್ಲಿಯರ್ ಕೂಡ ಹಾಕಿದಿರಲ್ಲ. ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು? ಇದು ರೈಲ್ವೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್
GRP ರೈಲ್ವೆ ಅರಸೀಕೆರೆ.
ಇದನ್ನ ಹಾಕಿಲ್ವ ನೀವು ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಕೆಳಗಿನ ಕೋರ್ಟ್ನಾಗ ಹಾಕಿರೋದು ಸುಮ್ಮನೆ. ಕೆಳಗಿನ ಕೋರ್ಟ್ನಾಗ ಹಾಕಿರೋದು
ಇಲ್ಲ ಹಾಕಿದಿರಲ್ರಿ. SS Institute of Medical Science and Research Center.
ಬಾಪೂಜಿಯಿಂದ ಮತ್ತೆ ಅಗೈನ್ ಶಿ ಶಿಫ್ಟೆಡ್ ಟು ದಿ SS.
ಇದೆಲ್ಲ ಜೆರಾಕ್ಸ್ ಇದಾವಲ್ರಿ?
ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಸುಮ್ಮನೆ. ಅದೇ ಟ್ರಯಲ್
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಫ್ ಫಾರೆನ್ಸಿಕ್ ಸೈನ್ಸ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಮೆಡಿಕಲ್ ರಿಸರ್ಚ್ ಸೆಂಟರ್ ದಾವಣಗೆರೆ ಎಲ್ಲ ಜೆರಾಕ್ಸ್.
ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಹಾಕಿದೆ ನೋಡಿ ಸುಮ್ಮನೆ.
ಅದೇ ಕೇಳಿದೆ.
ಈ ಕೊಟ್ಟು ಮೇಡಮ್
ರಿಮ್ಯಾಂಡ್ ಮಾಡಕ್ಕಾದ್ರೂ ಬೇಕಲ್ರಿ ಎಲ್ಲ ದಾಖಲೆಗಳು?
That may make one submission.
ಹೇಳಿ.
All those things are not required. I will read para number 12. Just that para number 12 will make it everything clear, my lord. Please, my lord. Your lordship may take in page 7 of
ಆಯ್ತು, ನಿಮ್ ರೈಲ್ವೆ ಟ್ರಿಬ್ಯುನಲ್ ರೈಲ್ವೆ ಪೊಲೀಸ್ ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ. ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ?
Therefore, my lord, I will leave it to your lordship after reading para number 12, my lord. None was examined on behalf of the respondent railway, but DRM report is filed and marked as exhibit R1. Please, my lord. As part of,
ರೈಲ್ವೆ ಅವರು ಬರೀ DRM ರಿಪೋರ್ಟ್ ಫೈಲ್ ಮಾಡೋದ್ ಬಿಟ್ರೆ ಇನ್ನೇನು ಮಾಡಲ್ಲ.
I'll come to that, my lord. As per DRM report, inquiry has been caused in the matter, which reveals that on 4/9/2015, so and so received email complaint from Vidyanagar police station, Davangere, that one lady by name so and so, age of so and so, was admitted and for treatment as a result of train accident on 28/8/2015. Has died during the treatment. Based on the complaint, CMIS was registered on so and so. During the treatment on 4/9/2015, party expired. Further inquired with SM TTR about the alleged incident dated 27/8/2016. SM replied that no such incident that occurred on 27/8/2015 at Tiptur station. There is no record available, journey ticket, message extract, SM, TTR to prove the passenger is a bona fide passenger or the said incident happened in TTR platform on 27/8. The inquiry further conducted that subject C, miss number so and so, subsequent UDR number so and so was registered by GRP so and so only on the information received from outside the railways, that is local police, and no information was given from the railways. It proves that the subject incident had not occurred in to railways. No eyewitness was cited to prove the deceased traveled in train or fallen from the train at TTR station on 27/8/2015. Only one mark, that is back of the head, and no wound marks on the dead body at SSMRI hospital. In the inquest report column number 7, it is mentioned that recovered only clothes and not valuable things. No railway ticket was surrendered before so and so at the time of investigation by her husband, who was said to be the co-passenger of the deceased. Deceased was not in possession of journey ticket. Hence, he could not be considered as the bona fide passenger. No driver or guard of any train reported or witnessed the incident. Alleged incident was told to as happened in the broad daylight, and that too in Tiptur railway station. If such is the case, someone would have pulled ICC. ICC means Mellard interchange communication by seeing incident, but no ICC was reported. During daytime at the time of train arrival or departure, SM on duty or pointsman will be available on PF to exchange the signals with the driver and the guard. Moreover, GRP staff also available round the clock, so and so. But no one noticed any such incident on 27/8/2015. The co-passenger of the deceased unable to give the details of the train from which the deceased had fallen down, and the co-passenger, that is the deceased husband, was not examined or not cited him as a witness in the case is highly suspicious. On perusal of PME report, it is noticed that the deceased died not by any railway accident, but mentioned the death of so and so due to complications of head injury. But his case was that at the time of boarding, he has pulled the chain, that is the deboarding. He has pulled the chain, but the report, there is no such pulling of the interchange, there is no such communication. Therefore, my lord, the tribunal has dismissed the claim.
Deceased husband examine ಮಾಡಿರೋದು ರೈಲ್ವೆ ಟ್ರಿಬ್ಯುನಲ್
neither the deceased husband nor
ಅಲ್ಲ ಅವನ್ನೇ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರೋದು ಅವನೇ he is the applicant AW1.
He is also not
the railway tribunal member writes like that. ನೋಡಿ, the co-passenger of the deceased unable to give the details of the train ante first sentence ಅಲ್ಲಿ, from which the deceased had fallen down, and co-passenger, that is deceased husband, was not examined or not cited him as a witness in this case is highly suspicious.
Yes.
But he only examined as AW1. Very first sentence, he is unable to give details. That means he has been examined. But later part again he says that fallen down and the husband was not examined.
That is the reason, my lord, I told I'll just read para number 12 and leave it to this court.
Paragraph number 12, what is the railway member written, that is against the material on record. ಎಲ್ಲಿದ್ದಾರೆ ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ರಿ ನೋಡೋಣ, ರೆಫರ್ ಮಾಡೋಣ ಬ್ಯಾಕ್.
ಆಲ್ರೆಡಿ 2015
ಇಲ್ಲಿ ಜೆರಾಕ್ಸ್ ಇದೆ, ಮಾತ್ರ ಏನಾದ್ರು ಒರಿಜಿನಲ್ ಏನಾದ್ರು ಕಾಪೀಸ್ ಇದ್ರೆ ಕೊಡಿ. ಇಲ್ಲ ಅಲ್ಲೇ ಹೋಗಿ ನೋಡೋಣ.
2015 again will take a year together.
With the time frame, my lord.
ಸರ್ ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ? ಏನ್ ಮಾಡ್ಬೇಕು? ನೀವು ಮೆಟೀರಿಯಲ್ ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದಕ್ಕೆ ಕೇಳಿದ್ರಿ. ಹೋಗಿ ರೈಲ್ವೆ ಏನಾದ್ರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿ ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರಲ್ಲ, ಅದನ್ನ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡಿದ್ರೇನ್ರಿ?
ಹೌದು, ಮಾರ್ಕ್ ಮಾಡಿ.
ಎಲ್ಲಿದೆ ಹೇಳಿ, ತೋರ್ಸಿ.
ಎಕ್ಸಿಬಿಟ್ ಐ ವುಡ್ ಲೈಕ್.
ಅದಕ್ಕೆ ಕೇಳಿದೆ, ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನ್ ಹಾಕಿದ್ರಿ ಅದನ್ನ ಗಮನಕ್ಕೆ ತಗೋಬರ್ರಿ. FIR ಯಾವತ್ತು ರಿಜಿಸ್ಟರ್ ಆಗಿದ್ದು? ಇನ್ಸಿಡೆಂಟ್ ಆನ್ 27/8 7 AM. Fallen from train and injured in Tiptur railway station.
FIR is on 4/9. FIR is on 4/9.
4/9 ಅಲ್ಲಿ ನೀವು FIR ಆಗಿರೋದು?
ಇಲ್ಲ, ಹಾಕಿದ್ದೀನಿ.
ಆಯ್ತಾ? ಒಂದು. ನೆಕ್ಸ್ಟ್
ಆಲ್ ದಿ ಎಕ್ಸಿಬಿಟ್ ಮಾರ್ಕ್.
ಅಲ್ಲ ರೀ, ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಇನ್ಸಿಡೆಂಟ್ ಆದ್ರೆ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಲ್ವಾ ರೈಲ್ವೆ ಅವರಿಗೆ?
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಅಟ್ ದಿ ಮಿಡ್ ನೈಟ್
ಬಿಟ್ಬಿಡ್ರಿ.
ಅಲ್ಲ
ಕೋರ್ಟ್ ಅಷ್ಟೇ.
1 ರಿಂದ 1:30 ಗಂಟೆ ಆಗಿರ್ತಕ್ಕಂಥ ಇನ್ಸಿಡೆಂಟ್ಸ್.
ಸರಿ ರೀ, 27ರಿಂದ 4ನೇ ತಾರೀಕುವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ
ಅದೇ 27ರಿಂದ 4ನೇವರೆಗೂ
ಸತ್ ಮೇಲೆ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ರಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಹೆಂಗಾಯ್ತು ಸ್ವಾಮಿ ಅಂದ್ರೆ, ದಿ ಪ್ಯಾಸೆಂಜರ್ ವಾಸ್ ಸಸ್ಟೈನ್ ದಿ ಇಂಜುರಿ. So due to that, the applicant number 1 and his relatives
death intimations.
Our first they carry the passenger to the Tiptur hospital. From there they have shifted to the Nimans hospital. Allinda Bapuji hospital ಈ ಹಾಸ್ಪಿಟಲ್ ಸುತ್ತರಿಯದೇ ಆಗಿದೆ.
ತಿಪ್ಟೂರ್ ಹಾಸ್ಪಿಟಲ್ಗೆ ಕರ್ಕೊಂಡು ಹೋದಾಗ
ಸರಿ,
ಇಟ್ ಇಸ್ ಎ ಕೇಸ್ ಆಫ್ ಫಾಲಿಂಗ್ ಫ್ರಮ್ ದಿ ರೈಲ್ ಅನ್ನೋದಕ್ಕೆ ಎಲ್ಲಿದೆ ದಾಖಲೆ?
ಅದೇ ಒರಿಜಿನಲ್ ತಿಪ್ಟೂರ್ ಆಲ್ರೆಡಿ
ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ, ಆ ರೀತಿ ನೀವ್ ಹೇಳಂಗಿಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ರೈಟ್ ಸೈಡ್ ಕ್ಲಿಯರ್ ನೋಡೋಣ, ಡೇಟ್ ನೋಡೋಣ ಸ್ವಾಮಿ. H/O ಅಂದ್ರೆ ಹಿಸ್ಟರಿ ಆಫ್ ಫಾಲನ್ ಡೌನ್ ಬೈ ದಿ ಟ್ರೈನ್ ಅಂತ ಕ್ಲಿಯರ್ ಕಟ್ ಆಗಿ ರೈಟ್ ಸೈಡ್ ನೋಡೋಣ.
ನೀವು ಓದ್ತಾ ಇರೋದು ಅಷ್ಟೇ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಕ್ಲಿಯರ್ ಕಟ್ ಆಗಿ ಅವ್ರು ಬರ್ದಿಲ್ಲ ಸ್ವಾಮಿ. ಡಾಕ್ಟರ್
ರೈಟಿಂಗ್ಸ್ ಹೋಗ್ಲಿ, ನಿಮಾನ್ಸ್ ಶಿಫ್ಟ್ ಮಾಡಿರಲ್ಲ, ನಿಮಾನ್ಸ್ ಎಲ್ಲಾರು ಹಿಸ್ಟ್ರಿ ಏನ್ ಕೊಟ್ಟಿದ್ರಿ ಹೇಳಿ?
ಅದೇ ಅದ್ರ ಜೊತೆ ಅಲಾಂಗ್ ವಿತ್ ನಿಮಾನ್ಸ್ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಸೇರಿಸ್ತಕ್ಕಂಥದ್ದು ಹಾಕಿದೆ ನೋಡಿ ಸ್ವಾಮಿ.
ಇವನ್ನೇ ಯಾರ ನೀವು ಕರ್ಸಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕು, ಈ ಆತರ್ನ. ಕರ್ತವ್ಯ ನಿರತ ವೈದ್ಯರು, ಸಾರ್ವಜನಿಕ ಆಸ್ಪತ್ರೆ ತಿಪ್ಟೂರು ಅಂತಿದೆಯಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನ್ ನಾನ್ ಓದುವಾಗ ನಿಮ್ಗೆ ಏನಾರು ಗೊತ್ತಾಯ್ತೇನ್ರಿ ಅದೇನ್ ಹಿಸ್ಟ್ರಿ ಅಂತ?
ಸರ್ ಶಾಂತಿಭೂಷ್,
ಅದೇನದು?
ಇದು ರೈಟ್ ಸೈಡ್
ಫೆಲ್ ಡೌನ್ ಅಂತನಾ ಏನದು?
ಫಾಲಿಂಗ್ ಡೌನ್ ಅಂತ ಸುಮ್ಮನೆ ರೈಟಿಂಗ್ಸ್ ಕರೆಕ್ಟ್ ಆಗಿ ಅದೇನ್ ಅಲ್ಲಿ ಅದರ
ಫಾಲಿಂಗ್ ಡೌನ್ ಅಂತೀರಿ, ಅಲ್ಲಿ ಎಲ್ಲಿ ಯಾವ್ದು ಇಲ್ವೇ ಇಲ್ಲ.
ಇಲ್ಲ ಫಾಲ್ ಎಫ್ ಕಾಣ್ತದ ನೋಡಿ ಸುಮ್ಮನೆ,
F ಒಂದಿದೆ ಅಷ್ಟೇ.
ಅದ ಮೆಡಿಕಲ್ ಡಾಕ್ಟರ್ಸ್ ಇಂಗ್ಲಿಷ್ ಹಂಗ್ ಸುಮ್ಮನೆ ಅದು ಬಿಗಿನಿಂಗ್ ಒಂದ್ ಲೆಟರ್ ಬರೀತಿರ್ತಾರ ಸುಮ್ಮನೆ.
The doctor would have asked what happened. The patient would have said he has fallen from the train.
ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇನೆ. 27/8 ಹಿಸ್ಟ್ರಿ ನನಗಂತೂ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ ನನಗೂ ಓದೋದು
ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ ದಾಖಲೆಗಳು. ಹಿಸ್ಟ್ರಿ ಫೆಲ್ ಡೌನ್ ಫ್ರಮ್ ಟ್ರೈನ್ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ, ಕಾಲಮ್ ನಂಬರ್ ದಾಖಲೆಗಳು ಇದೆಯಲ್ಲ.
ಅಲ್ಲೇ ನಾನು ಓದಿ ಹೇಳಿದ್ ಸ್ವಾಮಿ, ಆ ಡೇಟ್ ಕೆಳಗಡೆ ಅಂತಂದೇಳಿ.
ಅವತ್ತೇ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಆಸ್ಪತ್ರೆ ಕರ್ಕೊಂಡು.
ಹೌದು ಸ್ವಾಮಿ, 27, 26 ಜರ್ನಿ ಸ್ವಾಮಿ.
ನೀವು ಇಲ್ಲಿ ಇದು ಬಂದ್ರಲ್ಲ ಮೆಂಟಲ್ ಹೆಲ್ತ್ ಗೆ, ಅಲ್ಲೇನ್ ಹಿಸ್ಟ್ರಿ ಕೊಟ್ಟಿರಿ? ಬರೀ ನೀವು ಒಂದ್ ರಸೀಟ್ ಹಾಕಿದಿರಿ ಇಲ್ಲಿ.
ಅಲ್ಲ ಇಲ್ಲಿ
500 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ ಮಾತ್ರ ಹಾಕಿದಿರಿ, ರೆಕಾರ್ಡ್ ಇದೆ ಹಿಸ್ಟ್ರಿ.
ಅದ ನಿಮ್ಯಾನ್ಸಿಗೆ ಸ್ವಾಮಿ,
ಇವೆಲ್ಲ ನಿಮ್ಯಾನ್ಸ್ ಇಂದ ಸಮಾನ್ ಮಾಡ್ಬೇಕು ನೀವು.
ಅದೇ ನಿಮ್ಯಾನ್ಸ್ ಇಂದ ಮೂರು ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ. ಒಂದು 27ನೇ ತಾರೀಕು ಶಿಫ್ಟ್ ಆಗಿ ರೆಸಿಪ್ಟ್ ಅಂತ ಐತಿ ಸ್ವಾಮಿ. ನೆಕ್ಸ್ಟ್
27ಕ್ಕೆ
ರೇಡಿಯಾಲಜಿ ಅಂತ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಅಂತ ಒಂದ್
ಆಯ್ತು, ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಸಮಾನ್ ಮಾಡಿ ಅಷ್ಟೇ.
ಇಲ್ಲ
ಚಾರ್ಜ್ ಆಗಿರೋದು 28ಕ್ಕೆ, ಹೌದಾ?
ಅದು 28ರಿಂದ ಬಾಪೂಜಿ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಶಿಫ್ಟ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ಸ್ವಾಮಿ. ಅಲ್ಲಿಂದ
ಅವೆಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ನೀವು ಕಂಟಿನ್ಯೂಟಿ ಹಾಕ್ಬೇಕು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ನೋಡಿ.
ಎಲ್ಲ ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಸೀರೀಸ್ ಇದೆ ಸ್ವಾಮಿ. 27ರಿಂದ ಟಿಪ್ಟೂರ್ ಇದೆ ಸ್ವಾಮಿ, 28ರ ತನಕ ನಿಮ್ಯಾನ್ಸ್ ಇದೆ ಸ್ವಾಮಿ.
ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ನ ಕನ್ಸಿಡರ್ ಮಾಡೋದ್ ಬೇಡೇನ್ರಿ ಟ್ರಿಬ್ಯುನಲ್ ನವರು? ನಾನೇ ಡಿಸೈಡ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಇಲ್ಲಿ
ಅಂದ್ರೆ ಬೋನಾಫೈಡ್.
ನಿಮ್ಗೆ ಅರ್ಜೆಂಟ್ 2000 ಎಷ್ಟನೇ ಇದು
2000 ಇನ್ಸಿಡೆಂಟ್ ಟೇಕನ್ ಪ್ಲೇಸ್ ಇನ್ ದಿ ಇಯರ್ ಆಫ್ 2015 ಸ್ವಾಮಿ.
22 ಅಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಈ ಅಪೀಲ್ 22 ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಆಗಿರ್ತಕ್ಕಂಥ ರಿಜಿಸ್ಟರ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು 18 ಸ್ವಾಮಿ.
ಅಲ್ಲಿ ಏನೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ರಿ ಹೇಳ್ರಿ ಕೆಳಗಿನ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ?
ಅಲ್ಲೇ ಮೇಡಮ್ ಕೊಡಿ, ಎಕ್ಸಿಬಿಟ್
ಬಂದಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಹೇಳಿ. ಒಂದು FIR 8 ದಿವಸದ ಮೇಲೆ FIR ನಿಮ್ದು. ನೆಕ್ಸ್ಟ್
ಅಲ್ಲ ಡೆತ್ ಆದ್ಮೇಲೆ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ಸುಮ್ಮನೆ.
ಡೆತ್ ಆಗೋರ್ಗು ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಅಂತ ಕೇಳಿದೆ ನಾನು.
ಇಲ್ಲಿ ಇಂಜೂರ್ಡ್ ನೋಡ್ಕೊಳ್ಳೋ
ಸಂದರ್ಭದಲ್ಲಿ ಡೆತ್ ಇಂಟಿಮೇಷನ್ ಇಲ್ಲ. ಇನ್ಕ್ವೆಸ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಬರ್ಸಿದಿರಿ? ಚಿಕಿತ್ಸೆ ವೇಳೆ ಮೃತಪಟ್ಟು ರೈಲಿನಿಂದ ಬಿದ್ದು A3. ಎಸ್ ಡೈರಿ ಫೈನಲ್. ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಹಾಕಿ ಅಲ್ವಲ್ರಿ ನೀವು?
ಒನ್ ಸೆಕೆಂಡ್. ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಎಕ್ಸಿಬಿಟ್ A12
A12 ಇದೆಯಾ?
ಇದೆ sir. Exhibit
A10
A10 is the,
A11 ಸಾಕ್ಷಿದಾರರ ಹೇಳಿಕೆ.
A11 is the statement of applicant number 1. sir. A10 is the wedding card of the applicant number 1's
ಫೈನಲ್
brother's
ರಿಪೋರ್ಟ್ ಇದೆಯಲ್ಲ A12.
A12 ಎಲ್ಲ ಹಾಕಿದೀನಿ sir. Exhibit
ಏನ್ report
18
ಇದೆ
ಹಾಕಿದೀನಿ
ನೋಡಿ.
sir total.
Is the final report. Final report.
Your lordship may remand the matter with directors to dispose of the matter within 4 weeks, my lord, we'll do it. If that is the case, if my learned friend wants to produce any other documents, let him produce it, my lord.
Told. Heard the appellant counsel and also the counsel appearing to the respondent. This appeal is filed against the order of dismissal of claim application filed by the appellants on the ground that in order to prove the claim, no material is placed to substantiate that it was a untoward incident. And also railway tribunal comes to the conclusion that deceased was not in a possession of any journey ticket and hence could not be considered as a bona fide passenger. Apart from that, an observation is made that during the time at the time of train travel and departure, SM on duty or pointsman will be available on PF to exchange the signal with driver and guard. Moreover, GRP staff was also available round the clock and no intimation was given by the railway regarding the incident. And also an observation is made that the co-passenger of the deceased unable to give the details of the track from which the deceased had fallen down. And co-passenger, that is deceased husband, was not examined or not cited him as a witness in this case is highly suspicious. The counsel appearing to the appellant in support of his argument, he contend that immediately after the incident, the injured was taken to the Tiptur hospital and thereafter on the advice of the doctor shifted to the Nimans hospital and from Nimans hospital he was shifted to Papuji hospital and then he was shifted to SSM hospital Davangere and died on 4/9/2015.
Yes, sir.
2015. And now produced the additional documents before this court, that is the records of Tiptur hospital as well as Nimans hospital. And also produced other additional documents. The counsel appearing to the respondent also contend that in view of production of additional documents, matter may be remitted back to the railway tribunal to consider the same in a time bound period. And the appellant also may be permitted to produce any other additional documents before the trial court. Having heard the appellant counsel and also the counsel appearing to the appellant and respondent, and the very observation of railway tribunal that no train ticket was recovered from the deceased, and the fact that incident was taken place according to the claimant in the railway station, and no doubt railway employees have not given any intimation to the police, and only case has been registered based on the intimation of death after the death of the deceased on 4/9/2015. But the observation made by the railway tribunal that co-passenger of the deceased unable to give the details of the train from which the deceased had fallen down. That is, deceased husband was not examined. Is not correct, and he has been examined as AW1 before the trial court. And the very evidence of in the affidavit, chief evidence categorically stated that his wife named Srimati Channamma has died in the untoward incident of the case. But also categorically stated that he himself and his wife got the journey ticket from Ranebennur to Tiptur on 26/8/2015 for the Niman's document of receipt is also produced, and also on 28/4/2020 to 2015.
28.
Sorry, 28/8/2015, payments are made in favor of the Nimans. Except the receipt, no other documents are placed, having taken treatment at Nimans Hospital and thereafter also SSM and Bapuji Hospital. And in view of the progress notes of the Tiptur Hospital, wherein history is mentioned as fell down from train. And also the receipt of National Institute of Mental Health and Neuroscience. And also other documents of investigation report as well as scan report. And also the receipt for having made the payment on the next day. It is appropriate to remand the matter to the tribunal, and tribunal also to consider the additional documents and give an opportunity to the appellant to produce further evidence, and also the appellant is permitted to produce any other additional documents before the tribunal, and hence the very observation made by the tribunal is erroneous and need not necessary to produce the railway ticket, only to consider the material on record, and also final report of the police who have conducted the investigation also substantiate the contention of the appellant with regard to the immediately injured was taken to the Tiptur Hospital and thereafter shifted to the Nimans and then Bapuji Hospital and also the SSM Hospital. And all these materials are also found in the final report of the police, and hence in order to substantiate the claim that it is a case of the incident was taken place in the Tiptur railway station and immediately shifted to the Tiptur Hospital, and documents which have been produced as additional evidence before this court also can be considered before the tribunal, and also appellant is permitted to examine the doctor who noted the history of the additional documents before the tribunal.
With kind permission,
In
2015
and the same can
doctor
be-
ಸಿಗ್ತಾರಲ್ಲ.
And the same can be disposed of within time bound period of 3 months from the receipt of records. In view of the discussions made above, I pass the following order. Appeal is allowed, impugned order is set aside, matter is remitted back to the railway tribunal to consider the matter afresh, considering additional evidence and give an opportunity to both sides and dispose of the same within a time bound of period of 3 months.
My
The-
respectful submission, my
The
lordship.
appellant and respondents are directed to appear before the railway tribunal on 7th of January 2025.
My request is, your lordship, kindly give the direction to the tribunal to summon the doctor of Tiptur. Otherwise,
ಸರಿ, ನೀವ್ ಯಾವ ಸೀಮೆ ಲಾಯರ್ ರೀ ನೀವು ಅಲ್ಲೋಗಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೋಬೇಕು, ನಾನು ಇಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೇಕಂತ.
my lordship, earlier in previous cases, the tribunal did not allow the application also. Thereafter, I preferred the.
I made an observation, you can examine the doctor ಅಂತ. ಹೈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಬ್ಸರ್ವೇಷನ್ ಇದೆ, ಸಮನ್ ಮಾಡಿ ಅಂತ ಕೇಳಿ ಅಲ್ಲಿ ಹೋಗಿ. ಎಲ್ಲ ಇಲ್ಲೇ ಆಗ್ಬೇಕು ಹೈಕೋರ್ಟ್ ಅಲ್ಲೇ ನಿಮ್ಗೆ.
They were not following properly.
ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡಬೇಡಿ, ಇಲ್ಲಿ ಬನ್ನಿ. ಇದೇ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲೇ ಹಾಕಿದ್ರೆ ಮತ್ತೆ ಹಾಕಿ ರೌಂಡ್ ಹೊಡಿಬೇಕಿತ್ತು, ಇಲ್ಲಿಗೆ ಅಲ್ಲಿಗಲ್ಲ. ನೆಕ್ಸ್ಟ್
HP ಲೀಲಾಧರ್ ಕಲ್ಯಾಣ
ಏನ ಪ್ರಪೋಸಲ್ ಕೊಟ್ರಲ್ಲ, ಏನಾಯ್ತ್ರಿ? ಏನಾಯ್ತು ಪ್ರಪೋಸಲ್ ಏನಾಯ್ತು?
I have to get some instructions from party Melody.
ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೇ ಹೇಳಿದ್ರು.
ಹೌದು,
Senior ಬಂದಿದ್ರು. Senior ಬಂದಿದ್ರು.
He's not in
ಬಂದಿದ್ರಲ್ಲ.
not in station, hangagi
Senior
immediately after vacation.
Counsel for the appellant submits that he has given some proposal and the learned counsel for the respondent submits that he could not get in contact with the respondent and seeks 2 days time ಅಂತ ಕೇಳಿರಿ.
ಹೌದು ಸೌದು ಇಲ್ಲ, he is not in station, ಹಂಗಾಗಿ next immediately after vacation ಹಾಕೊಂಡ್ರೆ I will be.
ಏನ್ ಮ್ಯಾಟರ್ ಏನಿದು?
Matter, your lordship, what happened? I am the defendant here. He filed a suit for specific performance of agreement of sale. I produced a plain copy, your lordship, it starts from internal page 34, your lordship. And the internal page 24, your lordship. In respect of scheduled property.
ಏನಾಗಿದೆ?
INLE, he have filed an application not to alienate ಅಂತ.
ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಆಗಿದೆ.
ಹೌದು. What happened?
ಅಲೋ ಆಗಿದೆ.
ಅಲೋ ಆಗಿದೆ. ಅದ್ರ ಮೇಲೆ you have come up with the what is happened in this case, your lordship?
ಅಲ್ಲ ಆಯ್ತು, ಬರ್ಲಿ ಬಿಡಿ, ಅವ್ರೇನೋ 2 ದಿವಸದಲ್ಲಿ ಕೇಳ್ತಾರಂತಲ್ಲ. ಇಮಿಡಿಯೇಟ್ ಲಿಸ್ಟ್ ಮಾಡೋಣ. ಇಮಿಡಿಯೇಟ್ ಆಫ್ಟರ್ ಇಂಟರ್ವ್ಯೂ.
4-5 ಸಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕ್ಬೇಡಿ.
ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಪ್ರಪೋಸಲ್ ಅದಕ್ಕೆ 2 ದಿವಸ ಟೈಮ್ ಕೇಳಿದ್ರು, ಐ ಕುಡ್ ನಾಟ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಹಿಮ್ ಅಂತ ಕೊಟ್ವಿ. ಈಗಲೂ ಕೂಡ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಕ್ ಆಗಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕೇಳೋಣ ಅಂದ್ರೆ ಕೇಳೋಣ, ಇಲ್ಲ ಇನ್ನೊಂದು ಟೈಮ್ ಕೊಡಿ ಅವರಿಗೆ ಅಂದ್ರೆ
ಅದಕ್ಕೋಸ್ಕರ ಲಾಸ್ಟ್ ವೀಕ್ ಬಂದಾಗ ಅದನ್ನೇ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು
ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಅಗೇನ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಆನ್ ದ ಗ್ರೌಂಡ್ ದಟ್ ಕುಡ್ ನಾಟ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂಡ್ ಹೆನ್ಸ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್.
ಡೇಟ್ ಕೊಟ್ರೆ ಒಳ್ಳೇದು.
ಆಯ್ತು, ಆನ್ 10/1.
G Vikram
KV Narasimhan.
This is a case where the trial court in the final decree proceedings appointed a receiver to manage a bar and restaurant. Lord, suit for partition came to be filed.
Agency ಇದೆಯಾ ಏನ್ರಿ?
And we have, in fact, my learned friend
3
has
offers
given a
I have
proposal.
given to my learned friend.
Yesterday he has given me 3 proposals. I will consider it and my lord, we will take a
You
submission.
don't do any business, I'll pay you 1 lakh rupees. Give me the business is first offer that I have given, because they have been reporting less than 1 lakh of a profit per month. I'm saying, don't do anything, I will only take over and I'll pay you 1 lakh. Or otherwise, if at all he wants to continue, I'm saying, pay me 2 lakh rupees, because 2/3 is the share given to me in the preliminary decree. You pay me 2 lakh every month and you run the business. Or otherwise, let there be an internal bid between both of us. Whoever make the highest bid, let them take over the management.
Bid also you offered?
All the 3 offers, my lord, I have given.
Lord, we will consider his proposal because on the last date of hearing, my lord, there was another proposal which we had given, where he had agreed to receive 1,50,00,000 in full and final settlement of all his claims, because this is a suit for partition and there are various other properties also which are involved. My lord, we said that we will divide the property in the ratio 40:60, which is also recorded in the order sheet. Now, my lord, he has given an alternate proposal because there were certain complications in reporting the compromise, because he had also filed a cross objection with respect to certain properties. Therefore, my lord, please have this matter after vacation, my lord. We will consider the request that, the proposal given by my learned friend, and we will make our submissions.
Both counsel submits that.
Or I may also request that the matter be referred for mediation if my learned friend.
We have
because it
spent
has
so
already
much of a
been-
time, my lord, before the mediation. We have spent so much of time there.
Already.
Already.
Already
Only
it was-
thing that I sought for an indulgence is, we will divide the property in the ratio of 40:60, no difficulty. There is one cross objection that I have filed, only against the purchasers of certain items of property. All that I said is, I'll prosecute.
Who
them.
sold the property?
He also had entered into an
I have
agreement.
not
Signed the agreement.
Agreement was entered into by both of us. But my lord, contrary to the terms of the agreement, he alone executed the sale deed. That, my lord, the problem started there. So I said, only concerning those properties, I'll prosecute my claim. The rest of the properties, we will divide it, unalienated properties. That was somehow not acceptable to the others. They said, if at all-
once for all, ಅದಕ್ಕೆ hesitate ಮಾಡೋದು ಎಲ್ಲ ಬೇಡ. Once for all, you sit together and even sold the property also, consider it and decide.
And my lord, there is another suit that they have filed with respect to properties which have already been sold by both of us.
I am not a party.
There are three
So I
suits for
said I
partition
can't
with respect to
solve
the
that.
same family members. So I thought that instead of settling this matter piecemeal, this matter, I agree that the matter
Why?
was
That's
referred
why
for
once for all,
mediation.
once for all. You
ಅದೇ
can consider.
mediation ತಾವು ರೆಫರ್ ಮಾಡ್ತು ಅಂತಂದ್ರೆ
mediation already time spend ಮಾಡಿ
ಟೈಮ್ ಸ್ಪೆಂಡ್ ಮಾಡಿದೀವಿ, ಬಟ್ ಅದ್ರೊಳಗಡೆ ದಿ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಆಫ್ ಅನ್ ಅದರ್ ಸೂಟ್ filed by our mother was not brought to the notice of the either parties.
As far
Now
as
it
I am
appears that
concerned-
there is another suit for partition where a decree has been passed, set aside by the first appellate court, as against which a second appeal is pending before this court. So there are so many
I'm not a party.
ಅದರಿಂದ ಇವೆಲ್ಲ ಸೆಟ್ಲ್ ಆಗ್ತದ ಏನು ಮತ್ ಸುಮ್ನೆ
likely to be settled, my lord, likely to be settled.
ಏನ್
We
ಹೇಳ್ತೀವಿ
will give our best shot.
that there is an element of settlement and each of them have given proposal and they are going to consider the same and report in the first week of January. Or otherwise they are going to argue the matter on merits.
Yes.
Merits. And hence list this matter on 10-1.
Very well. In fact, my learned friend also says that it is better to argue the case than sit across for a settlement. Much obliged. Great.
27. Shrikant, yes.
Yeah, for the respondent.
For the plan, my lord.
A request for an adjournment in this matter, my lord.
ಏನ ಇದ್ರಲ್ಲೇನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಲ್ರಿ? Objection number 4 with regard to difference in order portion from order sheet in OS number 13-6 of 20 with that of impugned order at page number 38 is kept open as per court order. Already ಆಗಿದೆಯಾ? ಆಯ್ತು. Respondent counsel seeks time and counsel for the appellant says no objection. List this matter immediately after winter vacation.
Much obliged.
28.
Kamaleshwara Pujari,
Sorry.
Nagaraj S. Jain and Prasid Raju. ಏನ್ರಿ list of
For respondent.
PI additional documents filed by advocate for appellant. ಹೇಳಿ ಏನು ಅರ್ಜೆನ್ಸಿ ಏನು 23 ಮ್ಯಾಟರ್ ಅಲ್ಲ?
Yes, please.
After winter vacation?
The court had permitted me to put up the construction subject to outcome of the appeal. Last occasion, my lords, your lordships had observed because the appellant's counsel argued that there are so many documents which he had produced and the same has not been considered by the trial court. So your lordship suggested whether we can remand the matter so that the application could be considered afresh. But appellant wanted to argue the matter, including on those documents which is produced as additional documents. The matter requires to be heard. I'm ready in the matter.
My lord, kindly say, I'm appealing, this appeal is filed by the
Immediately
plaintiff.
after winter vacation ಕೊಡೋಣ ಡೇಟ್. ಯಾಕೆಂದ್ರೆ it takes time ಅಲ್ವಾ? ಈಗ ಅರ್ಜೆಂಟ್ ಇದು 3 ದಿವಸ ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಇರುತ್ತೆ. ತೋಡ್.
My lord, matter requires some detailed hearing.
ಅದನ್ನೇ ಹೇಳಿದ್ದು. It takes time ಅಲ್ವಾ? ತೋಡ್. Appellant counsel and counsel for respondent present. List this matter immediately after winter vacation on
Date may kindly fix, my lord.
8-1.
Lordships.
8-1-25. ಓಪನ್ ಆಗದೆ 6ಕ್ಕ?
6ಕ್ಕೆ.
ಆಯ್ತು 8ನೇ ತಾರೀಕು.
ಆಯ್ತು.
And both the matter.
ಆಯ್ತು ಬೋತ್. ಅದ್ರಲ್ಲಿ ಅವರೇ ಇದಾರ ಯಾರು? ಬೇರೆ ಇನ್ನೊಬ್ರು ಯಾರು?
ಅದ್ರಲ್ಲಿ ಯಾರೋ ಬೇರೆ
ಸಾಗರ್ ಬಿಬಿ ಅಂತಿದ್ದಾರೆ. ಅದು ಅಷ್ಟೇ ಸೇಮ್.
ಅದರಲ್ಲಿ
That's what I request from the court client to connect this matter to that, my lord.
connect
But
ಮಾಡ್ಲಿಕ್ಕೆ
one and the
lords,
same.
two different suits.
But one is the post.
Two different suits, two different orders.
Connect ಮಾಡೋದ್ ಬೇಡ.
Vendor and purchase.
ಎರಡೂ ದಿವಸ ಒಂದೇ ದಿವಸ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಅಷ್ಟೇ.
ಅವತ್ತಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
30 urgent.
30 ಆಲ್ರೆಡಿ ಅರ್ಜೆಂಟ್. ಯದುನಂದನ್ 31.
Plaintiff's appeal, my lord, suit for partition, declaration that sale deed dated 2002, my lord.
ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ ಅಥವಾ ಏನು?
Spoken to my learned friend, maybe refer to mediation, my lord, will explore.
That matter senior counsel has stated that if at all any settlement.
Mediation go ಬರ್ತೀರಾ? Both
I know.
counsel.
ಆಗ್ಬೋದು. ಆಗ್ಬೋದು.
Both counsel submit that matter may be referred to the mediation. And hence parties are directed to appear before the Bangalore Mediation Center on ಯಾವತ್ತು? ಯಾವತ್ತು ಹೋಗ್ತೀರಿ? Vacation on 7th of January 2025.
Please.
The registry is directed to send the concerned papers to the mediation center.
3 o'clock.
At 3 o'clock.
Please.
They have settled the sister's claim and settle ಮಾಡಿದ್ದಾರೆ.
I have asked my lord learned friend to use it.
The father has sold the property in the year 2000. After lapse of 24 years, your lordship, they are seeking the
Have
income.
not been given anything. Request ಮಾಡಿದೆ.
ನೋಡಿ ಅದೇನು ನೋಡಿ
Thank you.
ಮೀಡಿಯೇಷನ್ ಹೋಗೋದಕ್ಕಿಂತ ನೀವೇ people can sit together and make use of your.
So one round discussion has taken place. So they are asking huge. So that's the reason you are not ready.
ಸರಿ,
So
ಆಯ್ತು. ಆಯ್ತು ಅಲ್ಲೇ ಹೋಗಿ
Mediation ಅಲ್ಲಾದ್ರೆ ಸ್ವಲ್ಪ
ಆಯ್ತು
ಹೆಚ್ಚಿಗೆ ದಿವಸ
ಅಲ್ಲೇ ಹೋಗಿ ಆಯ್ತು
Please, you.
32 A1 and 2 allowed interfering and alienating.
Please, my lord, appearing for respondent one, my lord. For respondent one, we have filed wakalat today, my lord. And NOC wakalat, we have filed in respect to respondent 2 to respondent 4, my
2
lord.
to 4 ಆಲ್ರೆಡಿ ಯಾರು ಹಾಕಿದಾರಲ್ಲ ರವಿಶಂಕರ್ ಅಂತ
My lord, in NOC wakalat, my lord.
ಅದು ಹಾಕಿದಾರೆ ಯಾರು ಅಂದೆ ನೀವೇ ಹಾಕಿಲ್ಲ ವೇಣುಗೋಪಾಲ್ ಗೌಡ ಫಾರ್ R1 ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್
Not filed today, we have filed wakalat.
ಹಾಕಿದಿರಿ
ಇವತ್ತು ಹಾಕಿದೀವಿ, my lord.
R1 council submits that he has filed wakalat today for R1.
There is some urgency in the matter, my lord.
Urgency.
Today we have filed, my lord.
Last time ಅವ್ರು ಬಂದಿರ್ಲಿಲ್ಲ.
Last time
ಇವತ್ತು
ಸರ್ವೆ ಆಗಿಲ್ಲ.
ಅಯ್ಯ ಅಲವಾಗಿದೆ ಅಲ್ರಿ ಇಂಟರ್ಫಿಯರಿಂಗ್ ಅಂಡ್ ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಅಂತ ಇದೆ.
May request for a short pass over, my lord, at least pass over.
ಈ ಮೂರನೇ ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ ಮೇಡಮ್ 32.2 ನಲ್ಲಿ ಫರ್ನಿಶಿಂಗ್ ಆಫ್
32.1 and 2 services not happened with
ನಾನ್
respect to
ಕಂಪ್ಲೈಂಟ್ಸ್ ಆಫ್
R1.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಸೆಕೆಂಡ್ ಒನ್ ಅಲ್ಲಿ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿಲ್ಲ ಫೋರ್ತ್ ಟೈಮ್ ಅಂತಿದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ನಿಮಗೆ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿ ಡೈರೆಕ್ಷನ್ಸ್
ಅದು ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ, my lord. 32.2 ಎರಡರಲ್ಲೂ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ, my lord. With respect to R1.
ಮುತ್ತಣ್ಣ ಯಾರು ನೀವಾ ನಿಮ್ದ್ರಲ್ಲೂ ಏನು
5064 ಅಲ್ಲಿ MFA 5064 ಅಲ್ಲೇ you are the appellant bank. ಇದು
ಸರ್ವಿಸ್ ಆಗಿಲ್ವಲ್ಲ R1 R5 and R9 ಗೆ
respondent 5 and 9 ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಒಂದು
159 ಮೆಮೊ ಕೊಡ್ತೀರಾ ಕೊಡಿ
Only 5 and 9.
only 5.
One ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ, sir.
ಒನ್ ಆಗಿದೆಯಾ
One ಆಗಿಲ್ಲ. 32.1 and 32.2 ಅಲ್ಲಿ R1 ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ.
5 and 9 ಹಾಕಿರಿ ವಾಟ್ ಅಬೌಟ್ 1
actually he has also
The
filed.
appellant counsel in MFA 5064 of 24 filed memo to dispense the notice on number 5 and 9. And their dispensation will not cause any prejudice to the pending appeal. In view of the memo, notice against R5 and 9 dispensed at the risk of the appellant. What about R1?
R1 actually, he is the petitioner in the OS in civil court.
Plaintiff ಅವನು.
Plaintiff.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಆಗ್ಬೇಕಲ್ಲ
ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ.
ಅವರಿಂದಲೇ ಹೆಂಗ್ ಹಿಯರ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ
Service we are trying for that.
ಯಾಕೆ PF ಏನಾಗಿದೆ ಮೇಡಮ್ ಕಳ್ಸಿದ್ದವ್ರಿಗೆ ನೋಡಿ ಇವ್ರು ಈ ಬೇರೆ ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಇಲ್ವಾ R1 ಯಾರು ಅವ್ರು ಅದರಲ್ಲೂ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ಅವರಿಗೆ
32 ಆಗಿದೆ ಸ್ವಾಮಿ. 32 ಸರ್ವಿಸ್ ಆಗಿದೆ.
ಆಗಿದೆ
32.1 ಮತ್ತೆ 32.
R1 ಸರ್ವ್ಡ್ ಏನಂತ ಆಗಿದೆ
ಅಂಡರ್ಟೇಕನ್ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ
ಇವತ್ತು ಟುಡೇ ಫೈಲ್ಡ್ ವಕಾಲತ್ ಮೇಲೆ
ವೇಣುಗೋಪಾಲ್ ಅವರೇ ಆದ್ರೆ ಇದ್ರಲ್ಲೂ ತಗೊಳ್ರಿ ನೀವು
ಆಲ್ ದ
ಇದ್ರಲ್ಲೂ ತಗೊಳ್ರಿ
ನೋಟಿಸ್
ಸೇಮ್ ಅವರೇನಾ
ಅವರೇ ಸೇಮ್ ರೆಸ್ಪಾಂಡೆಂಟ್
ಕೌನ್ಸಿಲ್ ವೇಣುಗೋಪಾಲ ಗೌಡ ಟೇಕ್ಸ್ ನೋಟಿಸ್ ಫಾರ್ ವೇಣುಗೋಪಾಲ್ ಗೌಡ
ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರ ಹೆಸರು
ಟುಡೇ ಫೈಲ್ಡ್ ವಕಾಲತ್ ಮೇಲೆ ಟುಡೇ ಮಾರ್ನಿಂಗ್ ಐ ಫೈಲ್ಡ್
ಹೆಸರೇನ್ರಿ
ಗೌತಮ್ ಮಾದೇವಯ್ಯ
ವಕಾಲತ್ ಹಾಕಿರೋದು ನೀವು ಅವ್ರು ಹಾಕ್ಲಿಲ್ಲ ಹಾಗಾರೆ ಮೇಲ್ಗಡೆ ಆಗ್ಲೇ ಹಾಕಿ ಮೇಡಮ್ ಮಾದೇವ ವೇಣುಗೋಪಾಲ್ ಗೌಡ ಅಂತ ಬಂತಲ್ಲ ಅದಲ್ಲ ಗೌತಮ್
ಮಾದೇವಯ್ಯ ಫಾರ್ R1
ಫೈಲ್ಡ್ ವಕಾಲತ್ ಫಾರ್ R1 ಅಂತ ಹಾಕಿ
ಟುಡೇ NOC ವಕಾಲತ್ ಇಸ್ ಫೈಲ್ಡ್ ಫಾರ್
ಶೋ ದಿ ನೇಮ್ ಆಫ್ ದಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಇನ್ಯಾರಿಗೆ ಹಾಕಿದಿರಿ
NOC ವಕಾಲತ್ ಫಾರ್ R2 to R4 ಮೇಲೆ
ಅವ್ರಿಗೂ ನೀವೇ ಹಾಕಿದಿರಾ
ಟುಡೇ NOC ವಕಾಲತ್ ಫೈಲ್ಡ್ R1 to 4
ಹಂಗಾರೆ ಹೇಳಿ ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಆಲ್ಸೋ ಫೈಲ್ಡ್ NOC ವಕಾಲತ್ ಫಾರ್ R2 to 4.
Yes, ma'am.
And in view of the said submission, delete the name of the counsel Venugopal Gowda and also the counsel Ravi Shankar for R2 to 4. ಸರಿ ಆಯ್ತಲ್ಲ ಇದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ 56064 ಅಲ್ಲಿ ಗೌತಮ್ ಮಹಾದೇವನ್ undertakes to file ವಕಾಲತ್ ಫಾರ್ ಮಾದೇವಯ್ಯ files undertakes to file ವಕಾಲತ್ ಫಾರ್ R1 and if ವಕಾಲತ್ is filed, show the name of the counsel ಗೌತಮ್ ಮಹಾದೇವಯ್ಯ for R1 ಅಲ್ಲಿಗೆ ಇದ್ರ ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಆಯ್ತು 32.2. ವಾಟ್ ಅಬೌಟ್ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇನ್ ನಿಮ್ ಮ್ಯಾಟರ್ ಅಲ್ರಿ
ಅದರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದಕ್ಕೆ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಆರ್ಡರ್ ಕೇಳಿದ್ರು ಪರ್ಮಿಟೆಡ್ ಮೈನರ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಒಂದು ನೇಮ್ ಕರೆಕ್ಷನ್ ಮಾಡ್ಬೇಕು
4 ಸರಿ ಬಂದಿದೆಯಲ್ರಿ
ಇಲ್ಲ ಐ ವಿಲ್ ಕರೆಕ್ಟ್ ದಟ್ ಅದು
ಬಟ್ ಇದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗ್ಬೇಕಲ್ಲ ಇದ್ರಲ್ಲಿ ಯಾರು ಅವರು
ಅದರಲ್ಲೂ ಸೇಮ್ ಪಾರ್ಟೀಸ್ ಅದರಲ್ಲಿ ಇದು ಒಂದು ನಾಟ್ ಟು ಇಂಟರ್ಫಿಯರ್ ಇನ್ನೊಂದು ನಾಟ್ ಟು ಎಲಿಯನೇಟ್
ನೀವೇ ತಗೋಬೇಕಾಗ್ತರಿ
ಪ್ಲೀಸ್
ಗೌತಮ್ ಸ್ಕ್ರೂಟಿನಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಅಂತಲ್ಲ
ಅದೇ ಅದು ಮೈನರ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಜಸ್ಟ್ ಕಂಪ್ಲೈ, ಅದು ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್.
Appellant is directed to comply with office subsection forthwith.
Please, my lord.
In MFA number 4712 of 24, Counsel Gautam Mahadevaya undertakes to file wakalat for R. ಇದರಲ್ಲಿ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? R12?
R1 to 9 same.
ಇಲ್ಲ 1 to 9 ಅವ್ರು ಅಪಿಯರ್ ಆಗಲ್ಲ, ಅವ್ರು ಅಪಿಯರ್ ಆಗದೆ 1 to 4.
1 to 4 on.
ಯಾರ್ಯಾರು ಅವ್ರ ಹೆಸರು ಹೇಳಿ?
My lord, Shri KV Shivakumar, KV Srinivas, CR Manjula Devi and SM Saranya.
ನೋಡ್ರಿ ಯಾರ್ಯಾರು ಅವರು?
R1 to 4.
R1 to 4. ಈಗ ನೀವು ಮೆಮೊ ಹಾಕ್ಬೇಕಾ ಏನ್
ಉಳಿದವ್ರಿಗೆ
ಮಾಡ್ತೀರಿ?
ಮೆಮೊ
ಇಲ್ಲಿ
ಹಾಕ್ತೀನಿ.
ಯಾರಿಗೂ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ?
ಉಳಿದವ್ರಿಗೆ ಮೆಮೊ ಹಾಕ್ತೀನಿ.
ಮೆಮೊ ಹಾಕ್ತೀರಾ?
6 to 9 ಮೆಮೊ ಹಾಕ್ತೀನಿ. ಬಿಕಾಸ್ R1 is the plaintiff. Plaintiff ಒಬ್ಬರೇ ಅಪ್ಲಿಕೇಶನ್
ಹಾಕಿರೋದು
ಅಷ್ಟೇ.
Counsel for the appellant files memo to dispense the notice against R 5 to 9.
5 to 5, 6, 8 and 9 7 ಬ್ಯಾಂಕ್ ಇದಾವೆ ಇಲ್ಲ. ಅವ್ರೊಂದು ಅಪೀಲ್ ಹಾಕಿದಾವೆ. 7
TP ಮುತ್ತಣ್ಣ ಅವ್ರದಾ?
ಹೌದು ಹೌದು.
Bank
7
bank.
R7
ಹಾಗಾದ್ರೆ dispense the notice against 5 and 6,
8 and 9
and 8 and 9, and
Yes,
hence the same is dispensed against them. The counsel TP Muttanna undertakes to file wakalat for R7 in MFA 4712 of 24. ಸರಿ ಆಯ್ತಲ್ಲ?
Please, madam.
The appellant counsel is directed to serve the copy of the appeal memo counsel Gautam Mahadevaya and also the TP Muttanna in MFA number 4712 of 24.
Please,
The counsel for the appellant TP Muttanna is also directed to serve the copy of the appeal memo of MFA 5064 of 24 to Gautam Devaya. Sir, Mahadevaya. And hence this matter immediately after winter vacation.
My lord, can I have it? Can I request for it to be heard on Friday, my lord? Urgency ಇದೆ.
ಎಲ್ಲ
ಅಲ್ಲ, ಸಾಲ್ಫೇಸಿ ಆಕ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮುಗಿದೋಗುತ್ತೆ. ಸಾಲ್ಫೇಸಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತೇವೆ. ಸಾಲ್ಫೇಸಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ ದಿನಾನೇ ಬೆಳಿಗ್ಗೆ ಡಿಸ್ಮಿಸ್ ಆಗತ್ತೆ, ಮಧ್ಯಾಹ್ನ ಸೂಟ್ ಹಾಕ್ತೇವೆ. ಸೂಟ್ ಹಾಕಿ ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೇವೆ. DRT ಬಾರಿ
ನೋಡೋಣ 19th.
ಅಲ್ಲ 19th if it may be taken.
My lord, after vacation, man. Immediately.
19th ನಾಳೆ ಆಗುತ್ತಾಗಲ್ಲ 20th.
20th, my lord. Grateful, man.
33 Kavita D.
ಕೊಡಿ ತೊಳಿದ್ ನಮ್ಮ
For respond number 6 and 7, the matter may
Not
be
important,
passed on. Senior ಬರ್ತೀರ some pass over ಆಗ್ಬೋದು.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯೇನ್ರಿ?
ಹೌದು ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಸ್ಟೇಟಸ್ ಆರ್ಡರ್
ಪಾಸ್ ಓವರ್ ಮೊನ್ನೆ ಇತ್ತು, ಇವತ್ತಿಗೆ ಹಾಕ್ಸ್ಕೊಂಡ್ರೆ
ಹೌದು,
ಪಾಸ್ ಓವರ್.
34
ವರ್ಧಮಾನ್ ಗುಂಜಾಳ್ putting up of construction. Schedule A property. A1 was rejected. Rajgopal Naidu.
She has not measured the site at all.
Huh?
She has not measured the A and B schedule property or demarcated it. The entire effort is gone waste, my lord.
ಈಗ ಕೊಟ್ಟಿದಾರ ರಿಪೋರ್ಟ್?
Your lordship, if you take a look at
ಇದ್ರಲ್ಲಿ ಯಾರೋ ಕಮಿಷನರ್
Commissioner
ಅಪಾಯಿಂಟ್
report
ಆಗಿತ್ತು.
ಕೊಟ್ಟಿದ್ದಾರೆ, my lord.
ಯಾವಾಗ?
Objections filed ಮಾಡಿದ್ದೇನೆ ನೆನ್ನೆ ಆಫೀಸ್ ನಲ್ಲಿ.
Your lordship, commissioner report ಅಲ್ಲಿ he has mentioned ಅವ್ರು measure ಮಾಡಿದ entire site measure ಮಾಡಿದ್ದಾರೆ, on which the construction is put up on both property. There is a compounded property of the appellant that has come before the report. ಅದರಲ್ಲಿ 28 ಒಂದ್ ಕಡೆ ಇದೆ, 28 ಒಂದ್ ಕಡೆ ಇದೆ, ಇನ್ನೊಂದ್ ಕಡೆ 46 ಇದೆ.
ಕೊಡಿ ಮೇಡಮ್, ಅದೇನ್ ನೋಡೋಣ. ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಕೊಡಿ. ಇಲ್ಲ ಇದೆಯಾ? ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ರಾ?
Objection ಹಾಕಿ.
ಕಮಿಷನ್ ಕಾಪೀಸ್ ಕೊಡಿ ಅದರ್ ಸೈಡ್ಗೆ.
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಮೇಲ್
sent by mail.
ಮೇಲ್ ಒಂದು ಫಿಸಿಕಲ್ ಕಾಪಿ ಕೊಡಿ.
ಅದೇ. I sent it by mail also. ಎರಡು ಇದರಲ್ಲೇ ಇದೆ.
The court was pleased to appoint the court commissioner by its order dated 2/12/24 to inspect the spot and to measure the land of the appellant and the respondent. Fix the date and time and so on.
The specific direction was A and B schedule, A and B schedule should be marked 33 feet. Thereafter is their property. That exercise has not been done.
Yes, counsel.
The commissioner's duty was to ascertain, my lord. He says that there is no 5 feet passage. What has happened, my lord? Up to 28 feet I have built. 5 feet I have left behind for the bylaws. Which portion his vendors were using, who are also my vendors. That property is already conveyed to me. That is B schedule property. That portion has not been identified by her. Your lordship may kindly see the order passed by your lordships on 22/11/24, my lords. It's made very clear.
Order ಕೊಡ್ರಿ 28 ಅವ್ರೇನು ಆರ್ಡರ್ ರೆಫರ್ ಮಾಡ್ತಾರೆ. ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿರೋದು?
Time of, may I read, my lord? 22/11/24, my lords. May I read, my lord? The claim of the appellant is that he has purchased the property to the extent of 33 feet by 50 feet and submitted to give permissive position to use the vendor to utilize the eastern of 5 feet into 50 feet in order to access their land. The defense had made construction of said property which is shown as B schedule property, which is part of A schedule property. Learned counsel for the opinion of the respondent defense would submit no such existence of B schedule property, and defense is also not claiming any right in respect of 32 feet by 50 feet. So the commissioner ought to have measured my property up to 33 feet depth. She measures up to 28 feet depth and leaves it at that.
Your lord.
And that was my specific instructions, memo of instructions. She has not followed the instructions.
What is your measurement?
There was no, my measurement is whatever is the existing measurement, there's a plus or minus of only a feet, my lord. Because there's one passage here on the
Answering to my question, counsel, what is your measurement?
total measurement, my lord.
His claim is 33 by 50, 53. Oh, that.
Yes, my lord.
What is your measurement?
None measurement, whatever is here, my lord, it is correctly given in what as per the chat. Your lordship, the cross is there, my
You are
lord.
not answering to my question.
My lordship, on one side it is
You
20.
said that whatever the construction you made within your property.
Yes, my lord.
Then what is your measurement?
My lord, on one side it is, on the southern side it is 22.5 plus 12.5, that is 35 feet, my lord.
22.5
plus 12.5, 35 feet. Because there's a little cross of the property which is not there. And on this side it is 34 feet, which is it, and 35 feet is correct.
But sketch ಎಲ್ಲ ರೀತಿ ಇಲ್ವೇ ಇಲ್ವಲ್ಲ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ?
ಇದೆ my lord, ಅದು break ಆಗಿದೆ 22.5 and 12.5 ಇದೆ my lord. In the sketch in which we have signed.
If it is so mentioned, my lord,
that
I
is
am the
the-
prior
that is on the
purchaser. How
southern
will he
side.
get right over the property?
That is on the, there is no passage that we have left, my lord. They have never left a passage because attest ಮಾಡಿರೋ photos ಅಲ್ಲೂ they have completed the construction, they have put a compound, there is no passage left.
But your counsel, senior counsel made the submission that he is not claiming any right in respect of 33 by 53.
No, I am not claiming any
33
right.
by 50.
Yes, my lord.
And also not claiming any, his contention is that
The sale
portion
deed,
of
madam.
5 feet into 50 feet. In order to access their land, and now the defendants had made construction in this.
My lord, appellant's property is in the main road, my lord. There might have been road widening because it was a revenue piece of land which is agreed. And there was a, because even on the other side, our ಹೇಳೋದು 33 by 50. But our ಎರಡು side ಅಲ್ಲೂ the difference of measurement ಇದೆ. On this side, it is showing 28.5 feet. So there is a difference of 5 feet. On the other side, they tell it is 50 feet. There is a difference of 46 feet. ಎರಡು ಕಡೆ road ಹೋಗಿದೆ. Now, due to widening of road or whatever, they might have lost their road. And now they are, because of demolition, they are trying to claim it back. Before this, they have been in the purchase of property was in 1980. ಇವತ್ತಿನವರೆಗೂ ಯಾವುದೇ claim ಆಗಲಿ, trying to take back the portion, nothing has been put forth. There was existing construction on the said property till date. The owners were till the date of demolition, there was an existing structure and the same was being used by them and there were no claims. And new construction put up by the appellant herein, ಅವರು ಕಾಂಪೌಂಡ್ ಅನ್ನೇ ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲಿರೋ ಇನ್ನೊಂದು ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಕಾಂಪೌಂಡ್ ಅಂತ ಏನ್ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೋ, that is the compound existed since decades, my lord. It is not a new compound that has been put up. Auru allige 27 feet, 28 feet, they have closed their compound. There is nothing to show that there was a passage left. Iವಾಗ probably to cover their lacune because of BBMP ಏನಾರು notice ಕೊಟ್ಟಿದ್ದಾರೋ, they are telling that 5 feet there is a passage. If they have lost something to the road, to both sides there is a road, my lord,
What is
because
that,
Taraki main road is on one side, my lord, and
Purchase overlaps my 5 feet ಅಂತ ಹೇಳ್ತಾರೆ.
Karyappa road is on one
How
side.
can it be, my lord? His subsequent purchase already conveyed to me the 5 feet by 50 feet.
The earlier purchasers, they should have put up their claims before the earlier vendors. Nothing as such is put up. It has been
This sale deed in whose favor, counsel? You are referring this sale deed. This is
That's a defendant sale deed, my lord.
defendant sale deed. The two items are shown
yes, my lord.
in the property. One is 12.5, another is
22 and a half.
22.5. It comes around
35 feet, my lord.
total.
Yes, I mean, yes, my lord, 35 feet.
That is not even their case.
In the sketch, what is the area? All of them are present at the time of conducting the spot inspection.
It is the same, my lord.
No, my lord, the commissioner has failed to mention the depth of my site as 33 feet. She should have specifically mentioned that. And there, my lord, it will overlaps. He has purchased the land which is already conveyed to me. That has not been reflected.
Your lordship, the court commissioner
crux
could
of the
not have
matter.
measured anything when they have compounded their own property.
And he
There
admits
is
my
nothing left. There is no passage. There is no way out. Nothing left to show that there is a passage, my lord. Trying to contend something which is in my property when I have not made any encroachments. I have been living in the place that I have purchased. My sale deed and the measurements confers to it. If they have lost any land towards the road on both sides, they cannot come and claim on my land because the 50 feet is their property when it is measured by the council, because both councils were present. Now there is 46 feet only on one side. Now then they would be claiming 4 feet from the other side of the property also. If there is anything put forth before, it is not come put forth. They have made a new construction, my lord. It was only taken in 2017. They have taken a plan and they've made a new construction that was probably under 5 years ago. And they have completed the wall. There was no passage left. There is no exit left. It is inch to inch they have completed. There's nothing left even to move around. We found it difficult to take the measurements also. When that being so, probably BBMP's issued notice or something. So they have made this one to take back that 5 feet, which is not there. They have lost that probably to the road on both sides because there is Saraki main road. It has been widened for formation of even metro line has come up on the same road. When that has come up and this S Karyappa road, because 130 feet by 130 feet, we all both claim the title from the same property. When that being so, after due to the development of the city, portion of it might have been lost due to the developmental activity or the widening of the road or the footpath have been drawn up. When that happened, they might have lost land. They have sat on their own piece of land, not for here, for decades, my lord. There have been no differences, no claims, nothing is put forth that any communication between the two parties from 80 is put forth before this honorable court. Only when I demolish, my lord. Because I have even made a paper publication in my sale deed that I am purchasing so and so property. The purchase, it was put up for sale also for a long time. Then I have come and made the purchase. Now, only probably to cover their mistakes of not giving up any setbacks in their own property.
Now,
Or
may I make my submission, my lord?
They have tracked back to me telling that there is a
I
passage.
will clarify to the court what you have said is
Yes,
incorrect.
yes,
Your lord, may I kindly say, my lord. They were, his vendor and mine were common. My vendor has sold me 50 feet by 33 feet. That is certain, my lords.
Your sale deed.
I'll explain, my lord. Now,
Your sale deed
num sale deed.
dated.
Okay. The 1980 is the first sale deed, my lord, through to my vendor. 1980. I'll give the date also, my lord.
Then
1/2/1980. It was sold to my vendor's vendor. My father purchased the property, my grandfather, and my grandfather sold it to me 50 by.
all measures about 50 by 33.
My father gifted it to me, my lords, later. This is Nanda Kumar said it. my father purchased the property. Then he gifted it to me on 25th July 2002. Then, my lord, it was gifted to me. Thereafter, my lord, that means it was gifted to my mother. Sorry, it was gifted to my mother. And thereafter, my mother gifted it to me in the year 2009. And thereafter, my lord, I played a bidding. Thereafter, I went ahead with the construction, my lord. I've taken the building plan showing as 33 feet by 50 feet. Plan has been approved. What happened, my lord? The last 5 feet was to be left open. I have left it open. Since they were using as a passage, where at the end of 28 feet, I put a wall. And now I wanted to shift the wall back since they have sold the property up to 33 feet. At that time, they obstructed. That is the reason, my lord, my property should be measured up to the end of 33 feet, which he admits.
Now you have only 28.6. 28.6. Actual measurement is 28.6.
ಹೇಳ್ತೀನಿ 28.6 ಗೆ ತನಕ ನಾನು ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದ್ದೆ. ಆ ಬಿಲ್ಡಿಂಗ್ ಆದ್ಮೇಲೆ ಇನ್ನು 5 ಫೀಟ್ ಬೈಲಾ ಪ್ರಕಾರ ಖಾಲಿ ಬಿಟ್ಟಿದ್ದೆ. ಅಲ್ಲಿ ನಮ್ ವೆಂಡರ್ಸ್
then why you put the compound?
ಯಾಕೆ ಹೇಳ್ತೀನಿ, ಈ 5 ಫೀಟ್ ನಲ್ಲಿ ಉಳಿದಿದ್ದ ಜಾಗದಲ್ಲಿ ಅವರು ನಮ್ ವೆಂಡರ್ಸ್ ಕಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರು. ನಮ್ಗೆ ಇಲ್ಲಿ ಓಡಾಡಕ್ ಜಾಗ ಇಲ್ಲ, ಓಡಾಡಕ್ ಜಾಗ ಬಿಡಿ ನಮಗೆ ಅಂತ ಹೇಳಿದ್ರು. ನಾವು ಬಿಟ್ಟಿದ್ವಿ. ಅವ್ರು ಬಾರದ ಮೇಲೆ ನಾವು ಮತ್ತೆ 5 ಫೀಟ್ ನಮ್ದು ವಾಪಸ್ ತಗೊಳಕ್ ಹೋದಾಗ ದ ಡಿಸ್ಪ್ಯೂಟ್ ಸ್ಟಾರ್ಟೆಡ್.
But our measurement only except 1 feet. Except 1 feet. Actually, their total area is 35 feet. But land remaining is only 36 feet.
One ನಿಮಿಷ,
there is a shortage of 4 feet
one ನಿಮಿಷ
land.
They refer to my sale deed in their sale deed, and they say 33. They have seen my sale deed. So 50 feet by 33 feet ನಾನು purchase ಮಾಡಿದ ಮೇಲಿಂದ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಸ್ಟಾರ್ಟ್ ಆಗತ್ತೆ. If there is overlapping, my lord, he cannot claim over that, because if his vendors have sold him excess land, how am I to be affected, my lord? That is the dispute. That is the passage which I could have used the word vacant space left for bylaws. Because it was used I said that you use it. And when they sold it, they said they gave it back to me. I wanted to put up a compound wall, they obstructed. Because they say it is mentioned in their sale deed. If the excess land is sold to them,
now this area is vacant or there is a compound? Commissioner, as per the commissioner report, both the properties are having compound.
ಒಂದ್ ನಿಮಿಷ, ಯಾಕೆ ಕಟ್ಕೊಂಡ್ವಿ ಅಂದ್ರೆ ಅವ್ರ ಪ್ಯಾಸೇಜ್ ನೋಡ್ಬೇಕಾದ್ರೆ ನಮ್ ಬಿಲ್ಡಿಂಗ್ ಒಳಗೆ ಓಡಾಡಕೂಡದು ಅಂತ ಹೇಳಿ ನಾವಲ್ಲಿ ಹಾಕೊಂಡಿದ್ವಿ. ಅವ್ರು ಯಾವಾಗ ಮಾರಿದ್ರು ನಾವು ಮತ್ತೆ 33 feet ನಾವು ತಗೊಳಕ್ ಹೋದಾಗ they started a dispute. And that portion could not have been sold by his vendor because it's already sold to me. How can he claim on that land, my lord?
Remaining area is to youth actually. When the property was sold to him for respondent.
That because it was he has purchased.
When they have purchased the property.
What he purchased, he will have to satisfy. I don't know what was remaining. What was remaining, I don't know. This portion was sold to me, and the vendor has sold it to others also. Various persons out of 130 feet by 130 feet, she has sold it to others also. I was the first purchaser of 50 feet by 33. And remaining portion, if she has sold to anybody, it is not my problem how much was remaining. It is for them to ascertain before purchasing what was the title the owner had. Their vendor had, which they have not, the taxation they have not done. Now they are trying to claim on that 5 feet passage, which is already conveyed to me.
Told. But the appellant counsel and also the counsel appearing for the respondent. Present. The appellant filed.
Your lordship can say one more thing, my lord. Abutting that my 5 feet wall, which was a disputed B schedule property, my lord, he has put up construction. For a moment, my lord, that portion is a vacant land for has to be left as per bylaws. Even that he in his land he violates, comes into my land and builds it. There is no approved sanction plan produced. In fact, I placed this the municipal plan which was there when I sanctioned the plan. It clearly shows I have left 5 feet I have left. For my safety, my lord, on the hindsight, because they should not enter my property, I put up a compound wall. When they sold, I wanted to take back that 5 feet. They said, you can build your compound wall extending now. We went ahead, and at that time, this person obstructs.
But now already there is a construction. You can take the. You can seek, you can seek, you can seek only for.
Mandatory injunction ಕೇಳಿದೀನಿ. ಅದನ್ನು ರಿಮೂವ್ ಮಾಡ್ಬೇಕಂತ mandatory injunction ಕೇಳಿದೀನಿ. Immediately I have filed it.
Mandatory injunction, then court has to record the evidence.
No. We approached, please, my lord, we approached the municipal authorities and asked them to show the sanctioned plan. I have got the proof. They did not show any sanctioned plan. Corporation not given any sanctioned plan. High-handedly, he comes and builds on the 5 feet passage. Let him produce a sanctioned plan if he has
Shed
got.
is only put up
Because that
there.
would
To
show.
protect his property, shed ಹಾಕಿರೋದ್ ಬಿಟ್ರೆ, nothing more.
ನಿಮ್ plan ಕೊಡ್ರಿ.
Temporary construction.
Let him place the plan before the court. Your lordship may kindly see, even otherwise, 5 feet he had to leave as per bylaws vacant. Even if it was his plot, he builds that touching my property.
My lord, they have not left
And
anything
also
in their
encroaches on
property,
my
my lord.
property.
Because we have measured the portion, my lord.
And
They have not
it
left any
makes
bylaws, my lord.
50
According to
33
bylaws,
feet is
nothing
mine.
is constructed.
When the commissioner completely fails to measure up to 33 feet. That is a mistake that has happened in the
But there
commission report. I have made an application, appointed as second commissioner, my lord. Let the second commissioner, I have made the application for that also.
5 feet is non-existent, my lord. What is
The
not?
DDLR be appointed, my
not
lord. They are
measured.
competent persons.
Heard the appellant counsel and also the counsel appearing for the respondent. The suit is filed for the relief of.
Sort of rejection of the report, my lord.
Permanent injunction restraining the defendants from laying claim on 5 feet into 50 feet passage, running north to south 50 feet and width of 5 feet east to west. And also the other prayer is, in the event the court comes to the conclusion that defendant is in possession of the property as permissive user or such other right, grant a decree of mandatory injunction to deliver the possession to the plaintiff. And also declare that plaintiff is the absolute owner of the Schedule B property and grant a decree of injunction prohibiting the defendants from interfering or obstructing in putting up the compound wall towards the east of their property and grant such other relief as sought. And also in the meanwhile, sought for the temporary and in the inter-alia, meanwhile, in the inter-alia sought for an order of temporary injunction and order 13 rule 1 and 2. Restraining the defendants, their staff, agents, henchmen, legal heirs, representatives, assignees, laborers, or any person claiming through or under him from trespassing or putting up any construction on the suit Schedule B property till disposal of the suit. It is the case of the plaintiff also that he is the absolute owner in possession of the suitable property, absolute owner of the property measuring east to west 33 feet, north to south 50 feet, 153.31 square meters, and the same was gifted to her by Srimati R.N. Sujata, R.N. Jayalalitha, R.N. Sudha, and R.N. Chetana, who are the siblings of the plaintiff's mother, Srimati Devi Karni, under gift deed dated 12/6/2009. It is also the case that a scheduled property measures east to west 33 feet and north to south 50 feet. And originally the said property was owned by one Ramaya Reddy, and after his death, his two wives, namely Yellamma and Papamma, and their children sold the A scheduled property to one Mr. M.E. Nandakumar, son of Venkatramaya, with sale deed dated 9/5/1979. Subsequent to the sale deed, notification deed was executed. Rectification deed was executed on 1/2/1980 by the vendors to correct the schedule of the property, and said M.E. Nandakumar sold the entire scheduled property to the mother of the plaintiff, Srimati Devika Rani. Subsequently, Devika Rani gifted the property in favor of her siblings. Under the gift deed dated 25/7/2002, the plaintiff and her predecessors in the interest had got the municipal kata mutated in their names, and they are paying the property taxes. And the plaintiff obtained the sanction plan from BBMP and put up construction in the A scheduled property. However, it is contended that towards the eastern side, the plaintiff's vendors had retained some portion of the land, And later, the plaintiff and plaintiff's mother, at the request of the vendor's family, had permitted them to use 5 feet of their property towards the western boundary. At that time, there was no construction on the A schedule property, and this was purely an understanding between the plaintiffs and their predecessors in interest. And therefore, plaintiff had given permission to use the passage as there was haphazard construction. It is also contended that when the plaintiff put up the construction for security reasons, she had erected a wall at the end of 27 feet and vacant space measuring 5 feet into 50 feet. And the same was kept open, and the title and possession remains with the plaintiff. It is also contended that legal heirs of Ramaya have sold the property to the defendants, and the defendants have now demolished the entire structure and are preparing to put up a new building on the property purchased by them on B schedule property shown in the plain schedule. And in this regard, when the plaintiff objected, the defendants are asserting their right over the passage measuring 5 feet into 50 feet. And the defendants have originally denied the right of the plaintiff and intimated that passage showing ABCD measuring 5 feet into 50 feet is conveyed to them by their vendors. And therefore, the plaintiffs were prevented from putting up a compound wall at the end of 33 feet. The defendants have also warned the plaintiff if they continue the same and hence filed the suit. The defendants appeared and filed a written statement and adopted the same by defendant number 1, and defendant number 2 has filed separate objections to A number 1, and defendant number 1 also adopted the same. In the written statement, it is contended that Ramaya Reddy was the owner of 2 acres 18 kuntas in survey number 51/2 of Saraki village, and he sold it to Dodda Hanumappa Reddy on 27/10/1947, and subsequently Ramaya Reddy brought back the said land through registered sale deed dated 3/10/1955, and out of the land held by him, he sold 20 kuntas to Sonnappa, and out of the remaining area, he farmed the layout and sold individual sites. However, Ramaya retained site measuring 130 into 130 feet, and he got the site converted for residential purpose. The Panchayat authorities have assigned the site number. A portion of the site was sold to R. Jairam on 8/12/1967, and the remaining site has been dealt with by Ramaya Reddy. Said Ramaya Reddy passed away, and his 2 wives and children have conveyed portion to Sri Nandakumar, with sale deed dated 9/5/1979, and the remaining portion has been released by way of a registered release deed dated 11/2/22 by the LRs of Ramaya Reddy. And these defendants have purchased item number 1 and 2 of these properties from Srimati Rukmini, and subsequently the defendants 1 and 2 got their names mutated in their revenue records. The defendants have denied the contention of the plaintiff. The passage referred to by the plaintiff has not been shown in the sale deed dated 9/5/1980, 25/7/2002, 12/6/2009, and hence rejected the claim of the plaintiff. The trial court, having heard the appellant counsel and also the counsel appearing for the respondent, formulated the point and comes to the conclusion that the plaintiff has not made out the prima facie case. While answering the point for consideration, taken note of the assertion of the plaintiff that with regard to the alleged passage measuring 5 feet into 50 feet, but contend that there is no document produced to substantiate the claim of the plaintiff regarding existence of the passage or to indicate that the said portion is part and parcel of a scheduled property. It is also discussed that there is no reference to the passage in any of the documents produced by the plaintiff. Hence, the right claimed by the plaintiff over the B scheduled property is a disputed issue, which requires full-fledged trial. Mere production of such would not establish the right of the parties in the absence of any corroborative material, and hence comes to the conclusion that there is no any prima facie material to indicate the existence of right of plaintiff over B scheduled property. The proprietary right and entitlement of the plaintiff in the B scheduled property is the subject matter of suit, and hence rejected the application. Being agreed by the said order, the present appeal is filed. The main contention of the counsel appearing for the appellant that the trial court committed an error in making an observation that Schedule B property is a disputed issue which requires a full-fledged trial. The trial court failed to exercise the jurisdiction vested in her by not granting the injunction, when the title deeds were not denied, and has failed to note that Schedule B passage was part and parcel of Schedule A property. The council also would vehemently contend that appellant property measures east to west 33 feet and north to south 50 feet out of the larger area measuring 130 feet into 130 feet. When the appellant predecessors in title and the original vendor Ramaya has sold the Schedule A property, they could not have conveyed more than the respondents. The Schedule B property is a part of Schedule A property in which she had allowed out of gratis to her vendors legal heirs, since they had put up construction haphazardly and the same having been demolished, the respondents cannot lay claim on the Schedule B property. And even according to the sale deed under which they have purchased, this 5 feet has not been conveyed to them. Thereby the learned judge has misread the material placed on record and erroneously comes to the conclusion that plaintiff has not made out any prima facie case without looking into the area of sale deed. That is 53 into 50 feet, 33 into 50 feet. And it requires interference. For counter, the council appearing to the respondent would vehemently contend that they have constructed the building within their area and they have purchased the property, and within the said area only they have constructed, and they have never made any attempt to encroach upon the land of the plaintiff, and also made the submission that they are not going to claim any inch of their land, and only their construction is within the property which they have purchased. When both councils have argued the matter and dispute is with regard to the 5 feet into 30 feet, this court appointed the court commissioner, since the very claim of the appellant plaintiff is that there was a passage. There is a passage. And on the other hand, counsel appearing for the respondent also submit that what they have put up the construction that is within their properties. And hence commissioner is appointed. This court also, while appointing the commissioner, also made an observation in the order. Order sheet idea, madam, nim kade? Order sheet. Nam court order sheet. Elide. One kade. With order dated 22/11/24. Also taken note of the appellant claims that he had purchased the property to the extent of 33 feet into 50 feet. And he gave permissive possession to his vendor to utilize the eastern portion of 5 feet into 50 feet in order to access their land. And now defendants had made construction in the said property, which is shown in the B schedule property, which is part and parcel of A schedule property. The counsel appearing to the respondent also submits that no such existence of B schedule property, and defendants are also not claiming any right in respect of A schedule property to the extent of 33 feet into 50 feet. Now the commissioner has filed a report before this court, and the commissioner report measurement discloses the property to the extent of the respondent 36 feet and 60 feet, and also the property of the appellant plaintiff 28.6 and 46 feet. And having perused this also, the area of 33 into 50 is not found in the commissioner report, and document of the appellant plaintiff discloses the 33 feet into 50 feet. And the same is also not disputed by the respondent, and respondent counsel also made the submission during the course of the argument that they are not claiming any right in respect of 30 to 50 feet. And hence it's very clear that there is a shortfall of land of appellant, not not in existence to the extent of 33 by 50 feet. And apart from that, survey sketch and apart from that, rough sketch is also prepared at the instance of the parties, and all the parties have signed the rough sketch also, wherein also the measurement is 36 feet and 60 feet in respect of the respondent is concerned. And the total area of the respondent purchased is 12.5 into 22.5.
Plus.
And also 35, it comes to 35, Allah?
Yes, my lord, 12.5 plus 22.5.
30, it comes to 35 feet. And also the respondent claims that their measurement is also in accordance with the sale deed. And hence there is a clear shortfall. And also suit is filed for the relief of declaration to declare that the plaintiff is the owner of the A schedule property. And also sought for the mandatory injunction in respect of B schedule property, which is shown in the schedule sketch, wherein he claims that there was a 5 feet into 50 feet passage was given at the request of the vendor of the plaintiff. And I have already pointed out that there is a shortfall of land not available to that extent as claimed by both of them. But in terms of the sketch prepared by the commissioner, the respondent is in extent of 1 feet other than his claim. And also counsel appearing with the appellant would contend that while getting the sale deed, the respondent ought not to have got the sale deed to the extent of 50 feet into 5 feet of land, which was already sold in favor of the appellant. And when the relief is sought for declaration as well as mandatory injunction, and also the temporary injunction sought before the trial court is restraining the defendants from trespassing or putting up of any construction. And when the suit is filed for the relief of declaration as well as mandatory injunction is sought, even if the court comes to the conclusion that there is an already encroachment.
Declaration short, my lord.
Declaration.
Declaration ಕೇಳಿದ್ದೀನಿ. Court fee ಕೊಟ್ಟಿದ್ದೀನಿ.
And when the relief is sought for mandatory injunction, and also appellant counsel also made the submission on 22/11/24 before the court that now the defendants had made construction in the said property, which is shown in the B schedule property. And the trial court also rightly comes to the conclusion that matter requires the trial with regard to the encroachment is concerned and by the respondent. And when such being the case, I do not find any ground to interfere with the order of the trial court, and even commissioner report also discloses that already bifurcating the two property, there is a compound. And the appellant plaintiff has to succeed with regard to his title is concerned when this relief is sought for the declaration. And also, according to him, he left the passage of 5 feet into 50, and the same also to be proved before the trial court with regard to this contention is concerned. If he succeeds that he left 5 feet into 50 feet in order to access the property of the vendors, and the same also to be considered while granting the relief of mandatory injunction by the trial court, and hence no merit in the appeal to interfere with the findings of the trial court.
One submission, my lord. At para 11, the legislation or to indicate the portion with there is no document previous to substitute the claim of the litigant and execute the power indicate such portion is part of HUDL property. My sale deed was before her.
The trial court, while making an observation, made an observation that with regard
para 11 of the order,
with regard to the claim of 5 feet into 50 feet, no such documents are found. And the said observation is erroneous. The question of document indicating the same doesn't arise when the property sold in favor of the appellant to the extent of 33 feet into 50 feet. And expecting the document doesn't arise when the specific pleading was made by the appellant plaintiff that by oral permission was given to make use of the premises 5 feet into 50 feet to the
Right.
original
In my sale deed, my lord, 50 into 33 feet.
original vendor, and the said observation is erroneous without looking into the document of sale deed. And all this aspect has to be considered at the time of considering the merits. In view of the discussions made up, I pass the following order. Appeal is dismissed, however, directed the trial court to dispose of the suit within a time bound period of 1 year. And both appellant counsel and also the counsel appearing to the respondent directed to assist the trial court for time bound disposal.
Once the trial could not be influenced by any observation, the commissioner's report. madam.
ನಾನೇನ್ ಅಬ್ಸರ್ವೇಶನ್ ಮಾಡಿಲ್ಲ, ನಿಮ್ದೇ ಜಾಗ ಕಡಿಮೆ ಇದೆ ಅಂತ ಬರ್ದಿದ್ದೀನಿ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಪ್ರಕಾರ.
Because the learned judge has failed to, that was a ground for allowing my lord when he has not read the document.
The appellant counsel shall not, the trial court shall not influence with any observations made by this court while disposing of this appeal.
35,
And while considering the matter on merits.
35, Vijay Kumar K.
And direction to dispose the suit.
ಕೊಟ್ಟಿದ್ದೀನಿ 1 year.
1 year.
5,
Hearing for appellant, my lord.
Hmm.
Plaintiff's appeal, my lord.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಏನ್ರಿ?
Status quo granted after hearing.
ಈಗ
some
ಆಲ್ರೆಡಿ
time.
ಇದೆಯಾ ಸ್ಟೇಟಸ್?
Yes, my lord.
ಆಯ್ತು. Interim order extended till next date of hearing, list this matter immediately after winter
Date may-
vacation.
Date may be.
Huh?
Date may be.
ಆಯ್ತು 10/1.
Great.
36,
ರಾಕೇಶ್ ಕಿಣಿ.
Appellant.
ಇದು ನೋಟಿಸ್ ಆಗಿದೆ ಅದರ್ ಸೈಡ್ಗೆ.
Notice ಆಗಿಲ್ಲ.
89 days delay ಇದೆಯಲ್ಲ.
Delay.
Issue notice on IA number 1/24 and also on main.
37,
ಎನ್ ಕುಮಾರ್, ಏನ್ ಫಾರ್ ಪರ್ಮಿಷನ್ ಅಂತೇನ ಇದೆ? ಡಿಲೇ ಬೇರೆ ಇದೆಯಲ್ರಿ?
Delay ಇದೆ, my lord.
2707 days.
No, my lord,
ಏನದು?
I came to know the issuance of probate
Hmm.
only when the summons is, notice is issued
Hmm.
in the suit filed by the respondent,
Hmm.
a suit for injunction filed by him, my lord.
At issue notice against the respondents on IA number 1/24 and also on main.
38,
I appear for respondent number 1 and 3, my lords.
Appellant first.
ಏನ್ ಅರ್ಜೆಂಟ್ ಏನ್ರಿ?
ಇಲ್ಲ, ಇದು ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ. ಅಪೀಲ್ ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ ಹಾಕದಾಗ್ಲಿಂದ ಹಂಗ.
Anyhow,
ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಕೇಳಿದ್ವಿ.
all the
It
parties.
was my lord granted ex
Matter has
parte.
to be taken on merits.
Hmm?
The matter has to be taken on merits since all of us have.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಾಯ್ತು? IA rejected.
Trial court,
Case rejected.
Earlier ನಿಮ್ಗೆ
ex parte it was granted.
ಆಯ್ತು.
But subsequently, my lord, it came to be vacated.
Vacated.
Yes.
ಯಾವಾಗ ಅದು
My lord,
ಪಾಠ ಕೊಟ್ಟಿದ್ದು ಯಾವಾಗ?
my lord, that was soon after filing of the suit.
ಅದೇ ಯಾವಾಗ ಅಂದೆ? How long you are enjoyed the interim relief?
Yes, from 2/12/2022
To
my lord, from 1/2/2023.
One-
1/2/23.
ಹಾ.
To until disposal, my lord. It was,
disposal ಯಾವಾಗ ಆಗಿದ್ದು?
my lord, that is by
23rd
improved order,
July.
23/7/2024.
Anyhow, they have enjoyed the ad interim relief.
The thing is,
Ah.
Lord, there is a vague
But the date
description
fix
of the
ಮಾಡೋಣ.
properties.
Relief ಏನ್ ಅವ್ರಿಗೆ ಇದ್ರು, they have enjoyed from 23 February to till the
February
disposal-
23
My
to
lord.
July 24.
My lords,
application.
1.5 years.
ಹಾ,
Looking
1.5
into
years
the-
it was there.
one
looking
and a half
into-
year.
1.5 year.
ಹೌದು.
lords, if I may be.
February 23 to disposal till 24.
ಹೌದು.
ಹಾ.
If I may be allowed to submit,
Hmm.
the document that they are relying on itself is insufficiently stamped.
Hmm.
Hence, the bar under section 34 is admissible.
You file an application before.
I filed an application, but even at the time,
Already filed.
no, I haven't filed the application yet. But
Before-
even
before
before
the
the
trial
trial court, yes.
ಹಾ.
But even at the time of granting an injunction order, the
Hmm.
said fact has to be considered.
Hmm.
Their document itself is inadmissible. Neither
Right,
is
so-
it stamped,
But
neither
the
is
appellant
it.
counsel and also the counsel appearing to the respondent and record discloses that the appellant enjoyed the interim relief from 1/2/23 till the disposal of the IA. And hence, in view of the ensuing winter vacation, it takes time to hear the matter on merits and hence interim, and hence the and hence in view of enjoying of the interim relief before the trial court for a period of 1.5 year, not to alienate,
Not to alienate.
not to
Respect of
alienate.
only 4 apartments.
No, it is schedule ಅಲ್ಲಿ 36 flats ನ ತೋರಿಸ್ತಾರೆ. So that is the variation.
Four out of
Total it is ಎಷ್ಟು?
Four
Not to
apa-
alienate ಅನ್ನೋದು.
4 apartments out of number of apartments that were mentioned.
My lord, there
Only in
there
respect of
cannot
4.
be a blanket stay on 29 apartments. They are asking for.
Not in respect
schedule
of 29.
itself, it's ambiguous.
Trial court order ಹೇಳ್ರಿ ತೋರ್ಸ್ರಿ ಎಲ್ಲಿದೆ?
4 apartments, my lord, out of
ಇದೆ
the
ನಾನು entry
29.
ಮಾಡ್ರಿ ತೋರ್ಸಿ, ಫಸ್ಟ್ entry ಮಾಡ್ರಿ ನಿಮ್ಗೆ ಕೊಟ್ಟಿರೋದು.
My lord, that is not.
ಟ್ರಯಲ್
placed.
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಾಪಿ ಇದೆಯಾ? ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ?
Page number 122, my
That
lord.
is not there.
609.
122.
Expert.
That's
But
the
yes.
application that is. Yes.
ಇಲ್ಲ ಅದ್ರ ಹಾಕಿಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಇವರು.
ಹಾಕಿಲ್ಲ?
ಹಾಕಿಲ್ಲ ಅವರು.
There's a
trial court, the
specific
application
finding in the main order wherein they
So
say
that's
that
why,
the advance.
that's why the
consideration
interim
itself
order granted was discharged.
Vacate ಆಗಿದೆ ರೀ, but they have
Please
enjoyed
take-
the relief.
I
Page 106.
I agree, my lord, sir.
ಮತ್ತೆ?
I
Please
agree.
take
It
106.
takes time for disposal.
Please.
ಈಗ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ.
ಇಲ್ಲ.
Page 106, my lord. 6. This is the application that was filed before the trial court.
106.
Yes, my lord. The schedule B, my lord, is in respect of which, my lord, A, my lord, is the entire extent of the landed property, 1 acre 80
Not
guntas.
5, 106.
106, my lord,
Temporary
is
injunction.
B schedule.
You sought only the injunction restrain defendants and the agent persons claiming through order them from alienating. Only in respect of B schedule property.
B schedule property.
B schedule
B schedule-
property and
4 residential.
particular flats.
Yes, 4 residential apartment out of
Not
the.
so-
ಎರಡು ಫ್ಲಾಟ್
There
ನಂಬರ್
are
ಹಾಕ್ತಾರೆ.
no particular flats in that, my lord. They've included all
ತಾವೇ
12, all the
schedule B
29
ನೋಡಿದ್ರೆ
flats.
ಹ್ಮ್.
Out of
ಇನ್ನೆರಡು
which
ಫ್ಲಾಟ್ಸ್
how can
ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ ನಂಬರ್ ನ.
we cannot.
In
pick
the
and
agreement,
choose.
there is no description of whatever the number of the flats which subjected for agreement. That is still highly disputed.
Hmm.
And my lord may kindly take notice in.
Why you are seeking for specific?
My lord, what happened? My lord,
ಎರಡು
the-
ಹಾಕ್ತಾರೆ ಇದ್ರಲ್ಲಿ.
when, my lord, the apartment, the project was sought to be developed, the agreement of sale was entered into. After, my lord, after that, my lord, there was, my lord, identification of the apartments.
Hmm.
Well, thereafter, my lord, any other agreement did not come into existence.
Hmm.
My lord, the agreement of sale specifies, my lord, a specified built-up area for 2,088 square feet.
Hmm.
My lord, that would be put up on a subsequent point of time.
Hmm.
So therefore, the apartment, my lord, the agreement of sale did not have, my lord, specific number of apartments.
Hmm.
After, my lord, it is put up. They failed to, my lord, execute the sale deed. Therefore, I was before the trial court, my lord, executing the agreement.
Hmm.
So therefore, my lord, fairly enough,
What is the area agreed to sell to you?
Even
my
the
lord,
area. is not
2088
calculated.
square feet of
20?
square feet
Ah.
of, my lord, 4 apartments under the agreement of sale. Agreement of sale is there before this honorable court.
Hmm.
But
Four
therefore,
apartments, whether it is mentioned specifically?
in the agreement of
No,
sale,
my
it was not mentioned.
Hmm.
Well, because, my lord, at that point of time, construction, it was
But
was
only
not.
area is mentioned.
The only area is
Even
mentioned.
the area does not
2088
carry.
square feet.
88 square
Ah.
feet, my lord.
And
That is
he-
what is now
he
available.
Other than the developer of the very property.
Hmm?
He is none other. The appellant before this honorable court, the plight is developer of the very property.
Very property, he only developed.
Yes, he is,
Ah.
and he commits default.
Ah.
He commits breach and made us to, face different cases by the prospective purchaser with whom we have entered into agreement.
Hmm.
The people have went to RERA
Hmm.
and order is passed against all the 3 of us.
Till
And
date,
he
the
has come up with
occupancy
writ petition
certificate
before
is
this
also
court.
not there.
My lord, way back in 2021, the respondent 1 and 2 have filed section 9 petition before the commercial court seeking direction and a direction to the appellant to finish the project.
Hmm.
Lord, he has constructed only the developers area and ignored the, I'm sorry,
Remaining,
the owner's constructed
area.
area.
He did
Now,
not complete the construction
ಮಾಡ್ಲಿಲ್ಲ.
as
And-
agreed.
And 2013 is the joint development agreement. Subsequently, in 2014,
was a
sharing agreement
supplement.
was entered into,
Hmm.
and he has not raised any voice.
Hmm.
My lord,
There
based
was
on
no
this
addendum
unregistered
also
agreement
to the agreement.
and looking into all these trivialities, my lord, that's why normally the interim order will not be not to elect, will not be discharged
Hmm.
because of looking into the vagueness. And he has, sought the interim order in respect of, in 3 suits are filed.
Hmm.
12 flats are with number are mentioned.
Hmm.
But contention is that the agreement was in respect of 4 flats.
Hmm.
And he stated that through
That is also subject to completion
ಹೌದು
of the project.
2088 ಅಂತ ಹೇಳ್ತಾರೆ, ಮತ್ತೆ 150 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಕಮ್ಮಿ ಬರುತ್ತೆ ಇಲ್ಲೇ ಹಾಕೊಂಡಿರೋದು ಇವ್ರ ಪ್ರಕಾರ.
Hmm.
And being developer of the property, how does he can say that there is a shortfall, the shortage in respect of the completion of the
My lord,
the
if
area
I
of the flat.
Hmm.
What
Hello,
is
sir.
claimed by me is a shorter extent.
Now, all
Lord,
the-
I am not a
what,
builder.
what happened is.
My husband, my lord,
all
was the builder.
flats What he has
But I have
shown
placed my
here
lord joint
are
development agreement.
subjected for.
My husband
sale
was the builder,
agreement.
which was a my lord partnership concern. Incidentally, my lord, my lord, he entered into an agreement of sale. There is no bar, my lord, under to enter into such a contract. My lord, they receive money out of it. In fact, my lord, lesser extent was put up.
There is no.
What I am seeking, my lord, is lesser than what is put up.
ಎರಡು ಸೂಟು ಇವರು ಏನು
My lords,
the
if I may be
developer
allowed
has
to-
come. One second. And
And
one suit is filed.
ನಿಮ್ಮನ್ನು ಕೇಳ್ತೀನಿ.
One suit is,
ಏನೋ ಆರ್ಡರ್ ಬರೆಯಲ್ಲ ಇರಿ.
two suits are filed by the developer in his individual capacity, and the third suit is filed by his wife. And the allegations are same. 40 lakhs we have paid, 14 lakhs in instrument in favor of the respondent number 1, and 26 lakhs in cash. And there is no, the trial court has also observed, he failed to place before the court the mode of payment that is made in favor of the respondents. So looking into all these things, because the very, relief sought in respect of the properties subjected for alleged agreement, he says 4, and in the agreement, in the relief, the schedule, he mentions 12, individually 12 flats in all the 3 suits.
Yes, madam.
My lords, even with respect to limitation, the agreement to sell is dated 2013. It's very clear under clause 4 that it's time is the essence of the contract. So ideally, even if this, notwithstanding the fact that the entire agreement to sale itself is a bogus fabricated document, they should have filed the suit in 2021. Besides, it's not registered, neither is it stamped. And there's a specific finding in the trial court's order, paragraph number 24 and 26, wherein they very clearly say that there is no proof to the extent that they have paid the advance consideration. The schedule itself is ambiguous. There is no flat measuring 2866 square feet or 2088 square feet as claimed under the schedule of the ATS. The trial court, there is no perversity in the order of the trial court, my lord. There is no stay, there's no question of stay.
Yes. ಏನ್ರಿ ನಿಮ್ ಬಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಏನ್ ನೀವು ಇಷ್ಟೊಂದು ತೋರಿಸಿದ್ರಿ? ಅಪಾರ್ಟ್ಮೆಂಟ್ ಬೇರಿಂಗ್ ನಂಬರ್ 101, 107 in first floor, 408, 314 in third floor, 401 and 407 in fourth floor, 508, 514 in the fifth floor, 601, 607 in sixth floor, 808 and 814 in eighth floor, measuring 2,710 square feet ಅಂತ ಮಾಡಿ.
These are the apartments that have fallen to the share.
4 ಅಂದ್ರೆ ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಎಲ್ಲಾನು ಕೇಳಿದಿರಿ ಎಲ್ಲಾ ಫ್ಲೋರ್ ಅಲ್ಲೂ.
Out of them, my lord, 4 apartments I have asked. But these are the apartments that have fallen to the share of, my lord, the defendants. My lord, the agreement of sale was executed, my lord, in respect of 4 apartments that would, my lord, of a specified dimension that would fall to the share of, my lord, the defendants. The amounts under the contract, my lord, are paid by way of checks. My lord, I'm afraid to hear that, my lord, no consideration is paid. What is the defense that is set up, my lord, is that, my lord, under the guise of, my
What
lord,
was the amount you have paid?
the, my lord, 40 lakhs, my lord, out of the agreed sale consideration.
What is the agreed sale
The,
consideration?
my lord, agreed sale consideration, my lord, varies between each of the contracts, my lord. In the instant case, it is 3 crore 9 lakhs.
3 crore
9 lakhs.
You paid only the
40 lakhs,
40
my lord,
lakhs.
under the
Now we are seeking for stay of 4 flats.
4 flats out of, my lord, the apartments that have fallen to their share. Because, my lord, the agreement, please take, my lord, the agreement of sale. Page 55, my lord, I have placed 55, my lord, I have placed it before the court with the list of documents. It specifies only 4 residential apartments, obviously so, because as on that date, my lord, the construction was not there.
No specific apartments.
No, my lord, it was not mentioned for the simple reason that, my lord, construction was not there. Subsequently, my lord, there was, my lord,
14 lakhs by way of check.
yes,
Remaining 26 lakh by way of cash.
cash, my lord,
Cash
according
receipt
to-
ಇದೆಯಾ ಇಲ್ಲ?
The, my lord, my lord, it should be there, my lord. However, my lord, the portion of the sale consideration is by way of check. In the other 2 agreements also, it is the same situation. But insofar as, my lord, the delay that they alleged, they, my lord, went before, my lord, by way of an interim measure before the commercial court. Commercial courts, my lord, rejects their application stating that, my lord, the project is almost complete. That was against, my lord,
Is this not immediately intervocation?
but to that extent, to, my lord, the limited arrangement, that, my lord, if they sell, my lord, the whole suit would become infructuous.
You
That,
only
my lord.
paid the amount of rupees 14 lakhs.
No,
by way of
I
check.
understand. Nevertheless, my lord,
Also, cash also you have not produced.
my lord, nevertheless, the agreement stares at them, no, it is not
Whatever
that.
it may be, counsel, by making payment of rupees 14 lakh, whether you can seek for restraining or restraint order against the respondents in respect of 4 flats.
No, my lord, that was the sale consideration that was agreed as it prevailed then.
15 ದಿವಸದಲ್ಲಿ ಏನಾಗಲ್ಲ, ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. It requires consideration. List this matter immediately after winter vacation on 7/1.
Oh, please.
ಕೇವೇಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಯಾರ್ದ ನೋಡ್ರಿ ಕೇವೇಟ್ ಹಾಕಿರೋದು ಯಾರೋ ಸಮ್
Respondent number 1 and 3.
ಕೇವೇಟ್ ರಿಟರ್ನ್ ವಿತ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಪ್ರಕಾಶ್ MH ನಿಮ್ದೇ ರೀ ನೋಡಿ. ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 6055 ಅಲ್ಲಿ
ಇಲ್ಲ KVA
ಮೂರಲ್ಲೂ ಇದೆಯಾ?
ಇಲ್ಲ ನಾ KVA ಹಾಕಿರ್ಲಿಲ್ಲ ಇದರಲ್ಲಿ. I entered appearance on notice.
Agar KVA, you are the KVA.
My learned friend.
I'll comply with you.
Comply with office objection. In the meanwhile, the counsel for KVA is directed to comply with office objections.
Publish.
49. P. Ramesh. K. Umadev.
Appellant.
130.
Defendant's appeal.
At 2:30. Remaining matters at 2:30. ಯಾವುದು 58 ಏನ್ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಡ್ಮಿಷನ್ ಬಿಟ್ಟು ಫೈನಲ್ ಇಯರಿಂಗ್ ತೊಗೊಳಕ್ಕಾಗುತ್ತಾ? ಮತ್ತೆ ಅಪ್ರ ಕೊಡೋಣ, ಆಗ್ಲೇ ಕೊಡೋಣ. ಅದಕ್ಕೇನು ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? ಅದರ್ ಸೈಡ್ ಇದಾರ? ಪುಟ್ಸಿದ್ದಯ್ಯನವ್ರು ಇದಾರೆ. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ ನೀವೇನು? ಆಫ್ಟರ್ 16th of January. List this serial number 58. Counsel for the appellant seeks time and counsel for respondent present. List this matter on 16th ಬೇಕಾ ಅಥವಾ 17th ಆಗುತ್ತಾ? 17th Thursday ನ ಬರುತ್ತೆ. ಫ್ರೈಡೆ ಬರುತ್ತೆ. 17/1/25. ಹೇಳಿ. ಪಟ್ಟಿನ ಏನಕ್ಕಿದೆ? ಅಡ್ಮಿಷನ್ ಅದರ್ ಸೈಡ್ ಇದಾರಲ್ಲ ತೊಗೊಳ್ಳಿ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ seeks time and counsel for the respondent also present. List this matter immediately after winter vacation. Data ಕೊಡಿ 10/1.
My lord, serial number 46, my lord, filing memo for withdrawal.
Withdrawal ಕೊಡಿ ತೊಗೊಳ್ಳಿ. Appellant counsel files memo for withdrawal of the appeal and permitted to withdraw. ಅಷ್ಟೇನಾ? Reason ಬರೀ ಅಷ್ಟೇನಾ ಏನು?
ಅಷ್ಟೇ.
Not pressed.
Published.
ಅಷ್ಟೇ
Serial number ಇದು list number 1 serial number 57.
Madam 41 ಇದೆಯಾ? 41 ಇದೆಯಾ?
ಬಂದೋಗಿದೆ ನೆಟ್ಗೆ ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
ಅದನ್ನ CD ನೆಲ್ಲ ಏನೋ ಮಾಡ್ಕೊಡಿ ಆಯ್ತಾ?
ಕಂಪ್ಲೇಂಟ್
ಹಾ.
ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್ ಆಲ್ರೆಡಿ ನಾನು ರೆಕಾರ್ಡ್ ಮಾಡಿ ಕೊಡಿ.
ನೀವ್ ಈಗ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದಿರಲ್ಲಮ್ಮ,
ಹೌದು ಸರ್.
ನನ್ನ ಹೆಸರು ಹೇಳಿ ದುಡ್ಡು ರೆಕಾರ್ಡ್ ಮಾಡಿರೋದು ಇದಾರಲ್ಲ,
ಹೌದು ಸರ್.
ಅದನ್ನ ಕೊಡಿ. ಒಂದ್ ರೆಕಾರ್ಡ್ ಮಾಡಿಸಿ ಕೊಡಿ ಅದನ್ನ. ಐ ವಿಲ್ ರೆಫರ್ ದಿ ಮ್ಯಾಟರ್ ಟು ದಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್, ಹೋಲ್ಡ್ ಎನ್ ಎನ್ಕ್ವೈರಿ ಅಂಡ್ ಆಲ್ಸೋ ರಿಜಿಸ್ಟರ್ ದಿ ಕೇಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಅಡ್ವೊಕೇಟ್. ಕೊಡಿ ಅದನ್ನ.
Okay sir.
ಯಾವಾಗ ಕೊಡ್ತೀರಿ?
ನಾಳೆನೇ ಕೊಡ್ತೀನಿ ಸರ್.
ನಾಳೆ ಕೊಡಿ. ಅದು ರೆಕಾರ್ಡ್ ಆಗಿರ್ತದಲ್ಲ ಮೊಬೈಲ್ ಅಲ್ಲಿ,
ಹೌದು.
ನನ್ನ ಹೆಸರು ಹೇಳ್ಕೊಂಡು ದುಡ್ಡು ಕೇಳಿರೋದು,
ಹೌದು ಸರ್.
ಅದನ್ನ ಒಂದು ಇದ್ರಲ್ಲಿ ಹಾಕೊಡಿ. ಪೆನ್ ಡ್ರೈವ್ ಅಥವಾ ಯಾವ್ದ್ರಲ್ಲಾರು ಹಾಕ್ಸ್ಕೊಡಿ. ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ ನ ಕಳ್ಸೋಣ.
ಅದ್ರಲ್ಲಿ ತುಂಬಾ
FSL ಗೆ ವಾಟ್
ತುಂಬಾ ಕೆಟ್ಟದಾಗಿದೆ ಸರ್ ಅದ್ರಲ್ಲಿ.
ಕೆಟ್ಟದಾಗಿದೆಯಾ?
ಬೈದೆ ಸರ್.
ನಿಮಗ್ ಬೈದಿರೋದ ಅಥವಾ ನನಗೆ ಹೇಳಿರೋದ?
ಇಬ್ಬರಿಗೂ ಸೇರಿ ಬೈದಿರೋದು.
ಆ?
ಇಬ್ಬರಿಗೆ
ಆ?
ಇಬ್ಬರಿಗೆ ಹೇಳಿದ್ದಾರೆ ಸರ್.
ಇಬ್ರಿಗೂ ಬೈದವ್ರ? ಯಾರು ನಿಮ್ಗೆ ನನ್ಗೂ?
ಹೌದು ಸರ್.
ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ನಾನು ಇರೋದೇ ಇಲ್ಲಿ ಕೂತ್ಕೊಳಕ್ ಬೈಸ್ಕೊಳಕ್ಕೆ, ಆಯ್ತಾ? ಹಾ, ಅದೇನಾಗಿದೆ ಕೊಡಮ್ಮ, ಚಿಂತೆ ಮಾಡಕ್ ಹೋಗ್ಬೇಡ. ನಾನಂತೂ ಹೇಳ್ತೀನಿ, ಇವೊಂದವರೆಗೆ ನನ್ನ ಆತ್ಮಸಾಕ್ಷಿ ಬಿಟ್ಟು ಯಾವನ ಹತ್ರ 5 ಪೈಸೆ ಮುಟ್ಟಿಲ್ಲ. ಐ ಸ್ವೇರ್ ಆನ್ ಮೈ ಚಿಲ್ಡ್ರನ್. ನೀ ಕೊಡಮ್ಮ ನೀನು, ನಾನು ಐ ವಿಲ್ ಟೀಚ್ ಎ ಲೆಸನ್ ಟು ದೆಮ್. ಐ ವಿಲ್ ಟೀಚ್ ಎ ಲೆಸನ್ ಟು ದಿ advocate, whoever it may be, whether any advocate or anybody else. ಗೊತ್ತಾಯ್ತಲ್ಲ? ಏನಾದ್ರು ದುಡ್ಡಿಗೋಸ್ಕರ ಏನೋ ಹೇಳಿರ್ತಾರೆ ನಮ್ಮ ಮೇಲೆಲ್ಲ. ಆಯ್ತು, ನಾವು ಹಾಗೆ ಬಿಡಕ್ಕಾಗಲ್ಲ ಇದನ್ನ, ಆಯ್ತಾ? ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಮರ್ಯಾದೆ ಪ್ರಶ್ನೆ, ಗೊತ್ತಾಯ್ತಲ್ಲ? ನನ್ನ ಪ್ರಶ್ನೆಗಿಂತ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಮರ್ಯಾದೆ ಪ್ರಶ್ನೆ.
ಸಂದೀಪ್ ಸಾಹೇಬ್ರು ಸುಮ್ನೆ ಸೈನ್ ಮಾಡಲ್ಲ, ನೀನ್ ಅವ್ರ ಹತ್ರ ಹೋಗ್ತಿ ಅಂತ ಕೇಳ್ತಾರೆ ಸರ್.
ಅದೆಲ್ಲ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ.
ರೆಕಾರ್ಡ್ ಇದೆ ಸರ್.
ಅದು ಇದೆಯಮ್ಮ, ಹೋಗ್ಲಿ ಕೊಡು
ಹೌದು ಸರ್.
ಮೊಬೈಲ್ ಅಲ್ಲಿ.
ಇದೆ ಸರ್.
ನಾವೇ RG ಕಳ್ಸಿ ಇದನ್ನ ಮಾಡ್ಸೋಣ, CD ಮಾಡ್ಸೋಣ. ಕರ್ಸಿ RG ಕರ್ಸಿ, RG ಕರ್ಸಿ. ಕಂಪ್ಯೂಟರ್ನವ್ರನ್ನ ಕರ್ಸಿ, ಅವ್ರನ್ನ ಕರ್ಸಿ, RG ಕರ್ಸಿ. ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದಿ RG ಟು ಹೋಲ್ಡ್ ಎನ್ ಎನ್ಕ್ವೈರಿ ಅಂಡ್ ರಿಜಿಸ್ಟರ್ ದಿ ಕೇಸ್. ಕರೀರಿ. ಇಷ್ಟ ಆಗೋದೇನ್ ಬೇಡ. ಯಾವ ಕೇಸ್ ಅದು? ಕೇಸ್ ನಂಬರ್ ಎಲ್ಲ ತಗೊಳ್ಳಿ. ಇದೇನ ಬಾರ್ ಕೌನ್ಸಿಲ್ಗೆಲ್ಲ ಕೊಟ್ಟಿದೆಯಲ್ಲಮ್ಮ ಕಂಪ್ಲೇಂಟ್?
ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್. ಕೇಸ್ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಯಾರು ಇದು? ತೆರೇಸಾ ಅಂತ? ತೆರೇಸಾ ನೀವು?
ಹೌದು ಸರ್.
ದಯಾನಾ ಅಂತ ಅಡ್ವೊಕೇಟ್ ಯಾರ್ರಿ? ದಯಾನಾ ಬಾನು?
ದಯಾನಾ ಬಾನು ಅಂತ.
ನನ್ನಂತೆ ಬರುತ್ತಾ? ಬಟ್ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲ ನನ್ನ ಹೆಸರು ಬರ್ದವ್ರವ ಇದಕ್ಕೆ, ಬಾರ್ ಕೌನ್ಸಿಲ್ಗೆ. ನಂಬರ್ ಏನು? ನಂಬರ್ ಏನಿದೆ ನೋಡಿ
ಮೇಡಮ್. ನಿಮ್ದು ಕೇಸ್ ನಂಬರ್ ಇದೆಯಾ? ಕೇಸ್ ನಂಬರ್
ಕೇಸ್ ನಂಬರ್ ಇದೆಯಮ್ಮ?
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಹಾಕಿದಿರಲ್ಲ ಬೇಲ್ದು, ಅದ್ರ ನಂಬರ್ ಇದೆಯಾ? ಇದೆ ಸರ್. ಕೊಡಿ, ನಂಬರ್ ಕೊಡಿ.
ಅದೇನೋ ಅವ್ರ ಮೊಬೈಲ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದಾರಂತೆ, ದುಡ್ಡು ಕೇಳೋದು, ನಮ್ಮ ಹೆಸರು ಹೇಳ್ಕೊಂಡು ದುಡ್ಡು ಕೇಳೋದು. ಅದೇನು CD ಮಾಡಕ್ಕಾಗುತ್ತಾ ನಿಮ್ಮಲ್ಲಿ? ಏನಾದ್ರು ಇದಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಕ್ಕಾಗುತ್ತಾ? ಪೆನ್ ಡ್ರೈವ್ ಮಾಡಿ, ಈಗ ಮಾಡಕ್ಕಾಗುತ್ತಾ? ಹಾ, ಪೆನ್ ಡ್ರೈವ್ ಖಾಲಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಮಾಡಿ, ಅದು ಸರ್ಚ್ ಮಾಡಿ. ಪೆನ್ ಡ್ರೈವ್ ತಗೊಬನ್ನಿ, ಅದನ್ನ ಇದನ್ನ ಮಾಡಿ ನಿಮ್ಮ ಪೆನ್ ಡ್ರೈವ್ಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ. ಆಕೆ ಹತ್ರ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಬರ್ಸ್ಕೊಳ್ರಿ. ಕಂಪ್ಲೇಂಟ್ ಬರ್ಸ್ಕೊಳ್ರಿ. ಆಮೇಲೆ ಅವ್ರೇನು ಅಡ್ವೊಕೇಟ್
ಹೇಳಿ ಮೇಡಮ್, ಎಲ್ಲಿದೆ ಅಂತ.
ಬಾರ್ ಕೌನ್ಸಿಲ್ ಅಲ್ಲಿ ಎನ್ರೋಲ್ ಆಗಿದಾರ ಎಲ್ಲ ಫಸ್ಟ್ ನೋಡ್ಕೊಳ್ಳಿ. ಯಾರು ಫೇಕ್ ಅಡ್ವೊಕೇಟ್ ಇರ್ಬೋದು ಏನೋ, ಯಾರಿಗ ಗೊತ್ತು?
ಕೇಸ್ ನಂಬರ್ ಕೊಡ್ತೀನಿ ಸರ್.
ನಮ್ಮ ಹೆಸರು ಹೇಳ್ಕೊಂಡು ದುಡ್ಡು ಕೇಳ್ತಾರೆ ಅಂದ್ರೆ ಇಟ್ ಅಪಿಯರ್ಸ್. ಅವ್ರನ್ನ ಕರ್ಕೊಂಡು ಹೋಗಿ ಜೊತೆಗೆ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಟ್ರಾನ್ಸ್ಫರ್ ಇದನ್ನ ಮಾಡ್ರಿ, ಪೆನ್ ಡ್ರೈವ್ ಮಾಡಿ. ಇದು ಇಲ್ಲಿದ 11259/24 ಇಲ್ವಲ್ಲ? ಇಷ್ಟೊಂದು ನಂಬರ್ 1000 ಮೇಲೆ ಇದೆಯೇ ನೋಡಿ. ಓ ಇರ್ಬೋದ್ರಿ, ಇಲ್ಲೆಲ್ಲ ಇದೆ 13,456 ಇದೆ. ಕರ್ಕೊಂಡು ಹೋಗಿ ಕೇಳಿ, ಅಲ್ಲೇ ಕಂಪ್ಯೂಟರ್ ಸೆಕ್ಷನ್ ಅಲ್ಲೇ ಮಾಡಿ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಬರ್ಸ್ಕೊಳ್ಳಿ, RG ಕರೀರಿ, ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್.
ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಬರ್ಕೊಡಿ ಇದ್ರ ಬಗ್ಗೆ.
RGನ ಅದಾದ್ಮೇಲೆ ಬರ್ಲಿ, ಇವ್ರದೆಲ್ಲ ಪೆನ್ ಡ್ರೈವ್ ಹಾಕ್ಲಿ, ಕಂಪ್ಲೇಂಟ್ ಬರ್ಸ್ಕೊಳ್ಳಿ, ದೆನ್ ಕಾಲ್ RG.
On complaints of 230 first time 63 Prabhu Pujar.
For petitioners, praise time for complaints.
ಯಾವ್ದು ನಂಬರ್ ಯಾವ್ದು?
Sir 63
63.
first time non complaint.
ಫಸ್ಟ್ ಟೈಮ್ ಎಷ್ಟು ದಿವಸ ಬೇಕ್ರಿ?
2 weeks times.
Huh?
2 weeks times.
2 weeks.
And the vacation.
Counsel for the petitioner seeks 2 weeks time to comply with office objections.
64
Appear for petition, my lord. There are two office petition, my lord. One is, my lord, regarding age, my lord, that may be overruled also. The one regarding age of the petitioner, my lord. I have mentioned, my lord, as per the, my lord, trial court order, lordship. It is, my lord, ink page number 9, my lord, the rejection order. Trial. I have rightly mentioned the name of the age of the petitioner, 22 years. Another is, my lord, adali third edition anta prayer
22 years on what basis you made the
my lord, on the trial court order, lordship. Page,
trial court order?
my lord, ink page number 9, lordship.
But FIR charge sheet ಅಲ್ಲಿ ಏನಿದೆ ಏಜ್?
Charge sheet ಅಲ್ಲಿ 22 in the year 22 they have filed charge sheet. ಅವಾಗ 18 years
Year 22.
18 years ಹಾಕಿದ್ದಾರೆ. ಅಂದ್ರೆ ನಾನು 20 ಹಾಕ್ಬೇಕು ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. ಬಟ್ ಆಸ್ ಪರ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮೇಲೆ ದಿಸ್ ಏಜ್ ಇಸ್ 22 years.
22 ಅದ್ರ ಪ್ರಕಾರ ಹಾಕಿದ್ದೀರಿ?
ಹಾಕಿದ್ದೀನಿ ಸರ್.
ಆಯ್ತು. The counsel submits that before the trial court age is mentioned as 22 years and hence the petitioner name.
ಹೌದು ಸ್ವಾಮಿ.
Petitioner name is mentioned as 22 years.
Please.
Second in the petition.
Second
office objection.
Second office objection ಮೇಡಮ್ ಅದರಲ್ಲಿ ಪ್ರಿನ್ಸಿಪಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಂತ ಸೆಷನ್ ಜಡ್ ಅಂತ ಬರ್ತೀನಿ. ಥರ್ಡ್ ಅಡಿಷನಲ್ ಅಂತ ಒಂದು ಬರೀಬೇಕು ಅಷ್ಟೇ.
ಥರ್ಡ್ ಅಡಿಷನಲ್ ಅಂತ ಹಾಕ್ಬೇಕು. ಕರೆಕ್ಷನ್ ಮಾಡಿ
ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಆಯ್ತು.
ಡೈರೆಕ್ಟೆಡ್ ಮೇಲೋಡ್.
The counsel is permitted to correct the court name.
Please ಮೇಲೋಡ್.
HCGP is directed to take notice and file objections if any. ಏನಿಲ್ಲ after winter vacation.
Please ಮೇಲೋಡ್. ಒಬ್ಲೇಜ್.
ಯಾವಾಗ ಬರುತ್ತೆ? ಬುಧವಾರ ಮೇಡಮ್. 6, 7, 8 8ನೇ ತಾರೀಕು ಇರಬೇಕು. 8/1.
Please oblige.
65
Sanat Kumar KM.
2 days maybe. To comply. 2 days.
Counsel seeks 2 days time to comply with office objection. If complied, list this matter on 8/1.
second time non complaint 66 we appeal for the
Sumati.
Yes my
Bolin.
my lord, I have complied with the office objection, some office note they have given. No. Sir, it's second time non complaint.
ಎಷ್ಟಿದೆ? ಇನ್ನು 5 ಇದೆ ಆಫೀಸ್ objections. ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳಿ?
1 week.
1 week.
Yes.
Counsel seeks 1 week time to comply with office objection. If office objections are complied, list this matter on 8/1.
Much. Orders 67.
Provide police report in respect of service of notice issued on R2. ಏನಾಯ್ತು? Served on R2? Served. Additional SPP submits that notice is served on the R2 through IO. Counsel Sri? RS Abhay. RS Abhay. Abhay submits that he has filed a wakalat on behalf of R2. ಯಾವಾಗ ಹಾಕಿದ್ರಿ? ಅದೇನ್ ಕಾಪೀಸ್ ಕೊಟ್ರಿ ಅವರಿಗೆ? ಕಾಪೀಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಡಿ. Appellant counsel is directed to serve the copy of the appeal memo. Appeal ಇದು?
SC/ST.
SC/ST. And list this matter on 8/1. 8/1.
Pardon, my lord?
Next sitting 8/1.
But your lordship may kindly consider, of course. This, in this appeal, my lord, your lordship may kindly consider that we have challenged the order, page number 15, my lord. This order we have challenged. In that, my lord, your lordship may kindly see, we had not taken a ground regarding medical condition of my sister. And she is required to transplantation of kidney. I intend, because being a relative, I intend to give my kidney to her on that ground, of course. We have requested for the bail. But this ground was, of course, was not urged at that time.
ಅಲ್ಲಿ ಅರ್ಜಿ ಮಾಡಿಲ್ಲ.
ಮಾಡಿರ್ಲಿಲ್ಲ.
ಮತ್ತೆ ಇಲ್ಲ ಹೆಂಗ್ ಅರ್ಜಿ ಮಾಡ್ತೀರಿ?
That's why I am bringing it to your lordship.
ಈಗ ಫ್ರೆಶ್ ಆಗಿ ಹೇಳ್ತಾ ಇದೀರಾ?
Yes, because the condition is very serious, we are seeking. We have straight away filed this appeal again before your lordship.
6/11 ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಮತ್ತೆ?
Pardon.
This petition was filed on 6/11.
Notice service ಆಗಿಲ್ಲ. Notice service ಆಗಿಲ್ಲ.
Notice ಆಗಿದ್ದು ಯಾವಾಗ? ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್.
ಇವಾಗಲೇ ಆಗಿದ್ದ ನೋಟಿಸ್ ಸರ್.
But you have to give an opportunity to the victim ಅಲ್ಲ?
Opportunity to be given, my lord.
ಮತ್ತೆ matter comes before the court on 13/11. Appellant counsel seeks a time to comply with office objections ಇತ್ತು. Weeks time granted. ಕಂಪ್ಲೈನೇ ಮಾಡಿಲ್ಲಲ್ಲ ನೀವು?
ಕಂಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ.
Court well ಅಲ್ಲಿ after 1 month ಆದ್ಮೇಲೆ directed to take notice.
Yes.
ಈಗ ಸರ್ವಿಸ್ ಫಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಸರ್ವ್ ಮಾಡಿದಾರೆ ಆಲ್ರೆಡಿ. ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ದೆ, ಬಟ್ ಅವ್ರಿಗೆ ಆಪರ್ಚುನಿಟಿ ಕೊಡ್ಬೇಕಲ್ಲ ವಿಕ್ಟಿಮ್ಗೆ.
1 minute, my lord. Because your lordship may kindly see, ultimately this ground is not taken before trial court and the dismiss ಆಗೋದಕ್ಕಿಂತ your lordship may kindly dismiss this with liberty to approach the trial.
Go to the trial court
with
and
that,
then
yes, with that
if
observation.
it is rejected, then you can come back.
Yes, my lord.
Third.
That would be better.
Third. Heard the appellant counsel and also the counsel appearing for the respondent number 2, complainant counsel and also the additional SPP. And now the petitioner sought the bail on the ground that
He wants to donate kidney to his sister.
petitioner wants to donate his kidney to his ailing sister suffering from kidney disease.
Yes.
And there is a requirement of kidney transplantation.
Ground number 12, your lordship.
ಅದೇ 11 and 12. 12
Yes.
ಅಲ್ಲಿ ಇದೆ. And counsel for the petitioner fairly submit that he did not urge this ground before the trial court. The counsel for the respondent number 2, though seeks time in view of not urging of this ground, instead of considering this, the petitioner may be given liberty to approach the trial court with the grounds which have been urged before this court. And hence petitioner is permitted to withdraw this petition and approach the trial court, the ground which has been urged before this court. And hence permitted to withdraw.
With liberty to approach trial.
With liberty to approach the
Trial court and
trial court on the medical grounds which have been urged before this court.
grateful.
68. B. Siddeshwara.
Yes. Lord, this is bail petition and delay in trial, my lord. My lord, on the last date of occasion, learned public prosecutor said the trial has begun, my lord. My lord, actually, trial has CW1 was present on 14/11.
Learned counsel for the petitioner seeks time additional SPP submits the trial has been commenced and already CW1 is examined as PW1.
No, my lord.
ಆಗಿಲ್ವಾ?
ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಕಂಪ್ಲೀಟ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿಲ್ಲ. ಅಲ್ಲಿ PF ಒಂದಿದೆ, ಆ PF ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. PF ಆಗದಲ್ಲ ಇರೋದಕ್ಕೆ ನಮ್ಮಿಂದ ಡಿಲೇ ಇಲ್ಲ ಸ್ವಾಮಿ. ನಾವು ಪ್ರೆಸೆಂಟ್ ಇದೀವಿ ಪ್ರತಿ ಡೇಟ್. ಐ ಆಮ್ ಇನ್ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ, my lord. Accused number 2 is also present, my lord. SC of the year 2021, my lord. In November 2024, after filing this petition, my lord, after urging the ground of delay, my lord, the CW1 was kept present, my lord. Even CW1 evidence is not completed, my lord. His chief is pending, my lord.
ಯಾವಾಗ ಎಕ್ಸಾಮಿನ್ ಆಗಿದ್ದು?
My lord, 14/11/2024, my lord.
14/11/2024. 14/11.
Yes,
ಯಾವ ಕೇಸ್ ಇದೆ ಮತ್ತೆ?
My lord.
ಮತ್ತೆ ಯಾವ ಕೇಸ್ ಇದೆ ರೀ?
My lord, next case is 23/1/2025.
23/1/2025. ಏನ್ರಿ ಅಷ್ಟೊಂದು ಲಾಂಗ್ ಟೈಮ್? ನವೆಂಬರ್ ಇಂದ
ಡಿಸೆಂಬರ್ ಒಂದು ಡೇಟ್ ಬಂದಿದೆ ಸ್ವಾಮಿ, 6/12ಗೆ. ಅವತ್ತೂನು PF ಸೆಕ್ಯೂರ್ ಮಾಡ್ಲಿಲ್ಲ, ಸೊ ಅದು ಜನವರಿಗೆ ಹೋಗಿದೆ.
PF ಕೊಡ್ಲಿಲ್ವಾ?
PF
ಕರ್ಕೊಬರೋದಷ್ಟೇ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಪ್ರಾಪರ್ಟಿ ಫಾರ್ಮ್ ಸೀಸ್ಡ್ ಮೆಟೀರಿಯಲ್ ಕೊಟ್ಟಿಲ್ಲ, ಪ್ರಾಪರ್ಟಿ ಫಾರ್ಮ್ ಕೊಟ್ಟಿಲ್ಲ.
PF
PF
material objects are not produced.
Yes, my lord.
No, why they have not produced? Why they have not produced, madam? You made the submission last occasion that he has been examined. When the matter was set down for trial, is it not the duty of the high court to produce the material objects? On the ground of non-production of material objects, the case was adjourned. ನಾನು ಯಾವ್ದೋ ಒಂದು ಆರ್ಡರ್ ಓದ್ತಾ ಇದ್ದೆ, ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನೋ ಯಾರೋ ಕಳ್ಸಿದ್ರು ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ, ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ವಿಟ್ನೆಸ್ ಕರ್ಕೊ ಬರ್ಲಿಲ್ಲ ಅಂತ ಎಲ್ಲಾರನ್ನು ಬಿಟ್ಟು ಕಳ್ಸ್ಬಿಟ್ರು ಅಂತ ಅಕ್ಯೂಸ್. ಅದನ್ನೇ ಮಾಡ್ಬೇಕಾ ನಾವು? ಏನ್ ಹೇಳಿ? Why material objects are not produced? ಕೇಸ್ ಕಮೆನ್ಸ್ ಆಗಿದ್ದ ಯಾವಾಗ? ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿರೋದು ಯಾವಾಗ?
Madam, 14/11/2024.
14/11 ಅಲ್ಲಿ.
24. This month 14th, madam. Last month 14th. But I am in custody from 27/7/2021, madam.
ಏನ್ ಅಫೆನ್ಸ್ ಏನ್ರಿ?
302, madam.
ಮತ್ತೆ
4 years ಆಗಿದೆ ಸ್ವಾಮಿ. ಏನು there is no development in the trial.
4 years ಅಲ್ರಿ, 3 years 21 ಅಂದ್ರೆ
21, yes madam. 21.
4 years ಹೆಂಗಾಗುತ್ತೆ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದೊಂದು ತಿಂಗಳಾಗೋದ್ರೆ next year ಬಂದ್ಬಿಡ್ತೀವಿ ಸ್ವಾಮಿ.
I may be weak in mathematics, but
No madam. No madam.
he is the main accused.
Only 2 accused,
Whoever it
madam.
may be. Third, counsel appearing for the petitioner would submit that though the PW1 was examined on 14/11/2025 and his chief evidence has not been completed in view of non-production of material objects before the court, and even on the date of
6/12/2024.
6/12/2024. ಎಲ್ಲಿ ಇರೋದು ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್?
ತುಮಕೂರಲ್ಲಿ ಸ್ವಾಮಿ.
ತುಮಕೂರು. And hence, counsel for the state, additional SPP, seeks time to verify why material objects are not produced when the case is set down for trial. And hence, list this matter on 8/1/2025. ಅವತ್ ನೋಡ. ಮತ್ತೆ ಯಾವಾಗ ಇರೋದು ಡೇಟು?
23/1/2025.
23/1.
ಹೌದು ಸ್ವಾಮಿ.
ಏನ್ ಮೇಡಮ್ ಇದು? 2 ತಿಂಗಳು ಟ್ರಯಲ್, ಸೆಷನ್ಸ್ ಟ್ರಯಲ್ ಈಗೆಲ್ಲ ಮರ್ಯಾದೆ ಇಲ್ಲ ಅನ್ಸುತ್ತಲ್ಲ? ಅದು ಎಲ್ಲ ಈ ಸಿವಿಲ್ ಸೂಟ್ ಆದಂಗ ಆಗಿದೆ ಅನ್ಸುತ್ತೆ. ಒಂದ್ಸರಿ ಟ್ರಯಲ್ ಕಮೆನ್ಸ್ ಮಾಡಿದ್ರೆ ರೆಗ್ಯುಲರ್ ಆಗಿ ಹಾಕೊಂಡು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕು.
P9. ಸುಹಾಸ್ TL.
For the petition.
ಹೇಳಿ.
Time may be granted. Charge sheet apply ಮಾಡಿದ್ದೀವಿ. Charge sheet enter charge.
Time ಬೇಕಾ? Petitioner counsel seeks time, list this matter on 8/1/25.
70.
Dharmapal.
439, the regular bail. Since 2 years, 10 months he is in jail. The offense 304B, every death, and 3 and 4 of DP Act.
Accused number ಎಷ್ಟು?
Accused number 1, husband. ಅವಳು ಅಲ್ಲಿ ಅವಳ ತವರು ಮನೆಯಲ್ಲಿ
Accused number 1 husband ಅಂದ್ರೆ?
husband, ಇವಳ deceased husband.
Deceased husband.
Deceased husband.
Accused number 1.
Accused number 1. Accused number
offense 304B na?
Oh, 304B. Accused number 2 and 3 are father-in-law and mother-in-law. They are on
they are on bail.
Bail. Now charge sheet has been filed. The allegation ಅಂದ್ರೆ ಹರಾಸ್ ಮಾಡ್ತಾ ಇದ್ರು, 6 ಲಕ್ಷ ರೂಪಾಯಿ ಡಿಮಾಂಡ್ ಮಾಡಿದ್ರು. ಆಮೇಲೆ 2 ತಿಂಗಳಿಂದ ಮನೆ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ. ಮನೆ ಬಿಟ್ಟು ಹೋಗಿ ಅವಳ ಮನೆಗೆ ಹೋಗಿದ್ದಾನೆ ಇವನು 2 ತಿಂಗಳಲ್ಲಿ. ಆನಂತರ ಅಲ್ಲಿ ಇಲ್ಲಿ ಏನಾಗಿದೆ ನನಗೆ ಹೇಳಿದಂತ ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 20.
ಪೇಜ್ ನಂಬರ್ 6 ಅಲ್ಲಿ ನೋಡಿ, ಅರ್ಲಿಯರ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದೀವಲ್ಲ?
ಅರ್ಲಿಯರ್ ಹೌದು,
ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. The marriage of the victim was solemnized with accused number 1 on 24/5/21. And the death was occurred within a span of 7 months of her marriage. And having taken note of the contents of the death note, which has been placed before this court by the learned HCGP, he submits that same is sent to the FSL with regard to her handwriting, and the complaint also discloses that a victim is a BE graduate in electronic and telecommunication, and also taking note of the contents of the death note. The Kannada is written in English, wherein a specific allegation is made against this petitioner about his conduct, and subjected her for sexual harassment, and before committing suicide, she left the death note, and hence the court has to take note of the contents of the death note, and unless the FSL report is not received with regard to death note is concerned, it is not a fit case to exercise. ಈಗ ಬಂತ FSL report?
FSL report ಬಂದಿದೆ.
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 ಹೇಳಿ ಏನು?
ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 20 ಅಮ್ಮ ಅವಳ ಮೊಬೈಲ್ ಅನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋಗಿದ್ದಳು ಅಂತ ದಿ ಬ್ರದರ್
ಪೇಜ್ ನಂಬರ್
ಆಫ್ ದ ಪೇಜ್ ನಂಬರ್ 20 ಮಿಡ್ಲ್ ಲಾಸ್ಟ್ ಇದೆ ಪೇಜ್ ನಂಬರ್ 20 ಕಂಪ್ಲೇಂಟ್.
ಕಂಪ್ಲೇಂಟ್ ಬೇಡ, FSL ರಿಪೋರ್ಟ್ ಏನೋ ಕೇಳ್ತಾ ಇದೀನಿ.
FSL ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಅದೇ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಅವಳು ಬರುದಂತ ಬೇರೆ
ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಅವಳದೇನಾ?
ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಅವಳದೆ ಅಂತ ಬಂದಿದೆ.
ಮತ್ತೆ
ಪಾಸಿಟಿವ್ ಬಂದಿದೆ.
ಹಾ,
ನಾವು ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅಮ್ಮ
ಸಾಯಕ್ಕಿಂತ ಮುಂಚೆ ಡೆತ್ ನೋಟ್ ಬರ್ದಿಟ್ಟು ಹೋಗಿದ್ದಾಳೆ.
ಹಾ ಅದು ದಟ್ ಇಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಟ್ರಯಲ್ ವೆದರ್ ಶಿ ಹಸ್
Matter for
ರಿಟನ್
trial
ಆರ್
also.
ನಾಟ್ ಅಂತ.
Now we are
ಇಲ್ಲಿ-
seeing only prima facie material.
ಇಲ್ಲಿ ಏನಂದ್ರೆ ಅಕ್ಕ ಜಾಹ್ನವಿ ಮನೆಯಲ್ಲಿ ಒಬ್ಬಳೇ ಇದ್ಲು ಅಂದ್ರೆ ಅವನ ಮನೆಯಲ್ಲಿ ತವ್ರ ಮನೆಯಲ್ಲಿ ಇವನ ಮನೆಯಲ್ಲಿ ಏನೋ ಆಗಿಲ್ಲ.
Counsel, I have given a liberty to approach this court after the FSL report. You rely upon FSL report. Where is that FSL report? ನಾನು ಆಗಿಂದ ಕೇಳ್ತಾ ಇದೀನಿ, ನೀವು FSL report ತೋರ್ಸಕ್ ರೆಡಿ ಇಲ್ಲ.
FSL
ಬೇರೆ ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ.
FSL ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಅಂದ್ರೆ ಅಮ್ಮನ ಮಗನ ಜಗಳ
ಹಾಕಿದೀರಾ FSL report? ಇಲ್ಲ ಹೇಳಿ ಫಸ್ಟ್. ನಿಮ್ಮ ಪಿಟಿಷನ್ ಅಲ್ಲಿ FSL ರಿಪೋರ್ಟ್ ಹಾಕಿದಿರೇನ್ರಿ?
FSL ಹಾಕಿದ್ದೇನೆ. ಪೇಜ್ ನಂಬರ್ 41.
ಹಾ, ಮತ್ತೆ ಹೇಳಿ.
41 ಅಲ್ಲಿ ಇದೆ.
41 ಅಲ್ಲ 43 ಇರಬೇಕು. ಸ್ಯಾಂಪಲ್ಸ್
ಅಲ್ಲ ಟೈಪ್ಡ್
ಕಾಪಿ ಆಫ್ ದಿ ಡೆತ್ ನೋಟ್ ಅದು. ಡೆತ್ ನೋಟ್
47 in 49 ಇದೆ ಒಪಿನಿಯನ್.
In short, there is no
49 ink page
rating.
number 49.
There is no divergent rating habits are observed between the questioned ratings marked as Q1 to Q4 and admitted ratings marked as A1 to A254, except natural variations. The similarities in rating habits which observed in admitted ratings marked as so and so, questioned ratings so and so are significant in nature, and they will not accidentally coincide in rating habits of two different persons, and when they are considered collectively, they are sufficient to express the positive authorship of questioned ratings marked as Q1 to Q4.
Now in the short there is no divergent
Death
rating.
note 2 page ಇದೆ.
ಹೌದು 49 ಇಲ್ಲಿ ಇದೆ. Now I am seeking a bail on the ground of ill health, my lord. Page number 79.
On the ground of ill health.
Ill health.
ಹೇಳಿ ಏನದು?
79 ಅಲ್ಲಿ 79 medical certificate. Letter from honorable court of third.
79
79 ink page.
ಏನದು ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್?
That Karnataka 31 years so and so previously visit on 3/8/23 1/8 so the various varicose vein problem. He was diagnosed and
Varicosities ಅಷ್ಟೇನೆ. In writing
and
long
finally
various hereditary secondary to incompetent perpetrators.
similarly 50 page number
ಪಿಸ್ತುಲಾನ recurrence fistula and advised medications.
Advice medication will be referred to Victoria Hospital for USC fistulization for further evaluation and treatment. He requires a regular treatment and management of the higher center.
Higher center.
Higher
higher center le tagolli with the supervision of
ಅಲ್ಲ
the
ಇದರಲ್ಲಿ
jail authority. I can direct the jail authority to take to hospital which you want.
Charge sheet has been already filed, my lord, since 2 years and 10 months he is in custody. My lord, any condition may be imposed and released and we face a trial.
Yes, madam. You are going to provide the treatment wherever he wants. ಹೈಯರ್ ಸೆಂಟರ್ ಬೇಕಂತ ಅವರಿಗೆ. ನಿಮ್ ಸೂಪರ್ವಿಷನ್ ಅಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗ್ಲಿ ಬಿಡಿ, ಜೈಲ್ನವ್ರು ಕರ್ಕೊಂಡು ಹೋಗ್ಲಿ, ಅವ್ನು ಎಲ್ಲಿ ಕೇಳ್ತಾನ ಅಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡ್ಲಿ. ದಟ್ಸ್ ಆಲ್. ತೊಗೊಳ್ಳಿ. Heard the petitioner counsel and also the
My request, my lord, 2 ವರ್ಷ 10 ತಿಂಗಳಿಂದ jail.
2 ವರ್ಷ ಆದ್ರೇನ್ರಿ? ಲೈಫ್ ಆಫ್ ಎ ಗರ್ಲ್.
Life of girl, she has
within a
suicide in
period
the
of
house.
7 months of her marriage.
All the allegation are false.
No,
That is
no,
not
counsel.
permitted.
Now you are talking about the liberty. Now I am talking about the life of a person.
He has not harassed and she has left him and gone to her house.
Within 7 months he
ಅಲ್ಲಿಂದ
takes the extreme step of committing.
ನಾವು ಅದರಲ್ಲಿ ಅದೇ ಅವರು she was chatting somebody. ಅದಕ್ಕೆ
Death note
ಅವಳ ಮೊಬೈಲ್
also tallies with the FSL
ಅವಳ
of
ಮೊಬೈಲ್
her.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಹೇಳಿದ್ರೆ ಅವಳ ಮೊಬೈಲ್ ಅನ್ನ ಅಮ್ಮ ಕಿತ್ಕೊಂಡು ಹೋಗ್ತಾಳೆ. ಯಾಕಂದ್ರೆ she was chatting with somebody and there was a quarrel
Whatever
between
it might
mother
be.
and
Whatever
mother
it
and
may
the
be.
daughter. So, the ಸಂದರ್ಭದಲ್ಲಿ it is.
Heard the petitioner counsel and also the counsel appearing for the state additional SPP. This court earlier rejected the bail petition of the petitioner with order dated 14th day of June 2022 in criminal petition number 2840 of 2022. And this court, while rejecting the bail petition, observed in paragraph number 6 that the deceased left the death note before taking the extreme step. And also victim is a BE graduate in electronic and telecommunication. And while rejecting, liberty is also given to the petitioner to approach the court after receipt of FSL report in respect of the death note. Now the now the FSL report is also placed before the court, and the FSL report is very clear that admitted handwritings of the victim deceased and also the death note, no variations and similarity is found. Now the council would vehemently contend that this petitioner is in custody from 2021,
22, 9/2/22.
9/2/2022. And also he is suffering from recurrence fistula since the same is diagnosed. And also he is admitted in prison hospital and on medication for deep vein thrombosis, hemorrhoids and fistula in ano. The patient complains of pus in ano, difficulty passing stool and difficulty perform his daily activity. And hence opinion is given by the central prison that he will be referred to Victoria Hospital for USG fistula gram for further evaluation and treatment. He requires regular treatment and management at higher center. Based on this report, the council submits that he may be enlarged on bail since he has to take the treatment at higher center. Per contra, the council appearing for the state would submit that death note is also placed before the court and also the same is sent to the FSL and FSL report is also positive. And the diagnosed is only recurrence of fistula. And also letter discloses that petitioner is referred to the Victoria Hospital and for further evaluation. And he requires regular treatment and management at higher center. Having taken note of the grounds which have been urged before this court as well as earlier order passed by this court, and also the offense is under section 304B, and also the victim lost her life within a span of 7 months of her marriage. And also the FSL report is positive that the death note and also her admitted handwritings are similar and no variations. And when such being the case, having considered the records which have been placed along with this petition, and he is suffering from fistula and also there is a recurring and also report says that he will be referred to Victoria Hospital for further evaluation at higher center, and the same also can be taken note of, and hence the jail authorities are directed to take him to higher center where the petitioner wants to get the treatment. And question of enlarging the petitioner on the ground of he is suffering from fistula cannot be a ground when the serious allegations are made, and in the death note also specific allegations are also made against this petitioner, and hence I do not find any ground to enlarge the petitioner by exercising the discretion. In view of the discussions made above, I pass the following order. Bail petition, take him to the higher center for his treatment with their supervision, treatment petition. Correct. ಹೌದಾ? ಓಕೆ, ಪರವಾಗಿಲ್ಲ. ಇದು ಯಾರೋ ಒಬ್ರು ಕ್ಲೈಂಟ್ ಒಂದು ನಾಲ್ಕು ಕಂಡ ಏನೋ ಹಾಕೊಂಡಿದ್ದಾನೆ. ಲಾಯರ್ ಲೇಡಿ ನನ್ನ ಹೆಸರು ಹೇಳ್ಕೊಂಡು 50 ಲಕ್ಷ ಕೇಳಿ ಅಷ್ಟೇ ಇರಲಿ, ಬೇರೆ ಇನ್ನೇನೋ ಮಾತಾಡ್ತಾರೆ. ಅದಕ್ಕೆ ಅವ್ಳು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾಳೆ ಅದನ್ನ ಈಗ ಅದಕ್ಕೆ ಕಂಪ್ಯೂಟರ್ ಪಾಯಿಂಟ್ ಕರೆದು ಬಿಟ್ಟು ಕೇಳಿದೆ. ವಾಯ್ಸ್ ಅದು ರೆಕಾರ್ಡ್ ಮಾಡಿ ವಾಯ್ಸ್ ಡಿಟೆಕ್ಷನ್ ಕಳಿಸ್ಬೇಕಾಗ್ತದೆ, ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಕು. ಯು ಕ್ಯಾನಾಟ್ ಟೇಕ್ ಇಟ್ ಆಸ್ ಇದು ಅಂತ ಅದಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀನಿ. ನೀವು ಏನು ನೋಡಿ ಏನು ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡಿ ಅದು ಒಂದು ಮಾಡ್ತೀನಿ, ಒಂದು ಕಳಿಸ್ತೀನಿ. ಅದರಲ್ಲಿ ಈ ಥರ ಓಪನ್ ಕೊಟ್ಟು ಮುಂದೆ ಮಾಡಿದ್ರು ಅಂತ. ಆಮೇಲೆ ಅದು ಸ್ಪೀಡಿನೂ ಇದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದನ್ನು ಕ್ಲೋಸ್ ಮಾಡಿ ಕಳಿಸ್ತೀನಿ. ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಚಿಪ್ ಜೊತೆ ಆರ್ಟಿಸ್ ತಗೊಂಡು ಸೆಂಡ್ ಇಟ್ ಟು ದಿ FSL and get the case register ಮಾಡಿಸಿ ಆಮೇಲೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.